Your educational background.
I got my undergraduate degree from University of Minnesota and my MA and my PhD from University of Wisconsin.
And what year was that?
1986.
And Dr. Beto, you mentioned this, but what's your current position at the University of Alabama?
I'm Professor Emeritus in history.
And how long have you worked at the University of Alabama?
Since 1994.
What positions have you held at the University of Alabama?
I was assistant professor, associate professor, full professor, and now I'm emeritus.
And what were you professor of?
History.
And Dr. Beto, what type of work do you do as a professor?
Well, teach courses, do a lot of research, some service.
And what type of courses do you teach?
I've taught a wide range of courses in American history, mainly 20th century, but I've taught introductory courses going all the way back to the beginning of American history.
And then you also talked about research as well. What type of research do you do?
Again, it's a wide range of research. I've written about mutual aid, history of mutual aid organizations. I've written a lot about black history. I have a biography that just came out of FDR. I did another biography of Dr. T.R.M. Howard, who was a very forgotten but kind of neglected civil rights figure. And I'm writing a book now about the independent black town of Mound Bayou, Mississippi, where Dr. Howard was a key figure.
And can you explain a little bit more about who Dr. Howard was?
Can you move a little into the microphone?
Oh, sure.
Or just look closer.
Okay, sorry about that. Yeah, I'm sorry, could you repeat that?
Yes, can you give a little bit more about who T.R.M. Howard was?
Well, T.R.M. Howard is one of the wealthiest black men in the state of Mississippi. He headed a hospital there. He headed a civil rights organization formed in 1951. He gave Medgar Evers his first job out of college, brought him into the civil rights movement basically, was involved heavily in the Emmett Till case, trying to find witnesses and evidence. He was a mentor to Jesse Jackson, later in Chicago, Fannie Lou Hamer in Mississippi. So he was an important figure up until sort of forgotten now, but he was a nationally known civil rights figure in the 50s.
And Dr. Bay, you mentioned FDR. Who is FDR?
Franklin Delano Roosevelt.
And what was your book on FDR about?
I did two books. I did a book about the Bill of Rights and the New Deal, which focused a lot on, FDR was named in the title, focused a lot on him. And then on the basis of that, I got a book contract to write a book about just a general biography of FDR, which was completed last year.
And then for your book on Mound Bayou, what's that about?
Mound Bayou is a black town in Mississippi. It was founded by two slaves, enslaved people of the Davis family, Jefferson Davis. And it was one of the few towns in Mississippi where African Americans could vote, hold office, all the way through the 20th century. And it was kind of a hub for civil rights activity, including in the 1950s, early 1950s, and earlier than that actually for Dr. Howard's civil rights activities, which he headed the leading civil rights organization in the state, called the Regional Council for Negro Leadership.
Okay. And Dr. Beto, have you written any academic articles or chapter publications?
I've written about, I don't know if you asked about books, but 7 books that either authored or co-authored or edited, and then I don't know how many articles, a dozen or more articles on various aspects, including the history of mutual aid, black history, a lot of different things related to those issues and other issues.
Okay. And Dr. Beto, other than writing the books and articles and publications, what other work have you done as a professor?
Well, I mean, I've taught a wide range of classes, as I've said. I've taught black history, I've taught political history, urban history. Again, sort of focusing on the 20th century. I've taught undergraduate classes and graduate classes. And I've supervised a number of students who are doing research themselves.
And can you explain a little bit about the research methods that you and your students do for your class?
Sure. It's very similar. The students will, I'll say, you know, let's do a topic. Is it feasible to do that topic? Is there information about it? Can you get the information? Is the topic worth looking into? Maybe somebody else has already done it 100 times, you know, that kind of thing. So pick a good topic, then get a good familiarity first with the secondary sources. Those are sources written mainly by historians, secondary accounts. Try to get a good handle on those, and you can use those to get clues as to where the primary sources might be. We call that the raw material in historians, which would be things like letters and government documents and interviews, and if it's a legal history, it could be court records, it could be court rulings, it could be things like that. Done by the people that are making the history, I guess you could say, in some sense.
One second, Dr. Beto. I'm just going to introduce his CV. Your Honor, so it's going to pass up Dr. Beto's CV to be entered as the next exhibit. Here's a copy for you all.
Thank you.
Dr. Beto, Dr. Beto, do you recognize the document that I handed to you?
Yes, my CV.
Okay. And does this list your academic experience and your educational background as well as your books and other publications?
Yes.
Okay. And Your Honor, if that's not already the next exhibit, we'll go ahead and admit it that way.
Any objection?
No, Your Honor.
Your Honor.
Exhibit 71?
Yes, Your Honor. And Dr. Beto, what topics have you researched throughout your time as professor?
Well, I've written about the role of non-governmental organizations in providing public services, including social welfare. Wrote a book about fraternal societies and mutual aid organizations, including a lot on black fraternal societies and how they provided insurance, basically, to people, hospitals, that kind of thing. I wrote, as I said, I wrote a biography of FDR, of T.R.M. Howard, of the hospitals in Mountain Bayou, and now I'm writing a book about Mountain Bayou.
And Dr. Beto, when you pick a topic, can you explain your research method that you use in exploring a topic?
Yeah, it's similar in all sorts of, in these cases in general. I'll see something interesting, say, oh, maybe I could write about that. That sounds like an interesting topic. That's the way it was with Howard. I said, this guy looks like an interesting guy. I just saw a reference to him somewhere. I want to know more about him. So I got all the secondary sources I could find. In that case, it would be books about the history of the civil rights movement in Mississippi, things like that. Got a good sense of who this guy was, and then from there I got ideas about, okay, there's nothing really much about him anywhere, so I went and looked for collections that I might have letters. I looked at newspapers, a lot on newspapers, searching the newspapers year by year to try to find stuff. I tried to find people that knew Dr. Howard and interview them. And that way would construct, you know, just a body of research. And then I finally felt comfortable at some point, say, all right, I'm ready to write, you know, this. I've got enough.
And is that the type of research method that, that other history professors or historians use?
Yeah, I think it's a standard method. It's the method I was taught as a graduate student, basically.
And is that the type of research you performed in this case?
Yes.
And Dr. Beta, have you provided expert testimony in a legal proceeding before?
Yes, I have.
In what states did you provide expert testimony in?
In both Alabama and Florida.
And what was your testimony in the case in Alabama?
The case of Alabama involved a provision in the Alabama Constitution disfranchising for crimes of moral turpitude. And so I looked at that, you know, history of that.
Okay. And then what about for Florida?
I looked at awareness in particular cases of the health dangers of smoking. Were people aware that smoking was dangerous, basically, that it could kill you and that it was addictive?
And Dr. Beto, in either case, were you excluded as an expert?
Yes.
You were excluded as an expert in
No,
either case?
excluded, I'm sorry, I didn't know what you know, I was not, I was never excluded as an expert.
Thank you, Dr. Beto. And Your Honor, this time we'd like to offer Dr. Beto as an expert in political history and civil rights history.
I'm sorry, expert on,
Political history and civil rights history.
okay, counsel?
No objection, Your Honor.
Okay. All right, Dr. Beto is tendered as an expert on political history and civil rights history.
Thank you, Your Honors. And Dr. Beto, what did you review in this case?
Okay, I looked at some of the secondary literature that was out there in the history of felon disfranchisement, both outside of Tennessee
I'm sorry,
And-
we're having a hard time hearing you, Dr. Beto.
I'm sorry. All right.
Bring that mic
I
up.
may need to move this.
Let's make sure it's working. Okay,
Okay.
all right,
All right, I guess so. All right, is this better?
a little bit.
A little bit? All right. Normally, in the classroom, I'm just shouting. Everyone can hear me, but not this time. All right. You asked me about, how I did this. I looked at the secondary literature, and then I zeroed in with particular focus on, the period. I mean, I did a general look, but I looked particularly at the period since, beginning the 1960s, looking at felon disenfranchisement in Tennessee, and the debates about that, and how the law changed, and that kind of thing, beginning in the 1960s.
And what questions were you asked to review in this case?
That was one of them. I was also asked to, after I'd sort of done a lot of that work, I was asked to look at history of guilty pleas for infamous crimes, and particularly what I focused on in that research was cases that did not involve the intervention of a jury.
And Dr. Beto, based on those questions, what did you conclude?
Well, in my research in general, I found quite a few examples of people pleading guilty to infamous crimes. And in most cases, although I didn't systematically study that aspect of it, but I'm just, as I go through all these court records, in most cases, a jury would be impaneled. However, I chose to focus only on those cases where a jury was not impaneled, and zero in on those particular cases in particular.
And Dr. Beto, what did you conclude about disenfranchisement in Tennessee.
About disenfranchisement or about this particular aspect of it?
This particular aspect in this case, as it relates to this case.
All right, that guilty pleas were pretty common, for infamous crimes in the period after the 1870s. That they were less common, but still did happen in cases that did not have the intervention of a jury, where basically what would happen is the defense lawyer and the prosecutor would sort of agree to go to a judge, and the judge would handle the sentencing, that kind of thing, and the jury trial would be waived.
And Dr. Bailey, let me go back to the first question that you were reviewing in this case on criminal disenfranchisement in Tennessee. What did you conclude based on your review of that question? Okay,
well, looking at the period since the 1960s, I did not see evidence that legislation was motivated by racial animus, that this was something that was driving forward these legislative changes that we see, especially beginning in the 1980s, but you see some interesting changes before that as well.
Your Honor, I want to pass here. Any objection? Okay. Your Honor, I want to pass up the expert report of Dr. Beto from November 21, 2025. Dr. Beto, do you recognize this document that I passed out?
Yes.
And what is it?
It's my, I guess you'd say, my second expert report, where I focus on the guilty plea issue.
Your Honor, if there's no objections, we'll move that as the next numbered exhibit.
No objections, Your Honor.
Dr. Beto, in reviewing the plea bargaining question, what research did you do?
Okay, I did a lot. I went to the Tennessee State Archives, spent quite a lot of time there looking at microfilm, but also some very good databases where they would have the actual court cases. And the cases, what I would look at is overwhelmingly my focus was on court minutes, which are basically summaries of the individual cases. What was the disposition of the case? Who was the defendant? What was the crime? Was the crime rendered infamous? What was the sentencing? That kind of thing. And these most counties had them. The circuit court or the criminal court, they called them different names at the time. But the cases that would be, the courts that would be deciding these particular infamous crimes cases.
Why did you decide to look at the court minutes?
Well, I looked at some other research that had been done by, this is looking at sort of the general secondary research, a guy named Lawrence Friedman. He did a book called The Roots of Justice, Crime and Punishment in Alameda County, California. And he basically, it's a book that is widely cited. He was looking back, said, well, when did plea bargaining arise? Is it a modern phenomenon? And he actually found good evidence that it existed 19th century and earlier, not as common now, but existed. And so I sort of wanted to do that for Tennessee, and I didn't see a lot of work that had been done for Tennessee. So one of the sources he used was court minutes. So I just used that source for Tennessee, for these counties.
And what were the type of court minutes that you looked at?
I looked at for quite a few counties. I could tell you the counties where these aren't the ones I just looked at. I looked at others too, but these are the ones where I found cases that met the characteristics I said. And the characteristics were there guilty pleas to infamous crimes? Was the case decided without the intervention of a jury? Was the offense rendered infamous by the judge, or described as infamous by the judge in his ruling? And so I looked for those, and I found examples. I'm trying to remember all the counties I looked at, or found examples. Bedford County, Giles County, Smith County, I'm sure I'm going to miss one, Truesdale, Washington, Wilson, oh, and forgot the M's, Montgomery and Monroe County. I think those are the cases.
And Dr. Beto, what was the time period for the court minutes that you looked at?
The first case I found meeting those standards, which are very restrictive, was in 1882. And then the last ones I looked at were in the 1960s, I think 66 or 67. And a lot of that, I mean, I could describe to you why I didn't go further.
And why didn't you go further?
Because, first of all, a lot of that stuff was not at the state archives. It was held by counties, and some would be very cooperative, some wouldn't. There were privacy considerations a lot of them had. They would say, oh, give me a particular case and we'll look it up for you. So no, I want to just look at, a wide range of cases. I want to do, and they weren't going to go for that. So these were readily available. I didn't have a lot of time, so, I didn't have time for all the bureaucracy, so this is a way to kind of go around that and still find a wealth of thousands, had access to looking through thousands of cases.
And how many court minutes did you review?
I never counted it, but it would be over 1,000, I'm sure. Again, just going through them, looking for these particular cases that fit this narrow definition.
And what all did you find in the court minutes that you were looking through?
I found 31. I think that was maybe off by one. I said 31 because I think one of them had two defendants or something. About 31 examples of cases in these different counties, and I copied the cases from the minutes and attached them to the document. And these would be, again, cases from these particular counties. I identified them, copied them, and they would fit that standard that I described earlier.
And Dr. Beto, just remind us, what was the standard you were looking for?
Okay, one, it would be guilty pleas to one or more offenses, because these were plea bargaining deals. So sometimes they'd say, I plead guilty to this offense, not guilty to this one. Occasionally that would happen. But there were guilty pleas, right? And then there was a waiving of jury trial and leaving it up to the judge, the court, basically, to putting themselves on the mercy of the court or whatever you want to call it to make the ruling and handle it from there. And then the judge would have to be for an infamous crime. So that would be the only ones I would have. And then it would also have to be where the judge would render the crime infamous, would state that the crime was infamous in the judge's ruling.
Your Honor, we'll hand Dr. Beto the examples from his report. That's the next numbered exhibit. And Dr. Beda, do you recognize the packet that I handed up to you?
Yes.
And what are those?
Those are, I'm not sure if those are all of them. It might be just the first part I gave you. I'm not sure. These are the copies of the court minutes of cases that fit that definition I just outlined.
Your Honor, if there's no objection, we'll move to admit that as the next numbered exhibit.
No objection, Your Honor.
73.
Dr. Beda, I want to turn first to the court minutes that are labeled as Giles County
Yes.
court minutes. That should be the first 3 pages in this packet. What year are these court minutes from?
This is 1882, April 6th, 1882.
And what happened in this case?
Well, in this particular case, the defendant pled guilty to the crime of housebreaking, and he pled guilty to the charge of petty larceny. So it was both housebreaking and petty larceny, and he pled guilty to the charge of petty larceny. And this was heard before the judge without, as it says here, without the intervention of a jury. And having heard a statement, etc., then the judge sentenced the defendant to hard labor, and then stated that the crime defendant be rendered infamous and incapable of being, I can't even read that myself here, of being, of testifying as a witness in any of the courts in the state, disqualified from exercising the elective franchise or holding any office under this state.
Thank you, Dr. Beda. I want to go to the next court minutes. It should be on the next page from the low up there. And what are,
Which county?
this should be Montgomery.
Okay.
Next one. It should be the next one right after Giles.
Yeah.
And Dr. Beda, what year was this case from?
This is 1915.
And how did you know it was from 1915?
Oh, because, you know, in fact, I think I try to copy the page before that has, that you could see that. You can see it at the top there, the date. Just to have, old habit, right? And then I did a close-up so people can read it. But in the minutes, it would list the dates.
And then what year was this case from?
1915.
And what happened in this case, Dr. Beda?
Okay, well, let's see. Pled guilty. Let's see. It's decided again without the intervention of jury. The defendant pled guilty to the charge of larceny, and then the court ordered the defendant to be taken to the county chain gang instead of the state penitentiary. So I don't know if that was a mitigation of sentence or not. And there to be confined at hard labor on the county for a period of 11 months and 29 days, and that he be rendered infamous and disqualified from using the elective franchise or holding any office under the laws of this state or from testifying in any court of justice, and that he pay the costs of this cause for which execution may issue.
And Dr. Beda, I want next look at the next set from Wilson County.
All right.
And what year was this one from?
1924.
And Dr. Beda, what happened in this case?
Okay. Let's see. All right. Waive formal arraignment, enters a plea, the defendant enters a plea of guilty for this trial, puts himself upon the county and the attorney general, doth the like, and submitted his cause to the judgment of the court without a jury, trial by jury being expressly waived. After hearing all the evidence, the court finds the defendant guilty. It is therefore considered by the court upon the defendant's said plea that the defendants for his offense of petite larceny shall be confined in the county workhouse at hard labor for a period of 4 months, and that he be rendered infamous and disqualified from holding office, giving evidence, sitting on juries, and exercising election franchise, and that he pay the costs of this cause, for which let execution issue.
And Dr. Bailey, we've gone through 3 of the examples that you found from the about 31 examples. Are these court minutes representative of the other court minutes that you found?
Yeah, I think they are.
And among
Some
your,
variation here and there, but they're very, very similar, yeah.
and Dr. Beto, among your findings, how many mentioned the loss of the right to vote?
All that mention that to say, give examples of what the defendant's going to lose by being rendered infamous. All of those but one mention the loss of elective franchise. In some cases, they would just say rendered infamous. They wouldn't say anything, but in most of the time, they would say, okay, here's what you lose. And when they give that list, sometimes they'd leave out serve as a witness, testify as a witness. Sometimes they'd leave out something else. But all of them, except one, mention the electoral franchise.
Dr. Beto, for the one that didn't mention the loss of the right to vote, what was the reason given in the court minutes for not mentioning it?
They didn't give a reason. They just gave a list, and in that particular case, they just didn't have it on the list.
Dr. Beto, you mentioned viewing about over 1,000 of the court minutes. Other than these examples of what you find, what other court minutes did you see?
Oh, I a lot of them in these counties and other counties as well. The unfortunate thing is some of the records just don't seem to exist. Like Hamilton County, there was a judge there who had a reputation. This is commented upon in the newspapers for fairness. So much so that he was often, both sides and defendants would often just say, let him decide for us, and let's forego a jury. Unfortunately, for that county during that period, I couldn't find any of the minutes, and that would have been interesting because some of those cases did involve infamous crimes.
And Dr. Beto, other than where you picked up these 30 examples for that met your standard of waiver or intervention, did you see other court minutes where folks were pleading guilty?
Yes.
And could you explain what those look like?
They would look very similar. However, what would happen right before they gave the sentences, a jury was impaneled, and then they would typically give the names of all the jurors. That was the standard feature. They just give the names. And then they would say, and the jury affixed the penalty, or basically what it would say things to indicate that the jury was affixing the penalty, but was sort of like listening to what the agreement basically that the prosecutor and the defense lawyer had, the defendant, and then they would sort of give their approval. And it doesn't go into details to whether they ever quibbled or anything like that, but that was the sense I got. They would call the jury in, they'd impanel it, and they would present what they had decided.
What type of crimes would those cases be?
I only looked at, all kinds of crimes you'd have for going to jury trial. That was happening all the time in different crimes, but I only looked at infamous crimes.
Dr. Bates, what was more common in your view? Guilty pleas when a defendant was rendered infamous and a jury was impaneled, or when a jury wasn't impaneled?
I'd say was impaneled. That was the more common thing. I step back, though, and say I didn't study that in the same systematic way. However, I came across, as I went through, and I copied some of them, it just looked a lot more common, comparatively.
And based on all the sources that you reviewed for this question, what would happen to a criminal defendant in Tennessee who pleaded guilty to an infamous crime?
I mean, that would vary. Sometimes there'd be evidence you get some sort of mitigation of sentence. And one piece of evidence is there was one case where these two people were involved together that I saw. I don't think it's one of these examples. It was another example that fit what you said, right, where they pled guilty. One of the defendants pled guilty. The other one didn't plead guilty. And the one who pled guilty had a shorter sentence than the one who didn't plead guilty. So that, there was evidence of I'm not an expert on it. I'm not going to pretend to be an expert. From my understanding of plea bargaining, it looked like plea bargaining was going on here. Negotiation of some degree was going on.
And Dr. Beto, based on all the sources that you reviewed, what evidence did you find that courts, lawyers, or citizens believe that a person who pleaded guilty would not be rendered infamous?
I'm sorry, could you repeat the question?
Yes, Your Honor. What evidence did you find that courts, lawyers, or citizens believe that a person who pleaded guilty would not be rendered infamous?
Objection, Your Honor.
Objection.
This is not, I believe, in his report, and it's also opining on what people believed rather than the evidence he saw.
Mr. Wilson?
I can restate, Your Honor. Dr. Beto, what evidence did you find that a person who pleaded guilty to an infamous crime would not be rendered infamous?
I didn't really see cases where they pled. I didn't really look for those cases. So there might have been cases where somebody would plead guilty and the judge might say, okay, you pay court costs. That happened a fair amount, where somebody would plead guilty and there was no real ruling other than, the defendant would pay court costs and things like that. So I see that happen a fair amount. Did I see cases where they were actually, not rendered infamous, even though they were convicted of the crime? I didn't see cases like that. They may have existed somewhere. I didn't see them.
And we'll pass up Dr. Beto's report from, I believe it was May of 2025.
Thank you.
And Dr. Beto, I want to turn to the other area of review that you did in this case, outside of plea bargaining. Do you recognize this document that I passed up to you?
Yes.
And what is it?
It's my the first expert report I did in this case.
And what was the expert report about?
It gave very briefly a background to the history of disfranchisement for crimes, infamous crimes, or crimes similar to that. A very brief background to the experience in Tennessee in the 19th century. But the main focus was picking up in the 60s, really in a major way in the 70s, and then after that.
And then we'll introduce that as the next numbered exhibit. If there's no objection.
No objection, Your Honor.
Okay. Exhibit number 74.
And Dr. Beto, based on your review, what did you conclude about criminal disenfranchisement in Tennessee?
Well, again, my focus was on the period after the 1870 Constitution, but really particularly in the 60s and later, and I did not find evidence that criminal disfranchisement, at least the legislation, that was my main focus, was motivated by racial considerations. There were a lot of other considerations going on into the various changes that occurred in beginning really in the 1980s as far as legislation, but a lot of that came out of some previous litigation, which was complicated.
And Dr. Bader, in reviewing criminal disenfranchisement in Tennessee, what sources did you rely on?
I looked at newspapers quite heavily. I looked at court cases. I looked at governmental reports. Oh, and I also listened, believe it or not, I listened to audio recordings of legislative House debates, which go all the way back in this state to the 1950s. But I listened for 1972, 1981, and 86, and I would have done more, but that's what I did.
Can you repeat those years again?
I listened for 1972, I listened for 1981 and 1986.
An objection, Your Honor.
Okay.
Based on his deposition, the review of those audios were after his report was completed in this case.
I'm sorry, repeat that again?
The 72, 86, and the other date he just said were after his report was issued in this case.
What do you mean?
It was a
after?
fact. It was a fact not disclosed in his report because that was evidence he had not reviewed when he rendered his opinions in this case.
Okay, so you're saying that this opinion was given after he concluded his report?
The listening to the audio that he just listed happened after his report in this case was issued. He had not reviewed those things when he rendered his opinion in this case.
Oh, I see, okay. All right, Mr. Wilson?
Your Honor, his report details where he listened to, or at least viewed the legislative record. If there's some indication that maybe we don't get into the audio files, that's fine. But based on his report, Dr. Beto did review a substantial legislative record, so whether or not that was the audio files or not, and what date or whatnot.
All right, so with regard to this 1972, 81, and 86 audios, are you conceding that that was not a basis for his opinion? It was not a underlying basis?
Your Honor, he viewed the legislative record, whether that's, in audio form or, through a transcript. It's still the same thing, Your Honor.
Well, we're referring to specifically, the objection is to these three audios. So, plaintiff's counsel says that the opinion was given prior to listening to these audios, and therefore, the opinion could not have been based on these audios. Do you agree with that, or disagree?
Your Honor, we'll just ask about the legislative transcript and not the audio.
All right, so
So,
are you moving to strike the testimony that is based on 72, 81, and 86? No, I'm saying, are you willing to strike that, or?
Sure, Your Honor, and I'll focus the questions going forward.
Okay.
Thank you, Your
all
Honor. Right, and Dr. Beta, what else did you review? Sources did you rely on for this report?
There were transcripts done of the 2005, 2006 legislative hearings on that particular law. So there were transcripts which I did review prior to doing the report. And I don't know if those had been taken from the audios or not. I found out about the audios sort of after that.
Right. And Dr. Beto, can you generally describe, before the 1960s, what were your findings about criminal disenfranchisement in Tennessee?
Before the 1960s?
Yes.
I didn't really look at that carefully. I did look a lot more at what I think were the main means of disfranchisement. And there was disfranchisement going on from the late 19th century, really kicking in the late 80s, 90s, through all kinds of different legislation. And I didn't really see evidence that criminal disfranchisement was being used for that purpose. However, I think that it's quite likely that people would use any means necessary during that period to deny voting rights, or at least a lot of white supremacist types, if they're going to use these other laws, they're going to use that. I would assume, but I didn't really see evidence of that. But I wouldn't doubt that it could have happened during that period of Jim Crow disfranchisement in Tennessee, late 18th into the 20th, or late 19th, early into the 20th century.
Dr. Beto, what did criminal disenfranchisement in Tennessee look like in the 1960s?
In the 1960s, it looked a heck of a lot like it had looked for quite a while in terms of the actual laws. They were still using the laws that pretty much the laws that had been enacted in the early 19th century of crimes that were considered infamous. That was a list of crimes that would be used, and if you were found guilty of one of those crimes, you would be disfranchised, or could be disfranchised anyway.
And what are some examples of those crimes that were listed?
Oh, it would be, let's see, bigamy, larceny, burglary, housebreaking. I might get some of these wrong. It would be destroying a will. I think would be abusing a female child. That was one. Horse stealing was one. There was a list that, and I'm sure I'm missing some of them, that was periodically reproduced, was still being used. That it really started in 1820s and had maybe changed in a few ways over time, but basically that was the guidance they were still using.
And Dr. Beto, what about for the 1970s? What did criminal disenfranchisement in Tennessee look like then?
It was sort of rendered chaotic in the 1970s, but it looked similar up until the end of the 1970s. However, there was an interesting change in 1972 that kind of upended the system eventually.
And what change was that?
All right. Well, this is there were 9 words that were deleted from a statute that would list all of the infamous crimes, and it said, after all these, and shall be rendered, and shall be, these are infamous crimes, and if you're guilty of these, basically it said, you will be rendered, you will lose your voting rights, and your other rights, right? The electoral franchise. And the 9 words just included electoral franchise. And there was a legislative house cleaning of some sort. It's mysterious. But those 9 words were taken out of that law, even though at the beginning of the law it says something like disfranchisement for crime. So it still said that in the label of the law, but in the law itself it took out these 9 words. I don't know why they did that, right? The best explanation we see, and looking at the source material, is that it was inadvertent. They didn't notice what they'd done. But courts later, much later, And I don't know the story on that either, but somebody called it to their attention, and a court ruled eventually, Chancery Court, late 70s, maybe even 1980, said, look, this law is no longer self-executing. Because you've taken out these 9 words, it is no longer self-executing. However, they were still, as far as I can tell, enforcing criminal disfranchisement using, on the belief that the law was still in effect all the way through to this time.
Dr. Beto, can you give us the citation to that legislation that you're referring to that removed those 9 words, and then the court case that you're referring to that ruled that the law is no longer self-executing?
Sure. It's in my second
Okay.
report. Let me see if I can find it for you. Oh, no, it's in the first report. What am I saying? Okay, let me go and go back here. I'll find it for you real quick. Okay, here it is. It's on page 5 and 6.
Would that be exhibit 74, Mr. Wilson?
74, yes, Your Honor.
Okay, and page 5?
5 and 6 is under the heading of bungled legislative house cleaning. And I quote the law and then highlight those words, it's a really weird story, that were taken out in 1972.
Okay, so which statute is it you're referring to?
It is 16. Okay, I don't list the statute, but I list a court case that cites it.
I
Here,
believe the
I think.
statute's listed in that first paragraph on page 5 under the heading, TCA.
Oh, yeah, it is. It is listed there. I'm a footnotes guy, so I just looked automatically at the footnotes. Yeah, that's it. Yeah. Yeah, and I found it. I went to the state archives, and they looked it up for me.
Okay, and what is that statute, Dr. Beto?
TCA 40-2712.
All right, thank you. And then you were going to cite us to that case, would that be on page 6?
Beginning at the page 5 and continuing that long block quotation on page 6.
And that's the Crutchfield case.
That is actually not. That is actually a quotation directly. I didn't put it in the footnotes, I put it in the body of the paper. That's the quotation of TCA 40-2712. And I don't remember if Crutchfield explained that. I think that they did. I think they discussed that. But I went back and I looked for the original citation.
I don't want to get confused. Which case are you citing for the proposition that the law was no longer self-executing after those 9 words were removed? Which case was that?
I believe that was Crutchfield v. Collins.
Okay. All right, thank you.
Although, let me look here. Let's see. I believe so.
Dr. Beatty, you mentioned earlier Chancery Court. Was that in your report on page 7?
Yeah. Yeah, that might have been the case. It might have been the Chancery Court case. I don't know if it was Crutchfield or the Chancery Court case. But anyway, I cite here a news story about it, where the judge in that case, Robert Brandt, 1980, said that careless deletion of those 9 words, assuming it was careless, I think it was, meant that enforcement of the disfranchisement law was no longer self-executing.
And thank you, Dr. Beto. And what happened after the 1970s regarding criminal disenfranchisement in Tennessee?
Okay, well, these court rulings sort of threw everything up for grabs. And the legislature, people in the legislature decided, well, we want to have criminal disenfranchisement. We're going to have to change, we're going to have to get a new law, right? And they could have, I think, probably just done the old law, brought that back, but there was really no support for doing that. So they did a new approach to criminal disenfranchisement instead.
And what was that new approach?
It was to declare all felonies infamous.
And what was the final vote in the General Assembly for that law?
I believe the vote was unanimous, at least in one of the two houses. It was overwhelming, though. Overwhelming support for it. I have it here, I think. Let's see, what do I say? Yeah, okay. In the House, it was 85-10, and in the Senate was unanimous.
And Dr. Beto, in your review of this 1981, what evidence of racial discrimination did you find in its enactment?
I didn't see any evidence. I didn't come across any evidence.
And what sources did you review for the 1981 law?
Well, I looked at heavily at newspapers. I looked at what I could find, which wasn't too much, at the state archives, as far as papers of particular legislators.
Objection, Your Honor. Dr. Beto testified at his deposition that he went to the state archives, or he had not gone to the state archives prior to issuing his report.
I didn't testify to that.
Your Honor, his report is reviewed where he shows that he reviewed the legislative proceedings of the 1981 law.
The legislative proceedings.
Yes, Your Honor.
Counsel, what do you say about that?
I guess I'm not sure where it says he reviewed legislative proceedings, Your Honor.
And your objection was to the,
Yes, Your Honor. He said that he had gone to the state archives to review documents relating to the 1981 law.
all right, can you clear that question up, Mr. Wilson, please?
And Dr. Beto, for your review, what sources did you rely on? You mentioned newspapers. Were there any other sources?
Yeah, I mean, I went to the state archives as well, and I looked up stuff I could find there, and there I did find out about these audios, but I didn't review them before I did the report. So I looked at things like the law. I mean, I looked at the old statute books. I tried to get information on the legislators who had been involved in this legislation, their private papers.
Yes, Your Honor, and the objection stands, same objection, and I think maybe the confusion here is Dr. Beto's done additional research after he issued his report in this case, and my understanding is he went to the archives after his report was issued in this case and after these opinions were rendered. And so that's not a basis of his opinion in his report.
Do you have that in the deposition?
All right, Mr. Wilson, counsel says it's not, going to the state archives was not a basis for his opinion that he went after.
I think we're going to look it up in the deposition, Your Honor.
All righty. I'm sorry, counsel, tell me your name again. I keep saying counsel.
Yes, Your Honor, Seth Engel.
Engel?
Engel.
Engel.
Yes, sir.
All right, yes, sir. Thank you.
Yeah, let me see if I can clarify. Dr. Beta, when did you go to the state archives before you're issuing this first report?
I don't remember the date, but it was very early. I went several times.
And did you go before you wrote the first report?
Yes.
Objection, Your Honor.
Yes, sir?
In his deposition, he stated specifically he had not gone to the state archives before
Okay.
issuing his first report.
I'm sorry, repeat it again?
At this deposition, he stated specifically that he had not gone to the state archives in connection with, well, I guess the question is, had you been to the archives in connection with this case before submitting your report? No, other than yesterday.
And so, would that be a basis for cross-examination, or would it be a basis for an objection to his testimony?
Objection to his testimony, Your Honor, because this is a undisclosed basis of his opinion that was not part of his report in this case. So he reached an opinion about this law without having gone to the state archives and reviewed whatever he reviewed at the state archives.
Your Honor, they were able to talk to him about it at the deposition and about his report for his findings in the archives.
I understand. The court will overrule the objection. I don't think that it's a basis for, I think Dr. Bader can testify to it. That might be an issue for cross-examination, but the court is not going to strike that, that testimony.
Thank you, Your Honor.
All right.
And Dr. Beto, after 1981, what happened with criminal disenfranchisement in Tennessee?
All right. Well, they declared all felonies to be infamous, and in 1986, they revisited the issue and passed some revisions to that law.
And what revisions were those?
The revisions basically streamlined the process, and also determined, specified, streamlined the restoration process, and also stated that there were certain crimes that you could not get the franchise restored for.
And Dr. Beto, based on your review, was that the first time in Tennessee law that some felons were disqualified from seeking the restoration of his or her voting rights?
As far as I know, it was, yeah. Mm-hmm.
And Dr. Beto, in your review of this 1986 law, what evidence did you find about racial discrimination in the General Assembly enacting this law?
I didn't find evidence, and that it had support of most of the African Americans in the legislature, as did the 1981 Act. And in fact, it was seen as easing, that were the headlines, easing the law, making it easier for people to, making it fairer and easier to have rights restored.
And Dr. Beto, what happened after 1986 with criminal disenfranchisement in Tennessee?
Well, there was a new debate that arose in 2005, and then ultimately led to a new law in 2006. And this, I could describe it if you want.
Yes,
Yeah,
what
okay.
did the
Well, what it
2006
did is it basically took it out of the hands of the courts, because before this time you had to go to a circuit court, I think it was, if you wanted to get your as part of the restoration process, you had to go to a judge. And what they did is they basically said, no, you don't have to do that anymore. You fill out a form, you fill out a certificate, and in that certificate it would be laid out what you needed to do in it. And then this would be submitted, I believe it was to the Division of Elections. And then a decision would be made. So they're trying to make the process more uniform. They're trying to sort of say, okay, you can streamline it, and this is a predictable way that you can get your rights, you can apply to get your rights restored.
And who was the legislator that wanted to change the law?
There was a legislator named Cohen from Memphis, Steve Cohen. He was big pushing this. But again, prominent supporters would also included African American legislators such as Larry Turner and Larry Miller.
Dr. Beto, based on your review, what evidence did you find of racial discrimination in the General Assembly's enactment of this 2006 law?
I didn't find any. In fact, the main opposition was it was too lenient. That was the argument that was made by some people. But I didn't see a racial consideration. In fact, I saw heavy support from African Americans. Let's see, Senate was 26-7. But as I said, and then closer in the House, but then most of the opposition came from legislators who thought this is being too generous. And the sponsors of the bill kind of complained about that. Said there's some people here who don't want to forgive anybody, and that kind of thing.
And Dr. Beto, what happened after the 2006 law?
Well, the big thing, I guess, is to get another law, 2025. You want to skip there, and that was the current law, the current disenfranchisement law, which again had heavy support, overwhelming support in the General Assembly. And the vote, the vote in the House was 86-8, and the vote in the Senate was 28-2. And what this did is it kind of took it back to the courts again. But it also, somewhat complicated, but it also had kind of separate tracks where you could get your, apply to get your voting rights restored, but your other rights might not be restored, right? But your voting rights might. So it created kind of a system it was seen again as part of easing the process, making it a little easier by the supporters.
And how did the 2025 law relate to the 2006 law?
I would say the main thing that happened was that it kicks it back to the courts, where the 2006 law took it out of the courts. But other than that, it's pretty similar as far as the standards that are being used.
Dr. Bailey, let me go back to the 2006 law for a moment. Were there any felons that were disqualified from seeking restoration under that 2006 law?
You mean permanently disqualified?
Yes.
Yes. There were a set of crimes. I'm trying to remember all of them. I think murder was one, rape, various sexual crimes were, involving children, that kind of thing. There were also crime of, I've heard it labeled different ways, interference with government operation. These were a set of crimes that would include things like, it was a whole list, tampering with witnesses, aiding an escape. Those would be two examples from that.
And was that also included in the 2025 law?
I believe so, yes.
And Dr. Beto, based on your review, what evidence did you find of racial discrimination with the General Assembly's enactment of the 2025 law.
Objection, Your Honor. It's an undisclosed opinion. This is not part of his report.
Your Honor, he talks about the 2025 law in his report. And it'd be
Give an
reviewed.
opinion as to whether or not there was racial discrimination.
Your Honor, he talks about in his report where it has overwhelming support in the General Assembly from Democrats and most African Americans.
I'm sorry, I'm having a hard time hearing you, Mr.
Sorry, Your Honor. Dr. Beto in page 11 on Exhibit 74 discusses at the end of that, before the conclusion, that the 2025 law had overwhelming support in the General Assembly and what the votes were for that. So he was reviewing at least the records or public records on those, on the 2025 law.
The objection goes to his opinion about, state your objection again, Mr. Engel.
Yes, Your Honor. The question was his opinion on whether there was evidence of racial discrimination in the law.
Okay.
The only thing in his report about the 2025 law is the race of the people that voted in favor of it.
Yes.
And so his opinion about evidence of racial discrimination is an undisclosed opinion. It would be fine if he testifies about the race of the legislators, but not the next question of opining that there's no evidence.
Your,
Mr. Wilson, did Dr. Beto give an opinion regarding racial discrimination? Was the question asked to the 2025 law or the 2006 law?
Your Honor, I just asked what evidence he found. I didn't ask for his opinion on.
No,
For
you
that.
did. The question had, you asked him specifically about racial discrimination. The objection is that it was not disclosed.
Your Honor, I think that's part of his disclosure in the report of how he's reviewing the law, and then I just asked him, what evidence do you find of any racial discrimination in the
All right,
General
and
Assembly?
the objection is very specific. The objection is that that was not an opinion that he disclosed. So I guess the first question is, did Dr. Beto disclose that opinion? And if so, when and where?
Your Honor, I think it's fairly within his report, Your Honor,
Well,
on
if you
Exhibit
can't cite me
74.
for it, I'm going to sustain the objection.
Okay.
You take a moment and see if you can find it.
May I take a minute? To the next page, I'm sorry.
Okay.
Well, Dr. Beto's conclusions says that discriminatory.
I'm sorry, Mr. Wilson,
So-
because you're talking down and
Yes,
oh, okay.
I'm sorry, Your Honor.
Okay, that's okay.
Dr. Beto's report explains, and I believe he testified in the stand today as well, that he didn't find any racial motivation in any of these laws from the 1960s onward. And so this is just a continuation of that as well.
So what is the answer then to my question? Did Dr. Beto disclose an opinion regarding the 2006, we're not talking about the 1960, because he went through various different changes dating back to the 60s. The question is related to the 2006 and 2025 changes. So that's a very specific question. And my question is, based on the objection, did he disclose that opinion? It's really a yes or a no.
Your Honor, just one clarification. Our
Okay.
objection is only to the 2025 law.
Okay, okay.
In 2006, there is a specific disclosure.
Okay,
Uh,
stand corrected as to the 2025.
Your Honor, we'll keep it with the objection on that, so.
I'm sorry?
That'd be fine to sustain the objection, so we'll strike that question.
All right, thank you, Mr. Wilson.
Okay.
The objection is sustained.
And Dr. Bayo, thank you. Those are all of my questions, and we'll pass the witness, Your Honors.
All right.
Thank you.
Mr. Wilson. Why don't we take a short recess before the cross-examination? Let's take about a 10-minute recess.
All right.
it's,
You completed your cross?
direct, Your Honor, but just wanted,
Correct, I'm sorry.
just wanted to
Correct.
point out one thing from Exhibit 74, which was
Okay.
the report from Dr. Beto, and that would be on the last page. It's just that, where he writes in his conclusions that discriminatory motivations cannot adequately explain the various legislative phases of criminal disenfranchisement revision since the 1960s, and then also towards the end. A key driver in each of these phases was a desire to implement uniformity and fairness. The main motivation for the most recent reform of 2025 was to simplify a system which many had come to regard as needlessly complicated. And following the earlier pattern, it had broad support.
Now, are you testifying, or what are you doing?
Your Honor, this is just from the report, so we just want to point out, I think it went to the kind of the last
I know, but you
objection.
can't testify, so what are we doing?
Yes, Your Honor.
Okay,
Just wanted to point that out. Thank you.
I know, but pointing out that you can't testify, so, I mean, it's in the report, though.
Yes, Your Honor.
Okay,
Thank you.
all right, thank you. All right, cross-examination,
Yes, Your Honor.
okay?
Good morning, Dr. Beto.
Good morning.
Dr. Beto, you're familiar with Ms. Moses's expert witness in this case, Dr. Philippa Holloway?
I read her report. I know a little about her, but I've never met her or anything like that.
And were you familiar, you were familiar with Dr. Holloway before you were approached to be an expert in this case, correct?
Yeah, I had seen her work on felon disfranchisement before that.
In your opinion, Dr. Holloway is one of the leading scholars on the topic of felon disenfranchisement, correct?
I'd agree with that, yes.
In your opinion, Dr. Holloway's work on the topic of felon disenfranchisement is quite good?
I would say it's good. I haven't gone over it in great detail and great depth, but yes.
Dr. Holloway's book, Living in Infamy, is one of the leading academic works on felon disenfranchisement, correct?
Yes, I would say so.
Dr. Beto, you read Dr. Holloway's report prior to writing your report in this case, correct?
Yes.
You are in general agreement with the opinions in her report, correct?
General agreement, I'm sure that there'd be aspects of it I would disagree with or take a different approach, but on the whole, yes.
Okay. Nowhere in your report do you criticize or critique Dr. Holloway's report, correct?
I don't believe I do.
You agree with Dr. Holloway's opinions in her report regarding the history surrounding the 1870 convention?
As I'm sort of sitting here now, I can't think of anything. I might disagree with some of that, now that I think about it.
Dr. Beto, you were deposed in this case, correct?
Yes,
You were deposed twice?
I believe so, yes.
Okay, and during both depositions, you testified under oath, correct?
Yes,
And during both depositions, there was a court reporter present,
I believe so.
and a transcript of those depositions were made,
Yes,
and you had the opportunity to review those depositions
yes,
and make any corrections that you wanted to.
yes.
Your Honor, if you can give the witness a copy of his depositions and the exhibits from his depositions.
Okay, any objection?
No, Your Honor.
Okay.
All of it, yeah, thank you. All right. Dr. Beto, can you turn to page 62 of the May 30, 2025 deposition? and I'll direct you to line 13, which says, question, you mentioned a general agreement with what Dr. Holloway put in her report. Can you tell me with what you agree? Answer, I agree, you know, in a general sense with her conclusions about the 1870 Constitution, that the 1870 Constitution was really a pioneering document in many ways in giving African Americans in the South voting rights and so forth. Did I read that correctly?
Yes, you did.
And that was true, and that was truthful testimony at the time you gave it?
Yes, it was.
All right, you can set that aside for now.
Okay.
Dr. Beto, you agree with Dr. Holloway's opinions in her report regarding Tennessee in the late 1800s?
In the report, yeah, that you're referencing there that I was discussing. Yeah, in general, I do agree with them.
Right. Doctor, you agree that in the late 1800s, white supremacist Democrats would do anything in their power to restrict voting rights on the basis of race?
I think that's a fair statement.
And Doctor, that includes both the laws themselves, but also how the laws are enforced, correct?
Yes.
You would agree with Dr. Holloway that the poll tax was one of the means used to restrict voting on the basis of race?
Yes.
And Doctor, the reason the poll tax was effective at discriminating on the basis of race to disenfranchise Black Tennesseans was because they tended to have lower incomes, correct?
That would be one reason.
You agree that the poll tax was facially race neutral, but was nonetheless a tool used to discriminate, correct?
Yes, I'd agree with that.
You agree with Dr. Holloway that felon disenfranchisement was one of the means that was used to restrict voting on the basis of race in Tennessee?
I didn't come across any evidence of that, but I find it believable that they would use any means necessary, including that. Or at least some of them would.
And Dr. Beto, you agree with Dr. Holloway's opinions in her report regarding the first half of the 20th century up to roughly the 1960s, correct?
It's been a while since I read it, and I don't know what her general conclusions were, but certainly in the early 20th century, there was a lot of disfranchisement going on through various legislation, including the poll tax and Dortch law and Myers law and other pieces of legislation.
Hey, Doctor, you agree with her opinions up to roughly the 1960s, correct?
I don't recall what her opinions were specifically about the 1950s and 1960s. My main memory of her is her discussion of that earlier legislation and the early enforcement of it. And on that, I do generally agree.
And Dr. Beto, can you turn to page 63 in that same deposition? All right, page 63, starting at line 4. This is your answer, and I generally agree with her conclusion that, you know, once Democratic white supremacist politicians dominate increasingly hold sway in the state of Tennessee, that they're going to use any means possible. And she gave a couple examples of that, and that they're going to use any means necessary. I think that they're going to use mainly things like the poll tax, but they're going to use criminal disenfranchisement provisions as well. So I agreed to her to that extent. This early period, I guess you could say the period up till roughly the 1960s. Did I read that correctly?
Yes, you did.
And that was true. That was true and accurate testimony at the time you gave it?
Yes.
And Dr. Beto, the any means necessary that you said, that is to disenfranchise Black Tennesseans, correct?
Yes.
Dr. Beto, you agree that white supremacist influence in Tennessee continued into the 1950s and the 1960s?
I agree it continued, although I think it was starting to wane, but I think it continued.
Okay. And you can put that, you don't have to hold the transcript word.
Okay. All right.
Okay, and you would agree that for the period of time prior to the 1960s, Tennessee would use anything, including criminal disenfranchisement, to dilute the political power of Black Tennesseans?
White supremacist politicians would, to the extent they have power.
I'm sorry, could you repeat that question, Mr. Engel?
Yes, Your Honor. You would agree that for the period of time prior to the 1960s, Tennessee used criminal disenfranchisement to dilute the political power of Black Tennesseans?
I would agree that white supremacists, I didn't see any evidence of it. I'm just saying as a matter of that they're doing other things, right? They're using other methods. Their influence is waning over time. I guess it depends on the particular circumstances, but there are certain white supremacist politicians, I think it's quite logical to believe they would use any method that they could. But to what extent they had power at a particular time, to what extent they were checked by competing forces, again, I didn't see examples of it. I'm just saying that it's a matter of logic that seems believable.
And Dr. Beto, is that both logic and your expertise as a historian?
Expertise of a historian in the sense that I would see people that would politicians, people that brought in, I think especially in the earlier period, things like the Dortch Law, the Myers Law, the Lee Law, that these were used in sometimes very blatant ways to discriminate, and I find it believable if people like that, if they had other methods, they would use those other methods, if they have the power to use the other methods.
Dr. Beto, what was the Lee Law? I'm sorry, you referenced the Dortch Law, Myers Law. Was the last one Lee?
Yeah, I'm trying to remember myself what it is. I think that was the two box, and I don't think it was ever actually implemented, but it was a law to segregate the ballots in local elections and in federal elections. And I don't think it was actually ever used because they were worried that the federal government would come in and start supervising elections, and that never happened.
All right, thank you. I wasn't familiar with it. I've heard the Dortch Law and the Myers Law mentioned during this trial, but I had not heard the Lee Law
It
mentioned.
was called the two-box law, too.
Okay, all right, thank you.
Dr. Beto, you mentioned that you hadn't seen evidence of those certain things. Isn't it true that you spent a total of 15 hours working on this case from the time you were retained until the time you finished your report?
15 hours? I'm not sure. I guess you have the records. I'm not sure how many hours I spent on it.
All right, Dr.
But
Beto,
certainly not as much as I'd like.
can you turn to that same deposition, page 51?
Okay.
And then I'll start at line 15. Question, from the time you were retained to the time you submitted your report, roughly how many hours did you spend working on the case? Answer. I'm trying to think how many hours. You were talking about it from the time I was brought into this case until the time I wrote the report, right? Questioner, yes. Answer, I'd have to say maybe 15 hours, something in that range. Did I read that correctly?
Yes, you did.
And that was true and accurate testimony at the time you gave it?
I don't remember giving it, but I'm not gonna dispute it.
And the report being referred to there, Dr. Beto, that's your first report, correct?
The first report, yes.
Dr. Beto, you mentioned, I think maybe that you would wish you had had more time to research your report, is that correct?
Yes, and I'm still thinking the 15 doesn't seem right, but it's there.
And Dr. Beto, that was your testimony in May 2025?
Okay,
Is that correct?
yeah,
And that's closer in time to when you did your research than today?
yeah,
And so your memory about what had happened back then is probably better in May 2025? than-
probably.
Thank you. Going back to, you said you wish you had more time to research your report. Is that correct?
Always, almost always.
And you didn't have the time to conduct the kind of research that you might have wanted to do in this case?
That's always true.
Right. You were under time constraints with this report, right?
Yes.
And there are things you could have done in conducting research or report, but you didn't have time to do?
There are always things I could have done.
There were also things you wanted to do, but didn't have time to do, right?
I suppose so. I can't think of examples offhand. Things I just said, oh, I wish I could have done this.
Prior to issuing your report in this, first report in this case, you had not listened to the audio debates of the 1981 or 1986 laws, correct?
Yeah, that came later.
And you would have reviewed those prior to issuing this report if you had more time.
Oh, yeah.
And you could have gone to the state archives prior to your first report, right?
I did go.
In your 15 hours, that included going to the state archives?
I think it was more than 15, but I did go to the state archives, and I turned in the records of my visit there.
Okay, Dr. Beto, can you turn to page 70 of that same deposition transcript? Sorry, page 67, apologies.
Okay.
Give me a second. And I'm going to start at line 9. Question, had you been to the archives in connection with this case before submitting your report? Answer, no, other than yesterday. Did I read that correctly?
Yeah, you did.
Was that testimony truthful and accurate at the time you gave it?
I guess so, but I remember going there and finding the particular item from the 1972 report, or this 1972 law. So I thought I'd gone there before that.
Could that have been after your report, doctor, but before the deposition?
Your Honor,
Possibly, yeah.
sorry, Your Honor, not just objection, but since there are multiple reports in this case, I just want to be clear that this is the first report,
report.
Exhibit 74.
Okay.
Dr. Beto, you would agree that your opinions in this case could change if you do more research?
I think that that's always possible, they would change, and could change in some ways.
All right, I want to switch topics, Dr. Beto. Talking about statutes, would you agree that statutes passed in Tennessee are informed by the provisions and laws that have been passed before them in Tennessee?
Generally, I think that that's true, although people have short memories about history.
So you would agree that to understand a law in the 1970s, 1980s, or 2000s, you would want to know what the laws passed before then were?
Yeah, it's always good to know about what came before, and what the reaction, what the law, what they were reacting to.
And so you would agree that the practice of disenfranchisement in Tennessee in the 1800s is relevant to understanding disenfranchisement in Tennessee today?
Well, certainly the Constitution of 1870 is quite relevant to today. Is disfranchisement relevant? Could you be more specific about that, what you mean?
Yeah, Dr. Beto, so in understanding laws today in Tennessee's practice of disenfranchisement, is it relevant to consider Tennessee's practice of disenfranchisement in the 1800s?
Well, that was sort of the whole basis of my report, to look at whether or not there was discrimination still going on in the 1960s and 1980s, or 1960s, 70s, and 80s. So in that sense, I would agree. It's relevant in that sense.
Okay. Dr. Beto, my question, I guess, is a little different. Is it relevant to you as a historian to understand Tennessee disenfranchisement today to look at Tennessee disenfranchisement in the 1800s?
It's always good to have historical background about whatever you're looking at. I mean, that's, the more background, the better. To see if there's been change, for example, if it's the same.
All right, Dr. Beto, I want to talk about your first report. I'm looking at the first few pages. The first, page 1, the header is Historical Origins and Context. Is that right?
Let's see. Yes,
And that goes on until page 4, correct?
yes,
Your report in this case was about disenfranchisement in Tennessee, correct?
yes,
And specifically, you focused on disenfranchisement in Tennessee after the 1960s, correct?
that was the focus.
And in your report, you discussed disenfranchisement in the state of Illinois, correct?
I mentioned it, yes.
New England,
I mentioned it in the background section, yeah.
the Midwest,
I believe I mentioned it,
the colonial era,
yes,
Plymouth Colony,
yes,
England,
yes,
Europe in the Middle Ages, the Roman Empire,
that's right,
ancient Greece.
yeah.
You mentioned the views of Emperor Julianus of the Roman Empire on disenfranchisement,
Mm-hmm.
and Aristotle,
Yes,
And Aristotle died 2,000 years ago, correct?
A little bit more than that.
And you thought that was relevant context to understanding Tennessee disenfranchisement after 1960, correct?
I think it's relevant to the history of criminal disenfranchisement in the United States to see what the Americans, what examples they were building upon, and when those examples first arose.
Okay, and your first report is 12 pages, correct?
Yes.
And you spent, I think, 3.5 or 4 pages on that context that we just discussed?
Yes.
Because you thought that context was relevant to your report in this case, correct?
Yeah, it's always helpful to have background and context.
Right. Dr. Beto, as a historian, you have relied on the work of Dr. Holloway, correct?
I've used the work of Dr. Holloway. I've
Can you-
drawn from the work of Dr. Holloway, yes.
Okay, and that Alabama case that you mentioned having an expert report in, you cite Dr. Holloway's in that report, correct?
Yes.
You cite her book, Living in Infamy?
It's been a long time since I wrote that, but yes, I believe, I do remember discussing her in that report.
And in fact, you cite her 5 times in that report, correct?
Could be.
How many times do you cite Dr. Holloway in your first report in this case?
I don't know, I'm not sure.
Isn't it true that you cited her 0 times in your first report in this case?
Maybe so.
Do you want to take a look if you have a second report and see if you cite Dr. Holloway?
I believe you.
All right. How many times do you cite Dr. Holloway in your second report?
In my second report,
Yes.
I don't know. I don't think I do. The one on plea bargaining,
Correct.
yeah. Partly because I wasn't aware of what she had done on that.
Well, for the first report, you reviewed her report prior to issuing your report, correct?
Yes.
And you mentioned on direct examination that it was important to look at all the secondary sources you could find, correct?
All the secondary sources, yeah, and I certainly looked at the secondary sources, including her.
One moment, Your Honor.
Okay.
Dr. Beto, can you turn in the binder that is labeled First Deposition Exhibits. I'm going to direct you to tab 4. You on tab 4, Dr. Beto?
Excuse me?
You're on tab 4.
Let's see. Yes, I'm on tab 4. It's a long one.
Dr. Bader, in tab 4, this is your report from that Alabama case we've been talking about.
Right.
All right, Dr. Bader, if you could turn to page... Yeah, page 7 of 34. And then could you also turn to, in your report, exhibit 74. Your report, exhibit 74.
Oh, it's the deposition. Or you asked me on my report. Okay. Okay. What page is that again?
It was either page 3 or 4. I'm trying to find it as well. It's page 3. All right, and Your Honor, I have a demonstrative I'm going to use with the witness, permission to publish it on the monitor and to give a copy to Dr. Beto.
Okay.
Okay.
You can have it, yeah.
Okay.
Yeah, yeah. I just put my copy. Publish it. Yeah, page 1. All right, Dr. Beto, and what you have and what's on the screen is a selection of those 2 pages, one from your Alabama report, that's on bottom, and one from your report here. Is that correct?
Yes.
Okay, and I'll start with that first sentence that's highlighted on both. Prior to the Civil War, 19 out of 34 states disenfranchised for infamous crimes.
Can you blow that up a little bit, please? The top part.
Your Honor, if helpful, I also have copies.
Okay, that might help. Okay. Thanks. All right, counsel, you may continue.
Thank you, Your Honor. So the first sentence on both of those, first full sentence, reads, prior to the Civil War, 19 out of 34 states disenfranchised for infamous crimes. Is that correct?
Yep,
And that sentence was in your Alabama report?
yes, it was.
And that report was from 2020?
I don't remember when it was, but that sounds about right.
And that same sentence is in your report in this case, correct?
Yeah, I went back to it for helping me to give the background.
And that second sentence, the Illinois Constitution of 1848, for example, denied the vote for larceny, incest, rape, kidnapping, perjury, bigamy, counterfeiting, correct?
Yes.
And that is, I think there's a couple words different between the two, but that's almost the same sentence, correct? And then that last highlighted sentence on the bottom, Thompson v. Merrill, says advocates for felon disenfranchisement during the 19th century, much like the predecessors in ancient Greece and Rome, and then it continues. The first part of that sentence is the same in both reports, correct?
Yes.
And there's the sentence on the demonstrative that's highlighted in a different color that says, like Tennessee, it did not include violent crimes on the theory that many of them were not infamous.
Yes.
And that sentence was in your Alabama report?
Yeah,
That sentence is not in your Tennessee report, correct?
that's right.
And there is a footnote there, footnote 18. Do you see that in your Alabama report?
Yes.
What is cited in that footnote?
I think I cited Professor Holloway there.
Okay, so in your Alabama report, you include a sentence about disenfranchisement in Tennessee. You took that sentence out in your report about disenfranchisement.
Yes.
And at the time you wrote your report in this case, you were aware that Dr. Holloway was plaintiff's expert in this case, correct?
Yes.
All right, you can put that down. Dr. Beto, you would agree as a historian that absence of evidence is not evidence of absence, correct?
No, it isn't. Not that, I mean, but that could be true for anything. It could be true for conspiracy theories, all sorts of things. You want to try to find the evidence. Always.
So as a historian, that you did not find evidence of something, does not mean that that thing did not happen, correct?
That can be true. Yeah, there would be examples of that.
And as a historian, that you did not find evidence of something does not mean that there is no evidence of that thing, correct?
I would say that that can be true, yes.
So it could be evidence in a source that historian just didn't review, correct?
That can be true, yeah.
All it means when when a historian opines that they saw no evidence of something is that in the sources that they looked at and reviewed, they did not find any evidence, correct?
Well, presumably, if the historian has a good record of research, they would be more credible than somebody who's just your ordinary conspiracy theorist or something.
Okay, so Doctor, I think you're saying it depends on the quality of the research the person did, correct?
Yes, and the extent, the quality, yes.
Okay, it depends on what sources they reviewed, right?
It depends on what sources and how credible those sources are. and whether there were other sources that contradict those sources. Depends on a lot of things.
Well, as a historian, if you're going to evaluate the work of another historian, you would want to know what sources they reviewed in reaching their opinions, correct?
If I'm going to review a work of another historian, that would certainly, if I'm writing a book review, that would certainly be something I'd look for. What is the credibility of their sources?
Well, as a professor as well, if one of your students were to turn in a paper that said, I found no evidence of something, would you want to know what they looked at in order to reach that conclusion that they found no evidence?
Yeah, I might say to them, did you look at this and did you look at that?
And so if they didn't look at things, that is a limitation on their opinion, correct?
Well, you can't look at everything, but yeah, as a general proposition, if they're not looking around for different sources.
In your opinion in this case about the laws post-1960 that you discussed, your opinion is limited to that you did not find any evidence, correct?
And I looked for evidence, and I looked at the usual places that one tries to find evidence, and I didn't find it.
Okay. My question, Doctor, was your opinion is limited to that the sources you looked at did not have any evidence, correct?
The sources I looked at did not have that evidence.
And you are not and cannot make a broader conclusion that there is no such evidence, correct?
I think you can make that conclusion if you've done the research and you don't find it. I mean, the burden of proof is on people who, at that point, who to contradict you. If you've done your duty and you haven't found it.
In rendering your opinions in this case, you did not review every source available, correct?
Every source available. I reviewed all the ones that came to mind that could, go to the issue of what motivations were. But I didn't review every single source. There are more sources out there probably that I never found or didn't have time to look at.
On direct examination, you mentioned primary sources, which included letters. Is that correct?
Yes.
In reaching your opinions in this case, in your report, did you review any letters prior to opining in your first report?
No, I did not. Prior to the first report.
Okay. And you mentioned as well that one of the other primary sources was interviews. You didn't conduct any interviews in rendering your opinions in your first report, correct?
No, I did not.
And those are locations where there could have been evidence, correct?
Interviews are always problematic, or not often problematic, because you want to test them against your first priority, which is to get all the written evidence from the time, because people's memories aren't always correct. But interviews can be very useful to supplement that work.
Dr. Beto, my question was, there could be evidence in those locations, correct?
There could be.
And you did not review letters or conduct any interviews, correct?
Not prior to the first report, but I did later, not interviews, letters.
Regarding the 1972 law, you opine there is no basis that the deletion of these words by legislators stemmed from an intent to racially discriminate, correct?
That's right.
But you've also said, I haven't figured out why they took those words out exactly, what they were trying to do. Is that correct?
That's true.
Regarding the 1981 law, you opine the public record does not provide a basis for the view racial considerations motivated the legislative changes, correct?
That's right.
And the public record you reviewed in this to reach that opinion in your report regarding the 1981 law was newspapers, correct?
That's right.
In rendering that opinion in your report regarding the 1981 law, you did not review any audio or transcripts of the debates of the General Assembly, correct?
Yeah, I hadn't been able to get to that yet.
And your report does not, you would agree that those are, that the audio recordings or transcripts of the General Assembly's debates?
Well, I did review transcripts. Let me take that back. For the 2005, 2006.
Sorry, Doctor, I'll get to that.
Yeah,
1981 specifically is all I'm talking
right.
about right now.
All right.
For 1981, you would agree that part of the public record is the General Assembly's debates regarding a law, correct?
Yeah, that was public information.
And you opine that the public record does not provide a basis, correct?
That's right.
But you had not reviewed the full public record at the time you rendered that opinion, correct?
I think I wrote the report before I found out about those tapes, but I'm not sure. No, I had not reviewed those. I mean, I had not reviewed those when I actually did the report, reminding me I had.
And you don't note anywhere in your report that you had not reviewed those documents in rendering that opinion, correct?
I don't think I did.
You mentioned newspapers that you reviewed regarding the 1981 law. How many newspapers did you review to reach that opinion regarding the public record for the 1981 law?
I didn't count them, but it was a wide range of newspapers in the state of Tennessee that in Memphis, Nashville, other places that covered everything I could find that covered the debates.
And those are all cited in your report, correct?
The ones I quoted from are cited in there.
The ones that form the basis of your opinion are in your report, correct?
Not necessarily. I mean, there are lots of times I'll find sources that are useful, have useful information, but I don't cite them because other sources provide that information. So that's a small sampling of the numbers of newspapers I looked at.
Well, how many, regarding the 1981 law, how many newspapers did you review?
Did I review?
Yes.
I never counted them. It was more, though, than the ones I cited, which is typical in historical research, you know. You immerse yourself in material, you don't always cite everything.
And you did not document all the newspapers you reviewed then in your report?
All the newspapers I looked at?
All the newspapers you looked at in forming the opinion regarding the 1981 law, but they're not in your report, correct?
No, but if those newspapers it had information, quotations, and other material that it contradicted the findings that I provided, I would have cited them.
Okay. Let's move to the 1986 law. You opine that, as with earlier changes, the documentary record does not reveal any intent to racially discriminate. Is that correct?
Yes.
And by documentary record here, you mean newspapers, correct?
I would say primarily newspapers, but you know, I looked at other things that were out there, including court rulings and things like that. But newspapers would be the main to-go-to source.
And the documentary record reviewed regarding the 1986 law consisted of approximately 5 newspapers, correct?
That I reviewed? I know it was many more than 5, but the ones I quoted in there might have been 5.
Okay, let's turn to the 2006 law. You quote from Larry Turner, correct?
Yes, I believe I do.
I think that's on page 10. You say, agreeing, another key sponsor, Larry Turner, D. Memphis, depicted the bill as embodying the basic tenet of Christian religion, forgiveness. Correct?
Yes.
You also testified that the 2006 law expanded the number of crimes that were permanently disenfranchising, correct?
The 2006 law, yes.
So the 2006 law expanded the number of permanently disenfranchising crimes, correct?
Yes.
And that included making tampering with evidence permanently disenfranchising?
Yes.
So you would agree then that forgiveness was not a basis for expanding the permanently disenfranchising crimes in 2006, correct?
Objection, Your Honor. This gets into speculation.
It gets into speculation. Could you explain that, please?
Your Honor, we're getting into the point where we're speculating about the legislature's intention in enacting this law.
Could you restate the question, please?
Yes, Your Honor. As a basis for the intent behind the 2006 law, forgiveness could not have been the basis for making more crimes permanently disenfranchising.
Your Honor, again, this still goes to the speculation of what the legislature's intentions were. So even though this is a quote by Representative Turner at the time, so the reenfranchisement law in 2006 did different things, but this could still be part of the whole bill.
Well, is it proper cross-examination? I mean, if the opinion was that it, what was the opinion with regard to Christian, could you restate that again?
Yes, Your Honor. Do you mean to read it or just?
Dr. Beto's opinion, yes.
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 Agreeing, another key sponsor, Larry Turner, D. Memphis, depicted the bill as embodying the basic tenet of the Christian religion of forgiveness.
All right, so if I understand, if Dr. Beto based his opinion that there was not an intent to discriminate the 2006 law based on Representative Larry Turner's statement, would this not be proper cross-examination?
Your Honor, I still think that the question is getting to speculation of what the legislature intended for this law.
Okay, what do you say, Counsel?
Your Honor, his entire opinions are about the intent of the legislature. If him opining about the intent of the legislature is speculation, then all his opinions so far have been speculation.
Your Honor, I don't think that's his opinion. I think his opinion is just going, what's the evidence in the record? He's not testifying as to the intent of anybody.
Well, but he goes further than stating what's in the record. He gives an opinion that there's no intent to racially discriminate based on what he reviewed, correct? So he does give an opinion. He's just not simply stating what Mr. Turner said. He's giving an opinion.
Your Honor, this question is going to what Mr. Turner is saying. And so as far as it's getting into the basis of what Mr. Turner is thinking about or what other legislatures think about, we think that's getting
All right,
speculation.
repeat the question one more time, Mr. Engel.
Yes, Your Honor, I'll try to say it in the same way. To the extent forgiveness was the basis for the 2006 law, that could not have been the basis with regard to permanent disenfranchisement being expanded, because permanent disenfranchisement is contrary to the concept of forgiveness.
I'll sustain the objection.
Dr. Beto, would you agree that permanent disenfranchisement is contrary to the concept of forgiveness?
Your Honor, objection for relevance.
Relevance, counsel?
Yes, Your Honor. His opinion is that there was no evidence of a discriminatory motive. I'm trying to parse that out and get specifically to motive for permanent disenfranchisement to show that the motives that he's discussing in his report that are contrary motives do not apply to permanent disenfranchisement.
Okay, restate the question, please.
Yes, Your Honor. It was, do you agree that the concept of permanent disenfranchisement is contrary to the concept of forgiveness?
I'll sustain the objection.
Dr. Beto, was Larry Turner referring to expansion of permanent disenfranchisement when he made this statement about forgiveness?
I'm not sure what he was referring to, but I think he was mainly referring to the procedures, which he interpreted as making easier for people to get restoration of rights, to streamline the process.
All right, Dr. Beto, you also quote from Senator Cohen, correct?
Yes.
And Senator Cohen, you quote on page 10, you say, his goal was to make a uniform system and it would make it to where you wouldn't have to go to court to hire a lawyer and pay court fees, which is a vestige of the old poll tax, correct?
Yes.
So is your understanding that Senator Cohen then is expressing in 2005 that the current 2005 felon disenfranchisement scheme is a vestige of the old poll tax?
The old poll tax. He's saying that it's unfair to the poor because they have to pay these court fees, so he's going to try to make it less onerous for them. So is he comparing it to? He's comparing it to the old poll tax. He's not making a racial argument there, but he's saying that if you're poor, it's why should you have to pay these extra fees? It makes it more onerous. That's sort of what I would see he's trying to do there.
So Dr. Beto, is your testimony as a historian that when Senator Cohen is referring to a vestige of the old poll tax, that is completely divorced from race?
No, I wouldn't say that. I think the main could be, including, I don't know what is in his mind, but I think he's saying that this is unfair to poor people, that they have to pay these court fees and hire a lawyer, and we need to streamline the process. So he might be thinking of race there, he might not be. He's mainly worried about, it's onerous for people. It's difficult. It's contrary to this doctrine of Christian forgiveness.
Dr. Beto, the 2025 law, it now requires someone to go to court to restore their right to vote, correct?
Yes.
It requires them to pay court fees?
I'm not sure what it requires as far as court fees, but yeah, I assume they're gonna have to pay court fees if they go to court.
And if they're going to court and paying court fees, they should probably hire a lawyer, correct?
I just don't know enough about.
Your Honor,
the
object to speculation for that one.
Counsel, Mr. Engel?
Yes, Your Honor. He's
Speculation.
opining about the 2006 law and the intent behind it. And so I'm trying to delve into that opinion regarding what Senator Cohen said, and specifically getting then at the 2025 law, which he does not opine on as
Right.
potentially having discriminatory intent.
Okay, Mr. Wilson?
Your Honor, I think the question that he was asking was, whether that required the hiring of a lawyer and getting to that. I think that's getting into speculative content as well.
Why would it be speculative? to answer that.
Yeah, it's speculative because it's essentially asking for Dr. Bay's opinion on this law to get in, so. and
What
requirements
if
of
you
it.
go to court and you have to pay fees, is it a good idea to get a lawyer? That's speculation? Overruled. I think the
Your Honor.
witness can answer that.
Thank you, Your Honor.
All right, thank you.
All right, Dr. Bader, can you answer the question?
Could you repeat it?
Yes. If somebody is going into court to try to restore the right to vote, you would agree that they should probably hire a lawyer, correct?
It depends on how difficult it is to navigate in. If you've got a simplified form to send in, it's straightforward, maybe not. Maybe so, though, if there's some ambiguity there. So it kind of depends. And to be honest with you, I'm just not sure about that aspect of the law.
All right, Dr. Beto, I want to switch gears and talk about your second report now.
Sure.
In your review of court minutes, is it correct that you did not review any court records from Shelby County?
I believe I looked at Shelby County, and I did look at Shelby County, and I didn't find anything. I'm not sure if Shelby County, I believe that there were criminal court records there, and I didn't see anything. So I went through those for a while, and I didn't see much.
You did not review any records from Davidson County?
I did look at Davidson County, and I looked at Shelby County. I think the one that just didn't have the records was Hamilton County, but I looked at Shelby and I looked at Davidson.
Okay, you didn't look at any records from Knox County?
I don't recall if I looked at Knox County or not. I was going to make a trip there, but I never did. And I don't know whether they had a sampling of those at the state archive. There's so many counties in the state, so I don't know.
You didn't review any records from Hamilton County?
I did, but they didn't, that was the problem. They didn't have criminal court records for that period. I really wanted to look at those because Judge McReynolds, according to newspaper reports there, had a reputation as somebody who would forego jury trials.
You didn't review any records from Rutherford County?
I believe I looked at Rutherford County. I looked at a wide range of counties.
Dr. Beto, you have, I believe, 31 examples, is that right?
Yeah,
None of those examples are from Shelby, Davidson, Knox, Hamilton, or Rutherford County, correct?
no, they aren't.
And those are the 5 most populous counties in Tennessee?
I don't know, but I know they're populous.
You specifically only looked at examples after 1870, correct?
Yes.
And the examples, your 31 examples that you include, you only reported cases where the guilty plea and the defendant was declared infamous by a judge, correct?
Yeah, and there was no intervention of the jury. Now, there might have been, because that wasn't what I was focusing on, but those other counties, I may have seen examples there, because I did see more examples of where a jury was brought in, but I didn't focus on those. I focused only on the ones with the jury, no intervention of the jury.
So if you saw an example of a guilty plea where the judge did not state that the defendant was declared infamous, you did not report that, correct?
If I'd have seen that, I would have copied it. I don't recall seeing anything like that. Having said that, I was looking for those examples that I gave you, namely, no intervention of the jury, crime declared was an infamous crime declared to be infamous. And there may have been examples of the one, could you repeat it again?
Yeah, so if you saw an example of a guilty plea where the judge did not state that the defendant was declared infamous, you did not make a copy of that, correct?
I might have made some copies because what would happen in some cases was, it was quite interesting. The judge would just say, okay, as long as you pay court costs, you can go. But they would not actually rule the defendant guilty of the crime. But they would say, you can go if you pay court costs. So I saw cases like that, and I think, again, I didn't focus on that, but I think some of those did involve guilty pleas, where maybe the judge just said, okay, in that case, I'm not gonna sentence you, but you gotta pay court costs. That's your is a mitigation of sentence kind of thing. I saw that quite a lot, actually.
But you did not include any of those in your report, correct?
No, because it was narrowly focused.
For the entire period of your focus from 1870 to 1924, is it correct that you found a total of 3 instances in which a person pled guilty, waived the right to a jury trial, and the judge thereafter declared the person had lost their voting rights?
More or less, because some of these cases would involve more than one defendant, but that sounds about right. The big spurt in that comes in the 60s.
And so in the 10 years between 1870 and 1880, you found 0 instances in which a person pled guilty, waived the right to a jury trial, and the judge thereafter declared that person had lost their voting rights, correct?
Yeah, again, I only was able to look at a small number of the tens of thousands of cases there are in Tennessee. But yeah.
And you said you looked at over 1,000 cases, correct?
That would be about right.
And you were doing text searching through a lot of that, correct?
What do you mean by text searching?
You didn't just go through microfilm, you were actually searching for specific words, keywords?
I did a combination. I did a lot of just going through microfilm, and then the databases that are out there that they have at the archives, I did a lot of text searches there.
I'm sorry, Counselor, I've got a little confused. Initially, you asked the question from 1870 to 1924. You said there were 3 instances. What was the distinction between the 3 instances and the 0?
Yes, Your Honor, it was 0 between 1870 and 1880, and 3 then, I think, starting in 1882 to 1924.
Okay, all right, thank you for clarifying that.
Dr. Beto, you would agree that in Tennessee, a person could plead guilty to a crime prior to 1870?
Prior to 1870, yes.
You would agree that in Tennessee, prior to 1870, a person could plead guilty to a felony?
Yes.
Dr. Beto, that's all the questions I have for you.
Okay, thank you.
All right, thank you, Mr. Engel. Redirect, Mr. Wilson?
Your Honors, I'll be short. Dr. Beto, did you find any racial discrimination in the enactment of the 2025 law?
Objection, Your Honor.
Your Honor, we'll direct, again, to Exhibit 74 in the last part for Dr. Beto's report.
I'm sorry, the question, there was an objection to the question?
Ye-
Yes, Your Honor, this is the same question that they tried to ask and was sustained on direct examination about racial motivation behind the 2025 law, of which Dr. Beto did not provide an opinion, despite providing a specific opinion regarding the 71, the 86, the 81, and the 2006.
Okay, Mr. Wilson?
Let me see if I can restate it. Dr. Beto, what were your conclusions about the 2025 law?
My conclusions were that I saw no evidence of racial discriminatory
Objection, Your Honor.
intent.
Okay, I thought we dealt with this on direct. Did you not agree that he did not give an opinion?
Your Honor, again, we'll point to that last page on Exhibit 74 where he does
Okay,
give an opinion on it.
don't point to, don't point me to anything. My question was very specific for you. And either he gave an opinion or he didn't. So what's on 74? Is it an opinion regarding racial discrimination or is it not?
Yes, Your Honor, we do think so, and
Okay,
that's what he's testifying
tell
to.
me what opinion he gave, and then counsel can respond to it.
Your Honor, that discriminatory motivations couldn't adequately explain, any of the legislative acts since the 1960s.
I'm sorry, repeat it again, please.
That discriminatory motivations couldn't adequately explain the enactment of any of the laws since the 1960s regarding criminal
All right,
disenfranchisement.
Mr. Engel?
Yes, Your Honor. Dr. Beto provides a specific opinion regarding racial discrimination, regarding the 72 law, the 81 law, the 86 law, and the 2006 law. He does not provide that opinion regarding.
All right, well, Mr. Wilson says that he does, and Mr. Wilson says that he's citing an opinion that Dr. Beto gave with regard to the 2025 law. So do you agree with that, with what Mr. Wilson is saying, or do you disagree?
No, Your Honor. The statement that Mr. Wilson's saying is a very broad general statement.
Okay.
It's not a statement about the 2025 law. And Dr. Beto was very clear if he had an opinion, there's a specific sentence about the law and what his opinion is regarding racial discrimination in that law. There's no such sentence in the 2025 section of his report. And now they're trying to use, now this is just some general language trying to backdoor that opinion in when it's very clear that Dr. Beto, if he had an opinion, knew how to say that in his report.
Okay, Mr. Wilson?
Your Honor, that very same paragraph on the last page goes down and talks about the main motivations for the 2025 law. So based on that opinion.
What page is it? Okay, let me see nothing, 'cause on the first report.
We're looking at Exhibit 74.
74, correct, Your Honor. And it'll be the starting with the sentence that starts with the key driver.
Okay. All right, why do you say that this does not apply to the 2025 law, Mr. Engel?
Yes, Your Honor, this is not an opinion about racial motivation
Okay.
at all regarding the 2025 law.
Okay,
And Dr. Beto, in each other section when he discusses one of the other laws, specifically says, the evidence I reviewed did not have any evidence of racial discrimination. And then now they're trying to point to a vague sentence about something else, not about racial discrimination, specifically an opinion about the lack of evidence of racial discrimination. In addition, Your Honor, I don't think the door was opened on cross-examination for redirect about his 2020, an opinion about the 2025 law.
Let me ask you though, in looking at Exhibit 74, unless I've got a copy that no one else does, I read the main motivation for the most recent reform of 2025 was to simplify a system which many had come to regard as needlessly complicated. I mean, that's in the record, correct?
Yes, Your Honor.
And you're saying that's non-responsive to the question?
Correct, Your Honor. That is an opinion about a different motivation. It is not an opinion that there is no evidence of racial discrimination. That's a very specific opinion that Dr. Beto makes regarding each of the other laws that he does not make in his report regarding the 2025 law.
right, in other words, that law was designed to make it easier to vote, but that's not the same question as whether or not there was any evidence of racial intent.
Correct, Your Honor.
Correct. All right, the objection is sustained. I read Exhibit 74, I've read the entire last paragraph, and the last sentence, the main motivation for the most recent reform of 2025 was to simplify a system which many had come to regard as needlessly complicated. Following the earlier pattern, it had broad, which included, and this is what it says, it had broad, which included a majority of Republican, Democrat, and African-American legislators. So the objection will be sustained.
Thank you, Your Honor.
Yes, sir.
No more questions for Dr.
All right?
One more question, sorry, Your Honor. That's all. Your Honor, those are all my questions. Thank you, Dr. Beto.
All right, thank you,
Thank
Mr.
you.
Wilson. Dr. Beto, that concludes your testimony this morning. Thank you very much for coming
Thank you.
and testifying. All right, it's 12:35, probably a good time to take a lunch break. So let's come back about 1:30, and what does your afternoon look like, Mr. Wilson?
We have one more witness this afternoon.
One more, okay. And then will there be any rebuttal witnesses anticipated, or?
No rebuttal witnesses, Your Honor. We're still evaluating whether or not we want to try to get a small thing into the record, but if we do that, it'll be very, very short.
Okay, so then we can look forward to closing arguments today?
Yes, Your Honor, we're prepared.
Everybody's prepared?
My intention with the one witness is to be very, very brief, so we anticipate closing.
Okay, wonderful. So then let's come back at 1:30.
All right.
Okay. All ready? Okay, let's take a recess. Okay. Just write it down for me. It's okay. All right, good afternoon, everyone. We're going to go ahead and get started this afternoon. Good afternoon, council. How are you?
I'm doing well, Your Honor. How are you?
Wonderful, wonderful. Good to see you. Let's see. So you have another witness you're going to call?
Yes, Your Honor. We'd like to
Okay.
call Gary Smith to the stand.
All right, Mr. Smith, please come forward. Hi, Mr. Smith. Hi, I'm fine, thank you. Raise your right hand for me, please. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? Wonderful. Have a seat, please.
Why don't you grab this? Yeah. Notebook? Oh, all right.
No? Okay. Mr. Hill, are you ready?
Yes, Your Honor.
Okay, you may proceed.
Good afternoon, Mr. Smith. How are you today?
Doing well.
And do you mind stating your name for the record?
I'm Gary Smith.
And Mr. Smith, what do you do for a living?
I am the Director of Advanced Analytics and Visualizations for the Tennessee Department of Health.
I didn't catch a word of that.
Let me see.
Director of, and then you lost.
Is that better?
Yes.
How about that? Okay.
What
All
are
right.
you as the director of again?
Advanced Analytics and Visualizations for the Tennessee Department of Health.
I want to pull that a little closer so you can sit back a little bit, yeah.
Yeah,
Okay.
I'll do. Just let me know if you can't hear. I'll
Okay.
make sure.
Okay.
I run a team of about 18 people, epidemiologists and data scientists. We conduct research, surveillance, reporting, presentations, all on the opioid crisis or the overdose epidemic in the state of Tennessee.
And Mr. Smith, I'm going to hand you a document that's going to be the next numbered exhibit. I think it's 75. It's for him and for the judges.
Thank you. Yep.
And what is it that I've just handed you, Mr. Smith?
A copy of my resume or CV.
And if you don't mind starting with your education, can you describe your educational background for us?
My undergraduate work was at Franklin and Marshall College. That's in Lancaster, Pennsylvania. From there, I have a master's degree in finance from Loyola College. I then went to Vanderbilt University in their PhD program for economics. I passed all the qualifying exams and even my first defense, but honestly, I just at the time, I decided that I didn't really want to go into academia. I kind of wanted to be in the field, if you will. And so I began my work as a statistician for Meharry Medical College, which is related to Fisk up in Nashville here. And then I went to TennCare, the Medicaid program. And I ran their informatics team for years.
You ran there.
It's called informatics team, but it was like an analytics team, really, right? We had a, go ahead.
I'm sorry, yeah, I'm having a hard time here. You said it was like a what?
So it was technically called the Office of Informatics, okay? But what I'm trying to describe is we did a lot of analysis. And then informatics has kind of transitioned a little bit more IT. I know I'm probably going off track here, so I'm so sorry. But I had two kind of major teams. One was kind of an IT team, and then so we had reporting packages, and then we did a bunch of analysis. And from there, just let me know if I should stop.
Go ahead.
Okay. I went to, I moved to Houston, and I worked for a payer representative. I mean, payer is a health insurer representative for 5 or 6 years. We did a lot of, which really was prior authorization, but it was working with medical teams and physicians and doing things like, in a statistical fashion, like pretest probabilities, trying to move people down the right pathways of care in a more timely fashion and kind of save money. That was one of the big things we did. And then I worked for a hospital and a payer before I returned here, and I've now been working for the state of Tennessee again for 2 years.
Okay. And in your role as the Director of Advanced Analytics and Visualizations, what exactly do you do?
I do, let me give you first of all, me and my team, we do an overdose surveillance. We do studies and research on the opioid, really the overdose crisis in Tennessee. For example, I'm currently working on a paper, I'm sorry. I'm currently working on a paper that evaluates a new overdose protocol that's been initiated in Erlanger Hospital in Chattanooga. It's a very kind of cool study. So we have a hospital that has this overdose protocol implemented. There happens to be 3 hospitals in Chattanooga. So one has the protocol, the other 2 don't. So we have a nice kind of case control type study. Then I'm going to do a multivariate logistic regression. I'm going to control for factors such as race, age, sex, insurance status, and then hopefully to isolate the benefit, that specific benefit of that protocol, right? Because that's the only thing that's really different.
And how much of your professional career has involved statistical analysis like
Over
the one
20
you
years.
just-
Yeah, I'm well over 20 years.
Okay. I know we talked about this a little bit before you testified. I think what might make today easier, just let me get the whole question out.
Yes, sir.
I know you're a little bit nervous, and we talked about that, and it's going to be okay. We'll be done soon. I know it's the spotlight, and it's tough.
This is the first time I've ever done that.
Yes.
Yeah.
So you were saying you've been doing some form of statistical analysis for about 20 years.
Over 20 years.
Okay. And you mentioned just now, I think you mentioned using a regression analysis in your
Yes.
current project with
Yes. Yep.
Chattanooga. Describe to me exactly what it is the regression analysis is, what it seeks to identify now.
Generally speaking, regression analysis is there's a outcome or dependent variable. Let's call it an outcome. It's probably more translatable. And then on the other side, there are independent variables, right? Or explanatory variables. And there's a relationship between that. The explanatory a change in the explanatory causes a change in the outcome. That's the most common interpretation, right? There's a causation. There's a direction, here. And so in the case of that example that I just discussed, the causation, right, is the protocol versus not having the protocol. And how do the outcomes change? The outcomes are, again, reduction in overdose deaths, non-fatal overdoses, and actually there's a third one we use where we're talking about increasing in linkage to care. That's use of buprenorphine, which is a treatment for overdoses. So again, there's a independent side, explanatory. There's a dependent side, which is going to be the outcomes, right? And you want to have these cofactors or these confounders and controls so that you can isolate or quantify in a meaningful way the relationship between that independent side and the dependent side. In short, if one independent variable changes some percentage, for instance, how does the outcome change? What percentage does it change? Right? And so in my regressions, I'll generally use age, race, gender, and in case of this particular one, we use insurance status because it's a barrier to care.
I'm sorry, you use what?
Insurance status, that's a barrier to care.
Okay.
Right? You may not go to the hospital. You may not seek treatment, which is a bad thing.
And if you were ballparking, about how many statistical analyses have you done in your
I personally have
20
done hundreds of substantial analysis. My teams have done thousands, right? Now, I don't necessarily review everyone, but I'm talking thousands, right? We have standards of practice. We understand what we're doing, and we have my analysis been submitted to courts. My analysis are used to allocate resources and direct care.
And in a typical statistical analysis, what sort of methodologies from the gathering data to actually producing the analysis do you go
Well,
through?
you're going to generally want to obviously identify the data that you're interested in, which, first you have a kind of a model and a construct. Then you identify the data, you import it, you clean it, you create categorizations or groupings or metrics, right? And then you're going to, if you want to go to regression, so that's kind of this descriptive piece first, right? That's kind of the initial piece where I'm going to do means and averages and proportions and all that stuff, right? So you can kind of start seeing the relationships, but that's the first step, right? If you want to then actually truly, in a statistically substantial way, understand the relationship, you're going to have to do a regression most likely, right? And that's the part where that's the next step, right? You want to understand, well, I'll stop there.
Okay. I guess I could ask more, but before I do, I'd like to offer up Mr. Smith as an expert in statistical analysis and data analytics.
And did you say data analysis?
Data analytics, yes.
Oh,
Your
data, I'm sorry. Any objection?
No objection, Your Honor.
Okay.
Thank
Is it Dr. Smith? Yes, Dr. Smith.
Not technically, ma'am. I just have, I did everything but my dissertation.
Okay.
Yeah.
All right, Mr. Smith, you've been designated or tenured as an expert in statistical analysis and data analytics.
Okay, thank you.
All right, you're welcome.
And I'd like to go ahead and hand the witness two things. One is his report in this case, and the other is the report of Dr. Baumgartner. And as background, he was offered as a rebuttal expert. Dr. Baumgartner's report is already in evidence. I did bring copies because I wasn't sure if everyone would have paper with them. So if I could go ahead and hand those up.
Okay. Did you want to mark the,
The CV, yeah, I'd like to move it into admission.
any objection?
76.
No? Okay. Exhibit 75, I believe.
75, okay.
Okay. We just moved it just now.
75.
75.
The CV was 75.
And so I think the CV was 75, yeah. The report's being handed up now.
Yes, the CV is 75. Do you have a copy of the CV? Because I had two copies. Okay.
Excuse me.
Go ahead and give you that just in case you need it for reference.
Oh, there's water?
Oh, yeah, okay.
And then the next thing I'll hand up, and this doesn't need to go to the court reporter, is Dr. Baumgartner's report, just for reference in case he asks us to look at pages.
Okay.
It's for the witness and the judges. Okay, I think that's trial exhibit 34.
All right, thank you.
What number?
34.
34. Thank you.
Y'all need any copies? I'm good. Mr. Smith, I'll be honest, I've promised some of my opposing counsel a 6-question direct, so I'm going to do my best to keep it to that. And so I'm going to ask you very generally, why were you retained in this matter? For what purpose?
To review Dr. Baumgartner's report for accuracy and methodology, and also to examine some patterns.
Okay, and I want to divide what will be the next 3 questions into 3 categories. We're going to start with what you agreed with.
Okay.
We're going to move to what you disagreed with, and then we're going to move to what you may have done differently.
Okay.
And so let's just generally start. What about Dr. Baumgartner's report did you agree with?
Well, I agree. Again, when generally speaking, the process with which he cleaned the data, we had a very similar approach. The actual numbers, the raw numbers, the levels, The levels even by race and the levels by category, which the ones and the two, the permanently disenfranchised versus the category ones. And therefore, the rates were the same. Well, originally, there was a difference. I'm not sure. I think he had a,
We'll come back to that.
okay, sorry. But the rates, in his corrected version, the rates and the rate ratios.
Okay, and you referred to raw numbers.
The
What-
300, oh,
What raw numbers are you talking about?
the 322,000 and the 12,600.
What's the 322,000?
The category one and the category two, respectively.
All right, and this may be a little bit of the nerve, so we're going to slow down a second. 322,000 what?
Convicted felons.
Okay, and the category two, what was that?
Category two would be those subject to the permanent disenfranchisement.
And about-
Subset of convicted felons subject to the permanent disenfranchisement.
And about how many of those were there?
It was 12,600.
Okay. And from that, Dr. Baumgartner produced several ratios and rates, is that right?
Yeah,
Okay. And you have both your report and his report in front of you.
I do.
Can you quickly summarize kind of what those ratios and rates were?
Yeah, so for, I'm going to use my report. Is that all right?
Sure.
Okay. Again, for category one, again, there was 322,248. 61% were white, that's 195,000. 36 were black, that was 116,000. There were
I'm
some,
sorry, wait a minute, could you slow down just a little bit?
yes, ma'am,
Okay, all right, could you please repeat that? You said 61% were
were white,
Okay,
and this is category one. And
Yes,
then
sir.
116.9, so let's say 117, or 36% were black. And then 8,400 were Hispanic, and 1,478 were other.
okay. All right, thank you.
Okay. And so you had no issue with any of the raw numbers that Dr. Baumgartner used in his report?
No, I would describe it as a distinction, not a meaningful difference.
Okay. Now, let's get to the next thing. What do you disagree with about Dr. Baumgartner's report?
Well, again, I don't disagree with the raw numbers, but I do disagree with, I think it's standard practice, best practice to discuss limitations of your study. For example, I do in my report. I talk about the metric and what its limitations are. I talk about the limitations of the study, what I'm going to do, what I'm not going to do. And I don't, and the first limitation that Dr. Baumgartner does not describe is, in my opinion, that needs to be described, is that causality piece, right? We're doing a descriptive statistic, and we're saying there's a disparity. And then I just want to make sure it's clear, that's not any statistical valid approach where, excuse me, this independent variable, this race, caused the disparity, okay? And I just want to be clear about that.
Okay, so what I'm going to ask you to do from here on in is, you've been speaking in generalities, talking about causalities or independent variables, dependent variables. I want us to use the concrete variables. Like, what are we actually talking about here? I think you were saying that Dr. Baumgartner's report speaks to some things but not others. What are you saying the limitation is? What does it not speak to?
The limitation is specifically that there's no implication of causality here between race itself and the outcome or the disparity in the rates, the difference in the rates. You would need to
Sorry,
do,
I'm having a hard time hearing.
sorry, let me repeat this.
Okay, that's okay. Hang on 2 seconds. Yeah, we're having a hard time here. We'll just wait.
Can the volume be turned up? For both, especially the witness.
I think Mr. Smith.
Sorry, my voice is not the
Oh, that's
strongest.
okay. Are you okay? Is
Yeah.
that mic comfortable for you? Does it need to be a little bit higher?
I don't know where the best way to put this is.
Okay. Okay.
Okay. Again, maybe I'll just lean into it. Let me do that. Okay. All right.
Okay, so,
Could you repeat your last question, please?
yes, Your Honor. I was saying how you've been speaking in generalities. You've used the word rate without saying rate of what. You've used the word ratio without saying ratio of what.
Oh,
And so what I'd like is, if you could, tell me what the limitations with specificity to Dr. Baumgartner's report are.
Yeah, again, the rate ratio used by Dr. Baumgartner is a prevalent ratio. It's a prevalent ratio between whites and blacks in terms of felony convictions in the state of Tennessee that are still alive, right? And that had a conviction here in the state of Tennessee. That's a measure of association. It's a beginning, right? It's definitely a difference, it's a disparity. But there is no implication that the race itself was the determinant of that disparity. That's why you do regression analysis, right? You study the topic. You might want to look. Should I keep going? Yeah. Okay. You might want to examine other factors, right? Like, for example, and I'm sorry for not speaking up here, but for example, you could look at gender. And in fact, if you look at gender, the disparity's much greater for men versus females, right? For category 2, it's threefold larger than the same disparity for category 2 in black and white. So it's a much stronger association.
So let me see if we can't translate that a little bit. If a legislator was trying to exclude a specific group from voting, sorry, you good? All right. The data that you uncovered as between race and gender, which category of people is more excluded by the disenfranchisement laws?
Men.
So gender.
Say that again?
So gender would.
Yes, sex, gender.
Okay.
Yeah. Well, relative to females, I just want to be clear. Okay.
Sorry, I keep waiting for the objection. Good? Okay. Did Dr. Baumgartner, to your knowledge, track any variable other than race as it relates to disenfranchisement?
No.
And if you were doing the same study, trying to figure out which category was most excluded, what sorts of other criteria might you have used?
Well, I think I would try to use, certainly I would consider other variables like gender, like age, maybe some form of socioeconomic ton of status variables, right? And then if I really wanted to quantify it, I would put him in a regression simultaneously so we can literally calculate the point estimates in a statistically appropriate way.
And by only using one variable, did Dr. Baumgartner ensure one answer?
He only, yes, yeah, in this sense, he only studied one thing, so there was nothing else to study.
And in the data that Dr. Baumgartner received from the Tennessee Department of Corrections, in that data, were there any other variables he could have easily used?
Gender's there, right? Age is there. I don't remember the other ones, but I think those are the two prominent ones that I would think would be relevant.
And did you see anywhere in his report that he chose to include those other two variables?
No.
Did you see anywhere in his report in which he did any independent research to see about any other variables?
I don't believe so. I don't remember every footnote, to be honest, but not in the body. I didn't see it.
Okay. Any other disagreements or differences of opinion with Dr. Baumgartner's report?
I do want to make one point, maybe two, actually. Figure 4, we can just, is there a way to look at that, or maybe I can?
Everyone's got what you have in front of you in front of them.
We can go to page.
Yeah, you said figure 4 in your report or Dr. Baumgartner's?
Dr. Baumgartner.
Dr. Baumgartner.
I didn't use this. This is the figure 4. This piece right here.
If you
I
could,
don't, I'm going to be honest with you.
do you want him to use the microphone?
If you want me to, I will. I'm going to be honest with you, I don't think I would. Yeah.
Okay. So instead of figure 4, why don't you identify by page number of Dr. Baumgartner's
Page 13.
Okay. And tell me what you were going to refer us to on page 13.
And mine's in black and white, but in the original report, it's a red line here. It's the line that is what he describes as a regression line. And I just want to be clear. Again, I think it's incumbent upon statisticians to be transparent about its limitations and what things mean, because statistics can be a black box. They can be opaque sometimes. And in no way do I want you to conclude that is a regression line in the sense of, here's some explanatory variables, right? This is the outcome. That's not what this is. And I think in that sense, my concern is that could be misleading to maybe somebody who's not necessarily understands statistics in a meaningful way.
Okay, and so you would say, I think, to repeat, figure 4 is misleading, is that what you testified to?
Objection, Your Honor. Leading.
Sorry, what's the objection?
Leading.
She's right, it's leading. Sorry, withdraw. You found another, or did you find any other mistakes in Dr. Baumgartner's report?
Well, again, I do. When I first did his study, his rates were off. Right, I think he had the wrong population for the state of Tennessee. Now, that's conceptually, right, or that's a calculation. I think conceptually. I think the part about the voting piece, again, I think his area, that part of his report is, to me, incomplete, as I stated in the report. It's not sufficient, in my opinion, to say possible, right? We're talking about category 2, there's 12,000.
I'm going to interrupt you for 1 second, because I think in your head you're skipping a bunch of explanation steps. Tell the court exactly what part of his report you're talking about, what he says, and why you disagree.
Okay, so I don't, let me tell you a piece of this. This is a piece about the possible elections. It starts on page 18.
Right, and tell us what it is that Dr. Baumgartner says in that section that starts on page 18.
Okay. He concludes that the population levels of the disenfranchised population, the category 1, was sufficient to sway elections. And that part's, I think, certainly the theoretical possibility is true. The question is at least where my perspective comes from, is what's likely and what's probable. What really would happen. And I didn't find any election, and nor did he, where he demonstrated the election would have been changed.
Okay, and let me see if I can't put a finer point on this. I think at some point, Dr. Baumgartner identified some close elections decided by, I think one of them was decided by 1 vote. Mm-hmm. And then he identified that the population base voting in that election contained much more than 1 disenfranchised by virtue of conviction of a felony. And then he went from that to the conclusion that the disenfranchisement statutes likely swayed the election. What about that do you disagree with? And why?
I would disagree with that.
Objection, Your Honor. Leading.
Is it leading, Mr. Gila?
Your Honor, I think I asked a very open-ended question. What about that do you disagree with and why?
Why do you say it's leading, counsel?
Counsel testified on the record, Your Honor.
I'm sorry?
Counsel testified on the record, Your Honor. He went through a whole explanation and said, do you agree?
Okay, let's have you restate the question, please. Make sure we understand the question.
Yeah.
Thank you.
I'm sorry, Your Honor. And I think the question was, he identified several elections that were close. And I think one was so close as to have been decided by 1 vote. And then he identified that in those elections, the population base voting in it had more disenfranchised felons than the difference in margin. Okay. And from that, he concluded that, I think on the stand,
Sounds like it's leading to me. Is there a way that you can ask that without leading the witness through what Dr. Baumgartner said?
Your Honor, if the question is, how does he disagree, how can I ask him how he disagrees without saying what
You can
he's...
ask him that question, but you're giving him all the things that he needs to premise his answer on, as opposed to just asking him the question. You're leading him. So if you just ask that question, I think it would be proper.
How do you disagree with Dr. Baumgartner's take on the likelihood of elections being swayed in Tennessee by felon disenfranchisement?
Again, I think whether an election was decided by 1 or 100,000, you don't know yet, right? You're going to add people, right? There's some pool of new potential voters, that's what we're saying, right? That haven't voted already. We don't know if they qualify in that area, right? If it's a statewide, that's pretty obvious. But if it's a local, small election, what proportion of that 12,000 actually lived in that district? What proportion actually registered to vote on time, actually decided to vote, right, appropriately on election day or mail-in or whatever the way, right? And then maybe not most importantly, who'd they vote for, okay? And so that's a lot of ifs. And so I don't know how one can jump to the conclusion, even if election was decided by one vote, how that result would, how adding these disenfranchised would change that. Because some are going to vote for candidate A, the current winner, and some are going to vote for candidate B, the current loser, right? You have to have more vote for candidate B, at least, than candidate A in that pool. And we don't know how that pool would vote, in my opinion.
I exceeded 6 questions, but if your honors will allow, I'd like to consult with counsel for just 1 minute. I'm about close to
Yes,
done.
sir. Thank you.
I have no further questions.
Okay, did you want to move your, Mr. Smith's report in?
Yes, Your Honor, I'm sorry.
Any objection to Mr. Smith's report?
No objection, Your Honor.
Okay, we'll mark that as the next exhibit, 76. Okay. And tell us your name again, counsel, please.
Ratcheva, Your Honor. Yulia Ratcheva for the plaintiff.
I'm sorry, repeat it.
Yulia Ratcheva for the plaintiff. Ratcheva.
Okay, thank you.
Yeah.
You may proceed, Ms. Ratchlet.
Hi, Mr. Smith. As you just testified, your academic training and professional experience is in the field of public health, correct?
My education is economics and finance, and then I've worked in the healthcare field for over 20 years. Even as a statistician, it was at a medical college.
You have never held any professional positions in the field of political science, correct?
No,
You do not have a degree in political science, correct?
no,
In any of your professional roles, you have never performed statistical analysis regarding political science?
Since I'm not a political scientist, I'm not sure exactly where the bounds are, but I'm going to say no for the X exercise.
And in your professional roles, you have never performed statistical analysis regarding felony disenfranchisement?
That's correct.
And you've never performed statistical analysis in your professional roles regarding the criminal justice system?
That's correct.
And the same question regarding racial disparities in the criminal justice system?
In the criminal justice system, that's correct.
And the same question regarding elections?
That's correct.
And the same question regarding voter participation?
That's correct.
And you have never published anything regarding any of the topics that I just listed?
That's correct.
And you would not hold yourself out as an expert in any of the topics I just listed?
No, I'm going to be a statistician.
And other than defense counsel, you only consulted with one other person for your report who was an epidemiologist?
That's right. I had someone just check my work real quick.
I'm sorry, what was the answer?
Yes, ma'am. I had someone check my work. Yeah,
And that individual was an epidemiologist, is that correct?
that's right.
And you did not consult anyone with expertise in political science?
I did not.
And you didn't consult anyone who was an expert in felony disenfranchisement, criminal justice system, racial disparities in the criminal justice system, elections, or voter participation.
I did not.
And this case is the first time you've conducted research on any of those topics that I just listed.
That's correct.
Can we go to your report, please? Which was Exhibit
What,
76. Can you go to page 9, please?
Mine doesn't have numbers on it.
Table 2 is also on that page.
Okay.
And you used publicly available data from the Center for Disease Control
That's correct.
for your population estimates of Tennessee's population, is that correct?
Yes, ma'am.
And then I believe you testified you used the Tennessee Department of Corrections database provided by defendants for calculating felony convictions in Tennessee.
Yeah, it was. I was told it was the same data set that Dr. Baumgartner used.
And you performed data cleaning on the data set that you received from TDOC.
Yes, ma'am.
And I believe you already said that performing data cleaning is a standard part of doing statistical analysis.
Absolutely.
And just to confirm, you already testified that you and Dr. Baumgartner had similar numbers in terms of raw numbers for all the analysis that you conducted?
Yeah, I think any difference I would call a distinction, not a meaningful difference.
And you do not dispute that using the 2020 census for population data is a reasonable source for this type of data analysis?
Yeah, in the end, the result was, I would say, not material.
So again, page 9, table 2 shows that Black Tennesseans comprise just 16% of Tennessee's total population as of 2023, correct?
That's correct.
But among those disenfranchised due to felony convictions, over 36% are Black,
That's correct.
and 38% of those who are permanently disenfranchised due to felony convictions are Black.
Yeah, of the 12,000.
So the share of Black Tennesseans who are disenfranchised due to felony conviction is more than double their share of Tennessee's population
For which category?
for Category 1,
It's,
more than double.
yeah,
And the share of Black Tennesseans who are permanently disenfranchised, Category 2, due to felony conviction is also more than double Black individuals' share of the population of Tennessee.
yes.
If you'll turn to page 10 of your report. This table shows the disenfranchisement rate and disenfranchisement ratio of felony conviction by race for all felons in Tennessee and for felons who are permanently disenfranchised. And you calculate that 4.5 out of 100 Tennesseans have felony convictions.
That's correct.
And you also calculate that 10 out of 100 Black Tennesseans have a felony conviction.
Yeah, that are still alive, that, met all the criteria. That's right.
So 1 in every 10 Black Tennesseans is
Or-
is disenfranchised due to felony conviction.
Per 100, that's right. Or 10%, whatever's easier for you guys to.
So 1 in 10.
Yeah, that'd be it.
And looking at the ratio, you report that Black Tennesseans are disenfranchised at a rate 2.68 times higher than white Tennesseans.
Yes,
And you also report that Black Tennesseans with felonies are permanently disenfranchised at over 3 times the rate of white Tennesseans with felonies.
that's correct.
You calculated your disenfranchisement rates by race by taking the number of people convicted of a felony for each race group and dividing that by the total population for each race group in Tennessee,
right.
correct?
Yep.
Correct.
Yeah, I'm sorry. Yes.
For the numerator, felons per race group, You only included individuals in Tennessee who had been convicted of felonies in Tennessee state courts, correct?
That's correct. I was trying to replicate what Dr. Baumgartner did, which I believe that's what he did as well.
So you did not include individuals residing in Tennessee who were convicted of federal.
Definitely not.
And you did not include individuals residing in Tennessee who were convicted of felonies in other states.
That's correct.
But both of these groups are also disenfranchised under Tennessee law due to their felony convictions, correct?
I mean, again,
Your Honor. Sorry, they're talking.
Okay, I'm sorry.
I think that last question, I was going to object it. I think it calls for a legal conclusion from
Okay,
the
could you
expert.
state that last question again, please? I'm sorry, I didn't
Of course,
hear the
Your
last question.
I was just asking both of these groups, individuals residing in Tennessee with federal felonies and individuals residing in Tennessee who had out-of-state felony convictions, are both disenfranchised under Tennessee's disenfranchisement laws.
Repeat it one more time.
Sure.
Okay.
Both of the groups we just discussed,
Is that category 1 and 2? No.
it's individuals with federal felony
I'm
convictions.
sorry, it's what?
Individuals who have federal felony convictions,
Federal, okay.
and
Versus-
individuals who have felony convictions from a state other than Tennessee.
Okay, and what was the question?
Are both of these groups also disenfranchised under Tennessee's law due to these felony
All right,
convictions?
Mr. Hillary?
And, Your Honor, I think that just calls for a legal conclusion that statistics expert.
Is it outside the scope of his report, or when you say it calls for a legal conclusion, I'm a little bit,
It's both. He doesn't speak to that specific difference in his report, and she's asking him whether a law disenfranchises someone, and that's a legal conclusion.
okay, counsel?
Mr. Smith, is it your understanding that that is the case, that both of these groups are
Wait,
disenfranchised?
let's address the objection.
Oh, apologies.
Mr. Hilo says it calls for a conclusion, and it's outside the scope of his opinion,
Yes, his opinion doesn't discuss that distinction.
so it calls for a conclusion,
Calls for a legal
a
conclusion.
legal conclusion. Okay, what do you say to that, counsel? Calls for a legal conclusion.
Mr. Smith is here opining on felon disenfranchisement and the racial disparity in felon disenfranchisement, so I think it's a fair question based on the opinions in his report.
And why do you think it's a fair question based on his opinions?
Because he speaks to individuals who are disenfranchised in Tennessee.
All right, Mr. Hilo, response?
So, Your Honor, he was offered as a rebuttal expert and generally used the exact same numbers that the primary expert he's rebutting is. He did not state that he made any independent judgments on who can vote in Tennessee and who can't. He just received the same felon database and used the raw numbers. I don't think he's got the legal wherewithal to know what Tennessee statutes actually, how they operate and what they do.
And, well, I got an interruption, sorry, I lost a little, and I apologize for that because I lost my focus as you were questioning, so I'm still having a little bit of difficulty understanding the question. What are you exactly asking? Could you,
I'll restate the question, Your Honor.
okay, let's do it that way, I appreciate that. Okay, let's restate the question.
And just to back up a bit, if that is helpful.
Okay, thank you.
Mr. Smith, for when you were calculating disenfranchisement rates by race, for the numerator of your calculations, which is felons per race group, you only included individuals in Tennessee who have been convicted of felonies in Tennessee courts, correct?
That's correct.
And you did not include individuals residing in Tennessee, but who have federal felony convictions.
That's correct.
And you did not include individuals residing in Tennessee who have felony convictions from state courts other than Tennessee.
That's correct.
And are you aware of whether or not these individuals are also disenfranchised in Tennessee due to these felony convictions?
Sorry. I'm not aware.
If you assume that these individuals are disenfranchised in Tennessee due to these felony convictions, your numerator in your calculations would be an underestimate of the number of Tennesseans disenfranchised due to felony conviction per race group. Is that correct?
So, Your Honor, that's outside the scope of his report.
But it's within his expertise, though.
I 100% agree. It is within his expertise, but does that open the door for me to ask questions outside the scope of his report as well?
Well, he's your witness, so you're limited to what's in his report and what he disclosed, but I don't know that defense would be limited to that.
I've always,
I don't know that defense would be limited to, she's not taking the witness, so she's not limited to that. But if it's within his expertise, certainly the counsel can ask him questions about his report, his analysis.
I can move on, Your Honor.
So the court will overrule the objection.
thank you.
And so if the numerator were larger, then your calculation would be an underestimate. Is that correct?
Well, if we're adding people to the numerator, right, the rate would change. The rate ratio may go up, may go down, depending upon whether there are more whites versus blacks, and et cetera, you know. Right. I don't know which way the rate ratio would go. I do know the rates would increase. So I think is what you're asking me.
Thank you, Mr. Smith. Turning to page 11 of your report, table 4.
Yeah, okay.
Per your report, none of Tennessee's 95 counties have a disenfranchisement rate any greater than 9.21 out of 100 for white Tennesseans with felony convictions. Is that correct?
I'd have to look, I'm going to be honest with you, but is that okay?
Yeah, go ahead.
Yes, Lake County is the max.
And again, that was 9.21 out of 100.
Correct.
So for any given county in Tennessee, a maximum of 10 in 100 white Tennesseans are disenfranchised due to felony conviction.
Yes, but can I just make one statement? Again, when you start breaking this down by counties, I'm using the residents, I think, of their first felony. It's less reliable than, obviously, the statewide metric. Just want to point that out.
And you also report that the maximum rate of disenfranchisement for black Tennesseans is 25.46 out of 100. Is that correct? If you turn to page 14 of your report.
Yeah, is it on that page? Are you sure it's not 25, the Sullivan?
25.46.
Yes. Okay. I must have misheard you. Okay, I was looking for 24. I'm sorry. Yeah.
And this is for Sullivan County, is that correct?
Correct.
And are you aware that Sullivan County is the 10th most populous county out of Tennessee's 95 counties?
I didn't know the exact number.
So in the 10th most populous county, over 1 in 4 black people cannot vote due to felony conviction.
Objection, Your Honor. She's assuming a fact that he just testified he didn't know. She's testifying.
Okay, counsel?
Your Honor, I believe it's an acceptable leading question.
Well, you
For
lead.
cross-examination.
This is cross-examination, so what was the objection, counsel? Assuming a fact that he did not know?
She just asked him if he knew the population relative of Sullivan County. He said no, and now she's asking a follow-up question that assumes the population relative of Sullivan County. It's not in the record. He just testified he doesn't know.
Okay, counsel, what do you say?
I'll rephrase the question, Your Honor.
Okay.
Is Sullivan County one of the, to your understanding, one of the largest counties in Tennessee?
I'm going to be honest, I don't know off the top of my head. I mean, I certainly know the 5 or 6 big ones. I don't recall.
But based on the numbers that you calculated, in Sullivan County, over 1 in 4 black people cannot vote due to felony conviction, is that correct?
Yeah, to the extent the data accurately reflects, right? I just want to point out again, when you start breaking it down by county, right, there are going to be errors because I think it's where they're convicted, not necessarily where somebody resides. So I don't know, but for the sake of argument, it's 25. That's what it was. Sure. Per 100.
I'm sorry, I'm having a hard time hearing you. You said what now?
Again, the data is limiting. Just to be clear, right?
No, I'm just saying you said 25 and then you said something.
Per 100.
Sorry?
Per 100. So,
Per 100.
yes, ma'am.
Okay.
Yeah.
All right, thank
yeah.
you.
And 25 per 100 would be 1 in 4.
That's correct.
And then if we look at Coffee County, you report that 21.93 out of 100 black Tennesseans in that county have a felony conviction.
That's correct.
So over 1 in 5 black Tennesseans in that county are disenfranchised due to having a felony conviction.
Again, I'm going to say yes with the provisos that you understand that the county data can be a little off. Okay.
You are aware that there are multiple other counties in your table 4 where more than 1 in 5 black people are disenfranchised due to felony convictions, correct?
Yeah.
And I count 13 counties listed in table 4 where more than 1 in 5 black people are disenfranchised due to felony conviction. Does that sound correct to you?
Let me just, I have 85 out of 95 have a greater than 1. And your question was again?
That there are 13 counties listed in table 4 where more than 1 in 5 black people are disenfranchised.
I didn't count them, but I'd certainly be happy to count them for you and confirm that if you like. Yeah, okay, sure.
So that's 13 counties where
That's correct.
more than 1 in 5 black Tennesseans cannot vote due to felony
Again, some
conviction.
are small, but just the proviso that obviously the county data can be a little wonky, but yes, that's given the best what one can do with the data you had.
That's correct.
Yep.
And you report that in 85 of the 95 counties in Tennessee, black Tennesseans are disenfranchised at a higher rate than white Tennesseans relative to their respective shares of the population.
That's correct.
And you agree that the felony disenfranchisement law in Tennessee has a racially disparate impact on the black population of Tennessee with felony convictions as compared to the white population with felony convictions?
So, Your Honor, I have 2 objections here. One is relevance, and I've held this one for a while. This lawsuit's not about general felon disenfranchisement. We've said that over and over again. These general felon disenfranchisement questions just aren't relevant to what this court is going to decide. The second is words like disparate impact are legally loaded questions with legal definitions, and she's now asked him to opine about a legal definition, and he's only here as the statistician. So we'd object to both relevance and to calls for a legal conclusion.
Well, that goes to the heart of the case, does it not? I mean, we've been talking the whole trial about legal terms and what the legislature meant and what statutes meant and
what judges meant and opinions meant, so I'm a little bit confused about the second objection at this point. But in terms of the first, what do you say in terms of relevant? Is that question relevant?
Yes, Your Honor. Mr. Smith's report is about felon disenfranchisement, and
So he addresses felon disenfranchisement in general.
correct.
Mr. Miller?
He does. As a rebuttal expert, he took all of the information in Dr. Baumgartner's report and either confirmed it or found differences with it. But whether or not it's in his report doesn't make it relevant. Relevancy is a legal issue.
Did you just hear what you said?
Yes.
Okay. Overruled.
Thank you, Your Honor.
Overruled, counsel.
And I can repeat my question, Mr. Smith?
And, well, Your Honor, if I could address,
You just said, just because it's in his report doesn't make it relevant. Well, the report is in evidence now. So I'm a little bit confused about that argument. Why do you have an expert giving opinions and doing analysis if they're not relevant? So to argue it's not relevant
and
is kind of difficult.
if I may,
But I've already made my ruling, so
okay,
it's overruled.
I'll skip that. The
Okay.
second objection, Your Honor, point well.
Second objection is overruled as well, as to legal conclusion.
Yes, Your Honor.
All right, you may proceed.
All right, I will repeat my question, Mr. Smith. You agree that felony disenfranchisement law in Tennessee has a racially disparate impact on the black population of Tennessee with felony convictions as compared to the white population with felony convictions?
Again, I just want to be clear. There is no doubt on a statewide level that the felony conviction as a proportion of the group populations were higher for blacks than whites. Category 1 was 2.68, and in Category 2 was 3.
I'm sorry, counsel, I'm sorry, Mr. Smith, I could barely hear anything you said.
So let me, again, the ratios are 2.68, right, from a Category 1, and the other ratio is 3.0. And so, yes, I would say that. I don't know, we would, in stats, would call it an unadjusted ratio. So I don't know what you mean exactly by disparate impact, but from an unadjusted ratio standpoint, rate ratio, clearly it's 2.68 and 3.0 for Category 2.
And Mr. Smith, you were deposed in this case, is that correct?
Yes, ma'am.
And you were under oath when you were deposed.
That's correct.
Do you recall me asking the same question at deposition?
I don't.
I have here the deposition of Mr. Smith. Is it okay if I hand it to you?
Any objection, counsel?
I mean, to the extent it's being used for impeachment, no objection at all. We just want to be sure it's impeaching.
Yes.
Okay.
Thank you.
And can you turn to page 67 of your deposition, please?
Is it supposed to have writing in here already?
Sorry, that's mine, but.
Are you sure? Okay.
Yeah, just turn to page 67.
Okay, 67.
Yeah. All right, and
Okay.
starting at line 17, question. So you would agree that there is disparate impact on the black population in Tennessee with felony convictions? Answer, there's a different outcome which would imply that, yes.
Yeah,
Your Honor will object to hearsay. That's exactly what he just testified to.
Mr. Helo, what is the objection again? I'm sorry.
Hearsay. It's not being used for impeachment. His testimony just now was that the black population is affected at a greater rate than the white population. You can't just read his deposition to bolster that. It's got to impeach it.
Mr. Smith was giving a different answer, which was not the same answer that he was giving in deposition, Your Honor.
I thought it was direct impeachment, but counsel can read it again. Maybe I didn't understand it.
I think his answer on direct was that the black population is disproportionately affected at a higher rate. This isn't
His
an
answer on what?
was that the black population is disproportionately affected at a higher rate than the white population. That was his answer on direct. This isn't impeachment. This is his deposition testimony saying that.
No, counsel, because, let me just try to explain this best I can. The question had to do with disparate impact. And the witness said that he did not give an opinion about that. That's what he testified to on cross-examination. It was about regarding disparate impact. So the portion of the deposition that was just read asked that question, and he answered yes. So
I'm sorry.
what am I misunderstanding?
I must have misheard. I thought he directly answered that there was.
Try to stand up and change the testimony, and that's just not proper.
My apologies, Your Honor.
You can put that aside, Mr. Smith.
Can I read, should I read this?
You can put
What
it
I
aside.
answered? Okay,
No.
put this aside.
Thank you.
Matter of fact, let's go ahead and have the court reporter. Can you read the testimony? Let's go back. Because I don't want there to be any confusion about what the question was, what the witness answered, and then what the testimony was in the deposition. It's not what Mr. Hilo said. And I just want everyone to be clear on that. So let's go back to the first time that you hear the word disparate impact in the question. Okay.
You agree that felony disenfranchisement law in Tennessee has a racially disparate impact on the black population of Tennessee with felony convictions as compared to the white population with felony convictions.
All right, stop it there. So his answer was, I don't know about disparate impact. And then in the deposition, he was asked specifically that question. So today he testified that he did not know about disparate impact. He did not answer the question. In deposition, when it was asked directly to him, he gave an explanation. Then he said, yes. Let's play it. Continue to play it. So that is a proper impeachment.
I understand, Your Honor, and my apologies. I was focused on what he said after the but, what
Well,
comes next.
but-
And
No, you don't have to apologize. It's just that I just have a hard time keeping up with some of your objections. Play it back, play it back. And can you play continue playing it so we can hear the next question. Okay.
Do you recall me asking the same question in deposition?
Okay. All right, let's proceed on.
Mr. Smith, you can set that aside. Mr. Smith, you agree that a law can be racially neutral, but have a disparate impact on outcome for different groups of people, correct?
I believe so, yeah.
Objection. Outside the scope of his report, he says he has no political science experience. He said he's never opined about anything legal. His report doesn't speak to this at all. His report doesn't use racially neutral, doesn't use facially not neutral. He's just not qualified to testify to any of this.
Okay.
Mr. Smith was also previously asked this question at deposition, Your Honor, and gave a response at that time.
Okay, can you show the court questions so I can make a decision on the objection? Can you show us the part of the deposition?
Of course.
Was there an objection during the deposition to that question, counsel?
I don't believe so, Your Honor.
Okay, can you pass that forward, please?
That'll be page 68, 69.
Do you have the extra copies? Okay, what page and what line?
It'll be page 68, line 21. Question: so given the conversation we were having, you agree that a law can be racially neutral but have a disparate impact on a certain group? Answer: yeah, it can have a different outcome, or results might be a better way to say it. Question: different results for different groups of people? Answer: that's right.
Okay, the objection is overruled. You may ask the question to the witness.
Yeah, you can have different results and outcomes. For sure.
I'll restate the question, and
Okay.
then you can answer just for the record, Mr. Smith. So you agree a law can be racially neutral but have a disparate impact on outcome for different groups of people?
Yes. Excuse me.
And Mr. Smith, on the other deposition testimony that I read to you about disparate impact, that was truthful testimony at the time you gave it. Is that correct?
I mean, there's a couple questions here that were about that, and just want to be clear. I said I think so. I think if a disparate impact means a difference in outcomes, then yeah, right? So I just...
Mr. Smith, was your testimony truthful at that time?
I believe so, yeah.
All right. All right, we can move on. If you'll turn to table 3 of your report, Mr. Smith.
I'm there.
You calculate for category 2 that Black Tennesseans are permanently disenfranchised at 3.01 times the rate of white Tennesseans, correct?
Yes.
And you did not provide any calculations for permanent disenfranchisement rates by race, by county in your report?
I did not.
And you did not provide any additional opinions regarding permanent disenfranchisement rates by race in your report?
I did not.
And if you'll turn to page 20 of your report.
Can you tell me the table? Because I don't have numbers
Sorry.
on
This
mine.
is the section titled Possible Impact on Elections.
Okay. Okay, I'm there.
You have never statistically analyzed the racial impact of election laws before this case, correct?
That's correct.
And you've never before done any work estimating voter participation?
No.
And you've never before analyzed voting patterns in the United States?
No.
Never before analyzed voting patterns in Tennessee?
No.
And you've never before analyzed voter patterns of individuals with felony convictions?
No.
You would agree you are not an expert in analyzing voter participation in elections?
I'm not an expert, no.
And you did not conduct any of your own empirical analysis to estimate how those disenfranchised due to felony conviction in Tennessee would have voted in the 2 elections you analyze on pages 22 and 23 of your
I mean, I contacted the BLS, and they gave me results, excuse me, of how people voted by candidate for the state of Tennessee, since, I think, from 64 to 2024. It was only statewide elections, so
But you did not conduct any of your own surveys of individuals?
I did not.
You use national percentages of voter participation by race to estimate how many felons in Tennessee would have voted in those presidential elections if able to vote?
That was the only data available.
You
So
do not-
yes, I just want to be clear.
And you do not know whether national voter participation percentages by race are comparable to Tennessee percentages, correct?
I do not.
You did not talk to any political scientists when you were doing these estimates?
No.
You do not do any work to figure out voting patterns among formerly disenfranchised individuals compared to the national voting participation rates?
No.
There are state and local level elections in Tennessee that ended in tie votes. Are you aware of that?
I think I heard it here, so I don't know. Yeah. To that extent, yes, I am.
One vote, if those elections, excuse me, let me rephrase the question. In those elections, just one vote could change the outcome of those elections, correct?
Yes, provided, I think I mentioned all the ifs that had to happen, but yes, one vote could.
No more questions.
Okay.
Redirect?
No, Your Honor.
No questions? Okay. Mr. Smith, I have one question for you. I'm looking at exhibit number 75, which is your CV.
Yes, ma'am.
And the first entry says, Tennessee Department of Health, April 2024 through the current. Are you employed with the state? Or
Yes, ma'am. Still am.
You're an employee of the state?
I'm employee of the state of Tennessee Department of Health. Yep.
Okay. All right, thank you.
Yep.
Okay, thank you for your, spending the day with us today.
Oh, you're welcome.
All right, have a great day.
Sorry for the voice.
No, you're fine.
I'll take that back.
Okay, any other witnesses?
Okay? Your Honor, we rest.
Okay, all right, the defense rests. And,
I think by rule, we renew the Rule 41 motion that Your Honors held in abeyance. I assume that's what Your Honors did with it, and so I think appellate procedure requires.
Rule 41 after close of defendant's proof, that's not when you make that motion.
No, we made it at the close of plaintiffs.
It's under advisement.
Agreed, and I think appellate procedure requires we renew it at the close of our proof if it's taken under advisement, so we'd like to renew that motion.
Okay, well, we'll keep it under advisement for now.
I figured, thank you, Your Honor.
All right, anything else from defense?
No, Your Honor.
No? Okay. All right, let's take a recess. Have you all decided on rebuttal witnesses?
We have, Your Honor. We're not going to offer any rebuttal, and so I believe we can go straight to closing arguments.
Okay, well then, let's take about a 15-minute recess. It's only 2:49 to give you all time to get prepared. And then we're going to come back and we'll take the closing arguments. Now, before we recess though, since we're doing well on time, do you want to have time limits on the closings, or how do you all feel about that? We'll start with plaintiff's counsel.
We actually discussed this the other day. I think we both are of the opinion that our closings are not going to be particularly long, so I don't think we need time limits. I think this, I know I will be less than, I'm shooting for 20 minutes or less.
Okay. And from the defense, what do you think about it?
I will try, but I'm a much slower talker than Mr. Albright, so
Well,
I'll probably more longer, but,
okay,
yeah.
and I think that that's fine. I mean, it's only 2:50, so we come back about 5 after 3. So if you're thinking about 20, you're gonna go longer. You just take your time, present your case,
And-
and plaintiff as well.
And Your Honor, I had planned also to offer potentially a short rebuttal after defendant's argument.
Oh,
Is
yes, you
that-
get a final close, absolutely.
Thank you, Your Honor.
All right, very good. So let's take 15.
All right. What are we in recess?
all have had a chance to take a deep breath and get prepared for your closing arguments. And I want to remind, I didn't get a chance earlier to address this when we came out, but there are to be no pictures taken in the courtroom. If anyone has taken a picture or a photograph in the courtroom, that is improper. Do not post any pictures of us online or of any sort, because there's no photograph taking in the courtroom. Now, what's taken outside is different. But at after the last trial, there were some pictures that were taken in the courtroom that were posted. So if anyone has posted any pictures inside the courtroom during these proceedings, I'm going to ask that you remove those pictures off of social media or any other public forum. And if anyone has taken pictures today, please do not post the pictures. I think when the officer opened court, did you say, what's your normal statement? No recording. No recording, okay. Well, we need to add to that opening, no photos, because photos and recording are a little bit different, but the whole purpose is the same. Okay, so having said that, let's go ahead and take closing statements. You may proceed, Counsel.
Thank you. Thank you, Your Honor. Good afternoon, Your Honors. John Hoppenreich here on behalf of Plaintiff Pamela Moses. As the Tennessee Supreme Court noted in May versus Carlton, the right to vote, so precious to Tennesseans during the Reconstruction era, qualifies today as a fundamental liberty in a representative government. That fundamental liberty, the basis of our democracy, is at issue in this case. As you heard Ms. Moses testify during this trial, the right to vote means so much to her, and that's why she's been fighting for so long to get it back. Now, you've heard a substantial amount of evidence presented during our week of trial, so I'm going to try to briefly review during my closing statement 4 things. I'm going to briefly cover our claims and the relief that we're seeking, the evidence supporting those claims, defendants' principal counterarguments, and why those counterarguments fail. And at the end, I think you will find that the evidence overwhelmingly favors plaintiff's case, and we will ask for a ruling in our favor. So let's start with what our claims are. We have 3 claims. First is our free and equal elections claim. This claim is that the plain text of the Tennessee Constitution holds that permanent disenfranchisement is unconstitutional absent conviction by a jury. And those words, I know the court has heard a lot of times, by a jury is very important there. The relief that we're seeking here is just that, a declaration that Ms. Moses was unconstitutionally, permanently disenfranchised because she was not convicted by a jury. And that on a broader scale, this can amount to manipulation of the electorate under the Free and Equal Elections Clause. Our second claims are equal protection claims. These claims are that permanent disenfranchisement has both the intent and effect of discriminating against Black Tennesseans, including Ms. Moses. The relief that we're seeking here is a declaration that permanent disenfranchisement is unconstitutional, not only because it violates equal protection, but because the state has articulated no government interest in the massive and disproportionate permanent disenfranchisement of Black Tennesseans. Our third claims are substantive due process claims. These claims are that permanent disenfranchisement is a conscience-shocking practice that should be declared unconstitutional by this court. Because again, the state has articulated no government interest whatsoever supporting permanent disenfranchisement, particularly the categories of offenses that are deemed to be permanently disenfranchising versus non-permanently. No articulated government interest there. and because this entire permanent disenfranchisement system is being administered in an arbitrary and capricious manner. And the relief we're seeking there is a declaration that permanent disenfranchisement itself, as a whole, is unconstitutional pursuant to substantive due process. So as you can see from the way I've laid out the slide here, these three claims go to three different populations. The first claim, free and equal elections, looks at people, specifically Ms. Moses for the as-applied claim, who were not convicted by a jury. The second, the equal protection claims, those focus on Tennesseans who are both black and permanently disenfranchised. And the third category, substantive due process claims, those claims focus on all Tennesseans who have been permanently disenfranchised. So those are the claims. Let's talk a little bit about the evidence in support of those claims.
Okay, before you move that screen, were there, I just want to be clear because under both categories, you have it as applied and you have a facial claim.
Yes, Your Honor.
Were any of those, are they all still?
These are all still present in the case. I think,
Okay. No question.
Your Honor may be remembering the facial claim under free and equal elections. There was a facial claim as to conviction by a jury and how that could affect the free and equal elections claims. That facial claim as to the by a jury language, just the facial claim, was dismissed. There remains this claim that was outlined
As
in...
applied.
Yes, there remains the as-applied claim. There also remains this manipulation of the electorate claim that was outlined in the court's opinion on the motion to dismiss. So if you look at the court's order dismissing some of the other claims, that claim remains.
Okay. All right, that's what I wanted to be sure. Okay, thank you.
Yes, Your Honor. Starting with the Free and Equal Elections Clause, this claim can really be resolved purely on the basis of the text of the Constitution itself. And I want to focus on these two provisions. There are two provisions in the Tennessee Constitution that talk about disenfranchisement. The first provision, Article 4, Section 2, that was added to the Constitution in 1834, and we'll talk about Dr. Holloway's testimony in just a moment. That provision says that laws may be passed, excluding from the right of suffrage persons who are convicted of infamous crimes. So that's 1834, the first provision added permitting felony disenfranchisement. Later in 1870, Article 1, Section 5, which is what we're calling the Free and Equal Elections Clause, that was amended. It used to just say the election shall be free and equal. In 1870, the words after the comma were added. And that provision controls the case here. It says the election shall be free and equal, and the right of suffrage, as hereinafter declared, shall never be denied to any person entitled thereto, except upon conviction by a jury of some infamous crime previously ascertained and declared by law, and judgment thereon by a court of competent jurisdiction. We'll talk in just a moment about what all those words mean, but the focus of this case and the focus of the free and equal elections claims are that focus on the by a jury language. That was added 36 years after the original provision permitting felony disenfranchisement as a limitation. And we'll talk about the Supreme Court precedent that establishes that that is in fact a limitation on government power. So, Article 1, Section 5, the clause says what it says. Now, defendants' main argument on the constitutional textual analysis, their main argument is that you should just simply ignore the words by a jury. And that is what the argument comes down to. This court, however, cannot ignore those words. They are in the Constitution and they mean what they say. Just last year, the Tennessee Supreme Court in McNabb versus Harrison held, and I quote, "Courts should presume that every word the drafters used has a specific meaning and purpose." Every word, not some words. The court went on, "Courts should avoid interpretations that render words inconsistent, meaningless, superfluous, or redundant." That is direct from the Tennessee Supreme Court just last year, and it clearly governs what's at issue here. The by a jury language in the Free and Equal Elections Clause, Article 1, Section 5, is clear and it's unequivocal, and it is supported not just by the dictionary definitions at the time, which Dr. Holloway covered in her report and the parties have briefed previously. It's not just a dictionary definition, but it is also supported by a clear and binding ruling from the Tennessee Supreme Court in the Gaskin case. Now, to remind the court, in the Gaskin case, the Tennessee Supreme Court looked at both of these provisions, and just like the Tennessee Supreme Court today says, it harmonized those two provisions. It determined how to read them together to make them make sense. And what that court ruled in Gaskin is that while in 1834, Article 4, Section 2 gave the state the power to disenfranchise, there were limits placed on that power in 1870 when Article 1, Section 5 was amended. In 1870, Article 4, Section 2, the original clause, that remained untouched. Says the same thing that it said in 1834, and in fact says the same thing today. 1870, the Free and Equal Election Clause was adopted specifically to sharply limit the authority that had been previously granted. Now, the limitations on that disenfranchisement authority operate in at least three ways. One, if you read the text, people cannot be disenfranchised unless they are convicted by a jury, which is what it says. People can't be disenfranchised unless the crime was declared in advance. That's what that language means. It means you can't retroactively disenfranchise. And three, you have to have a judgment entered on the conviction by a court of competent jurisdiction. That's that last part. So all three of those things have to be true in order for someone to be disenfranchised pursuant to the general authority from the 1834 provision. And so here's that language from Gaskin. This is the Tennessee Supreme Court interpreting these provisions. And looking at these two provisions, the court said the legislature is empowered to deprive convicted criminals of the right to vote under the limitations set out in Article 1, Section 5 and Article 4, Section 2. So that power that is granted the state is limited by this later provision. That's what the Tennessee Supreme Court has already said. The court went on to explain grammatically how the clauses in the Free and Equal Election Clause modify the words infamous crimes. It qualifies them. It places a time limitation on them. And I'll note specifically that the Tennessee Supreme Court in this case specifically quoted the conviction of a crime by a jury. That language is directly quoted out of the Free and Equal Elections Clause. So that is Gaskin. That is binding Supreme Court precedent. These two provisions, 1834 and 1870, have already been read together. The Tennessee Supreme Court has already interpreted them together and has already held that the Free and Equal Election Clause is a limit on state power, and it is a limit on the state's ability to disenfranchise without meeting the specific conditions in that clause. So that's the text. It is only if this court finds that text ambiguous that the court then moves on to the historical evidence. But even in that case, the court moves on to the historical evidence. That evidence is overwhelmingly in favor of the plaintiff. Now, you heard testimony, extensive testimony from Dr. Holloway, and you just heard testimony a little earlier today that the defendant's expert agrees that Dr. Holloway is one of the most preeminent historians in felony disenfranchisement. He approvingly agreed with, I would say, the vast majority of her opinions, particularly around this subject, 1870. He cited her book in an earlier expert report in Alabama. He agreed with her conclusions in this case. And what Dr. Holloway says is that the text of the Free and Equal Elections Clause was adopted specifically to counter the ongoing disenfranchisement of former Confederates and the subsequent manipulation of the electorate. If the court recalls, Dr. Holloway testified extensively about loyalty oaths,
I'm sorry, you said to counter,
the disenfranchisement of former Confederates, and the ongoing manipulation of the electorate because of that disenfranchisement. Because Dr. Holloway talked extensively about the loyalty oaths, these three excerpts are from newspapers prior to the adoption of the Free and Equal Elections Clause in 1870. We've got February of 1866 in the Daily Union out of Nashville, May 8th, 1866 from the Republican Banner out of Nashville, and then April 28th, 1866 in both the Daily Union from Nashville and the Daily Appeal from Memphis. And these are all cited in her report. These are all as a part of Trial Exhibit 1. These are all on pages 11 and 12, footnotes 42, 43, and 45 of her report. And what these excerpts show was, at the time, prior to 1870, the concern, the general public understanding and the general public concern with these loyalty oaths was that they punished citizens by denying them the right to vote without the involvement of a jury. This first excerpt on the upper left-hand corner, the Loyalty Oaths Bill, punishes and deprives the citizen of his rights and liberties without presentment or indictment and without the right of trial by jury. From April 28, 1866, in both Memphis and Nashville, the bill under consideration abrogates entirely the right of trial by jury and the sacred right of criminals to be heard before a constitutional tribunal.
can you blow that up a little bit, please?
I'm not sure that I can without breaking the presentation, Your Honor, but
Okay, that's okay.
I apologize. But these are in Dr. Holloway's report. They're quoted in full in her report. And similarly,
Do you remember what exhibit that is?
it's Exhibit 1, Your Honor. Exhibit 1, and these are all from pages 11 and 12, and they're footnoted 42, 43, and 45. Similarly, and I'll not linger on this, there are other references to people understanding that these loyalty oaths were violations of the Constitution, and I'm reading from the upper right-hand corner, violations of our Constitution which secures to me the right of trial by jury in open court. The concern here is that Tennesseans were being judged and found infamous and losing their right to vote, but not by a jury of their peers. Dr. Holloway testified extensively about this, and she also noted that no other state constitution has this by a jury language that we have in our Free and Equal Elections Clause. Tennessee is unique. Dr. Holloway also testified that there is no dispute, and in fact, you heard testimony from defense expert earlier, there's no dispute that guilty pleas existed prior to, during, and after the 1870 Constitutional Convention. Dr. Holloway has offered uncontroverted testimony that the delegates to the 1870 Constitutional Convention who wrote and adopted the Free and Equal Election Clause amendment, those delegates would have been aware of guilty pleas before a judge, and they knew what by a jury meant. So, in addition to just a plain reading of the constitutional provisions, which is what our Supreme Court cases counsel us should just adopt and go by the plain language, but in addition to just the plain language, the historical evidence unequivocally supports that by a jury in the Free and Equal Election Clause means what it says, and it was adopted intentionally with that understanding in mind. Aside from the by a jury language in the 1870 Constitutional Convention, Dr. Holloway also testified extensively about the historical impact that felony disenfranchisement laws had on black Tennesseans and black political power in Tennessee. Her testimony established that as a result of felony disenfranchisement and other similar laws, black voting plummeted in the late 19th and early 20th centuries. She testified to the historical consensus that these laws, specifically including felony disenfranchisement, were intentionally targeted to prevent black Tennesseans from voting. And you heard much of the same thing from the defendant's expert today. He agreed on the stand that racist and white supremacist Tennesseans, including political officials, elected officials, would do whatever they could to make sure that black Tennesseans could not vote, and that included felony disenfranchisement. That was testimony from just earlier today. Now, that's the historical evidence, but we have more than just historical evidence supporting our equal protection claims. We also have evidence from Dr. Baumgartner. Dr. Baumgartner testified to the overwhelming impact of permanent felony disenfranchisement to black Tennesseans. As you can see here, and this is figure 3, this is from Dr. Baumgartner's report, which is Trial Exhibit 34. This is figure 3 at page 11 of that report. The middle category, category 2, is permanent disenfranchisement. And you can see with your naked eye that there is a massive difference in the impact on white Tennesseans versus black Tennesseans. White Tennesseans are actually substantially underrepresented in terms of a percentage of those who are permanently disenfranchised. That 0.76 shows that they are below the 1 level. The 1 level would be equal representation by race. So white citizens are substantially underrepresented in terms of those who are permanently disenfranchised, while black citizens, as you can see, are massively overrepresented in terms of those who are permanently disenfranchised in Tennessee. So how does this comparison play out? Dr. Baumgartner testified that black Tennesseans are permanently disenfranchised at a rate of 3.2 times that of white Tennesseans. And when you take that 3.2 number, that works out to a 220% difference. I want you to take a moment to reflect on that. Black Tennesseans are 220% more likely than white Tennesseans to be permanently disenfranchised. That is the uncontroverted testimony of Dr. Baumgartner in this case. That is an astounding number. Taken together with the historical evidence from Dr. Holloway, that is more than enough to find an equal protection violation in this case. Now, the court may remember from back in January, there was some suggestion, I believe argument from counsel, that Dr. Baumgartner somehow compared the wrong groups, that his analysis wasn't comparing the right subgroups. Dr. Baumgartner answered those concerns during cross-examination, and that testimony is in the record. And frankly, that is just incorrect as a matter of statistics. But more importantly, defendants have had no witness testify to that argument. Defendants had an expert witness who was qualified on the stand today, had an opportunity to do a report, and that expert witness, you heard from him earlier today, did not address that argument at all. It is nowhere in the record. It's not in his report, it's not in his testimony, and as a result, there is no evidence of this subgroup analysis that I think the court may recall from last time. And so given that it's not part of the record, that is not a valid defense to Dr. Baumgartner's analysis. And I'll just note for a moment that even if that argument had been taken, it had been presented in evidence, which it wasn't, it doesn't undermine the claims in this case. It's very clear that the impact on black Tennesseans is substantially greater than the impact on white Tennesseans. You heard defense expert witness talk about the raw numbers today. The raw numbers, the numbers are what they are. The impact is what it is. And we think that impact and the testimony of Dr. Baumgartner clearly establishes a violation of equal protection in this case. So that's equal protection. Our last claims are substantive due process. You heard substantial evidence from Coordinator Goins on the stand about what we would submit as an arbitrary way that permanent disenfranchisement works in Tennessee. There is no reason why certain crimes, such as perjury, or evading arrest, or money laundering, or kidnapping, none of those crimes result in permanent disenfranchisement. And yet, things like impeding the movement of the highway patrol, or making a false report, or tampering with evidence, those are permanently disenfranchising. That's a lifelong loss of your fundamental liberties, to quote May. There is no reason. And more importantly, for this case, defendants and the state has articulated no government interest in support of the difference between these two categories. The one thing that we do know from Dr. Baumgartner's analysis, however, is that the list of crimes chosen for permanent disenfranchisement impacts black Tennesseans much more heavily than white Tennesseans. That's just a function of the numbers. So however those list of crimes were created, and there's no evidence as to a reason why or an interest in it, we know what the impact is, and that is to massively and disproportionately impact black Tennesseans. Lastly, on both this substantive due process claim and also the manipulation of the electorate claim, you may recall Mr. Goins testifying that every vote counts. That was in his declaration in another case. We admitted that declaration as an exhibit to this case. And I walked him through a number of close elections that he himself had identified. And he admitted on the stand that the results of permanent disenfranchisement, given that there are a number of elections that were either tied or decided by a single vote or a handful of votes, he admitted on the stand that if permanent disenfranchisement were overturned or it had been unconstitutional in the first place, that could have affected those elections. We have the secret ballot in Tennessee. There's no way to know and go back and reconstruct those elections absent interviewing every Tennessean. But his testimony on the stand was that every vote counts, every vote is important, and that this system could well have impacted the results of some of those elections. Now, I've mentioned several times that the state has offered no evidence of government interest. And why is that? It is because the practice of permanent disenfranchisement in Tennessee, particularly given the plain text of the Constitution and the overwhelmingly disproportionate impact on black Tennesseans, that practice is plainly unconstitutional. We think the evidence is overwhelming. And so, what you've heard from the state during this case is not arguments on the merits. What you hear is largely procedural matters. And I anticipate you're going to hear defense counsel cover some of these defenses and counter-arguments in just a moment, but I want to give the court a little bit of a preview about why these counter-arguments are incorrect. So the first counter-argument the state has raised several times prior to trial and at trial is a standing argument. Now, the version of the standing argument that the court heard during trial is a little bit different. It's not an argument that we've heard in briefing before or in the lead-up to trial, but boiled down, the argument is that the coordinator of elections is really just an advisor. He has no real role to play here. That's just simply not a credible argument. As we covered during Mr. Goins' extensive testimony, he is the top election official in this state. He is statutorily charged with authoritatively interpreting the election laws, and he testified, consistent with the statutes, that he is in charge of setting policy and procedures for election commissions across the state. And we've brought this up in briefing previously, and in post-trial briefing we will highlight it again, but I'll note for the record that twice in the past, Coordinator Goins has been a defendant in a voting case that has gone up to the Supreme Court. Twice, Coordinator Goins has raised standing as a defense, and twice, the Supreme Court has denied that defense and found that he was a proper defendant. We are covering old territory here. He is the top election official in the state. He is undoubtedly the right defendant in this case. More specifically, how do we know that Mr. Goins is the correct defendant? Well, three particular reasons. One, Mr. Goins was the one that sent the letter in 2019 causing Mrs. Moses's voter registration to be denied. He sent the letter. Two, by statute, which we'll look at in just a moment, it is Coordinator Goins who has the final say as to whether a person who has a felony conviction, when they are trying to register to vote, he has the final say by statute as to whether or not that person is eligible to register. And third, we know from the past, and we'll talk about this example in a moment, that when Mr. Goins is confronted with a court order saying, you must allow this person to register to vote, we know what he does because he's done it before. He writes a letter to the local election commission saying, I disagree with this court decision, but nonetheless, register this person and let them vote. And we'll talk about that example in just a moment. So going back to the first note, and I know this is small, this is Exhibit 64. On the left is an email that was part of that exhibit. And that email is attaching the letter on the right. And this is in 2019. Underlined on the left is attached, please find a denial letter for Pamela Janine Moses. The reason for denial is that Ms. Moses is permanently ineligible to vote due to her conviction. On the right is the letter that was attached to that email, conveying the signature of Coordinator Goins, and it says the reason for denial of restoration is that Ms. Moses was permanently ineligible to register to vote in Tennessee due to conviction, and then citing the permanent disenfranchisement statute. So we know in 2019, it was Coordinator Goins who caused Ms. Moses to not be able to vote. That's what this letter establishes. Let's look at the statute. The statute that I referenced here is Tennessee Code Annotated 22139, and this statute covers specifically what happens when a person who has been previously convicted of a felony wants to vote. Subsection B says, and I'm reading the underlined language here, before allowing a person convicted of an infamous crime to become a registered voter, it shall be the duty of the administrator in each county to verify with the state coordinator of elections that the person is eligible to register. So it is the duty of the administrator to check with Coordinator Goins before they register the person. Subsection C goes on to say, the state election coordinator, that's Mr. Goins, is empowered to formulate a uniform procedure for verifying the registration eligibility of any person convicted of an infamous crime, and upon receiving sufficient verification of such person's eligibility to register, the administrator shall allow such person to become a registered voter. This statutorily puts the responsibility with Coordinator Goins when a person who has a previous conviction for a felony wants to register to vote. He has the final say. The local elections administrator must check with him, and he has to approve that before that person can register to vote and vote. It is Coordinator Goins, not the local election commission, that must verify that the person is eligible to register. And the local election commission clearly has to go by what Coordinator Goins says, not the other way around. Finally, we know from past example, and this is my reference earlier to Coordinator Goins writing a letter, this was a specific instance. Back in 2024, a citizen obtained a court order saying that she could register to vote, despite Coordinator Goins' interpretation of the law that said she couldn't. He received that court order, and though he disagreed with it, he sent a letter to the election commission telling them to register the person to vote and to let that person vote. And the letter is Trial Exhibit 66. This is Coordinator Goins' testimony. In the underlined portion, I asked him, in your letter, you're saying, register this person. But if something else happens in the litigation, I may update you. He says, right, and tell you to purge this person. Is that right? And he says, that's correct. So we know what happens when a court, like this court, puts down an order saying a person is eligible to vote. Coordinator Goins takes that order, writes a letter to the election commission and says, okay, I may not agree with this order, but the order is what it is, register this person. And that's consistent with his statutory obligation that we just looked at. He is the one that makes the final decision as to whether a person is eligible to register. So at a high level, those three reasons are why defendant's standing arguments really hold no water in this case. In 2019, Coordinator Goins caused Ms. Moses injury by instructing that she couldn't register to vote because she was permanently disenfranchised. And that's consistent with the statute. Ms. Goins caused Ms. Moses injury by saying she wasn't eligible. He can fix her injury by telling the Election Commission, pursuant to statute, that she is now eligible, just like he's done with others before. And that is the relief we're seeking. A court order telling Coordinator Goins, this person is eligible to register to vote, make it happen. That's the relief that we're seeking as to the as-applied claim to Ms. Moses. So that's standing. Defendant's second counterargument is that we've challenged the wrong statute. And this is fairly quickly taken care of. Let's look at the specific statute at issue. This is Tennessee Code Annotated 4029-102. This is formally, so last year when the changes were made, this was moved over a section, largely left intact. This is formally 4029-204. And this section says the following persons shall never be eligible to have the right of suffrage restored and vote in this state. This is the permanent disenfranchisement statute. Nowhere else in the Tennessee Code is permanent disenfranchisement mentioned. And importantly, I want the court to understand this is not a multi-step process. It's not as if someone is disenfranchised and then something else has to happen and then they're permanently disenfranchised. This statute operates automatically and immediately. If a person is convicted of any of the crimes listed in subsection B3, then they are automatically and immediately permanently disenfranchised. Under this statute, as we sit here today, Ms. Moses is permanently denied her right to vote in this state. Her voting rights are forever gone unless it is found to be unconstitutional. And I know there has been some discussion in front of the court in briefing and also when we were here in January about the other statute, 112, which has to do with the initial finding of infamy when someone is convicted. But I want the court to think of it this way. If instead Ms. Moses had challenged 112, which is that initial finding of infamy, that automatic finding, and she hadn't challenged this statute, even if she had been successful challenging 112, that other statute, by its very plain text, this statute would still apply to her and she would still be permanently disenfranchised. Only by challenging this statute, 4029-102, only by challenging this statute can she get full relief from her permanent disenfranchisement. And we know, again, for another reason why this is the correct statute. It's because it's the statute that was cited in both the email and Coordinator Goins' letter in 2019 that we just looked at. I know it's really small, but I'll tell the court, both the email references Tennessee Code Annotated 4029-204-3B, which is the former section for this permanently disenfranchising offense, and the letter does as well. It says, permanently ineligible to register to vote in Tennessee due to conviction, see Tennessee Code Annotated 4029-204. This statute that we're looking at, that is the statute that was cited by Coordinator Goins in his letter when Ms. Moses tried to register to vote. So we know it is the correct statute to challenge for a variety of reasons, by its plain text and also by the fact that Coordinator Goins pointed it out himself. So in 2019, this statute is the one that's identified. In 2019, Coordinator Goins is the one that made the decision. But now that we're at trial, now he is saying that he has nothing to do with it, and this statute has nothing to do with it. That's just wrong as a matter of law, and it's contradicted by his own testimony. This is the correct statute. This is the permanent disenfranchisement statute. It's the correct statute to challenge. It is the only statute to challenge. Now, defendant's other argument is that, well, there's some permanency in here, but this statute lives within the rights restoration section of the code. So really, this is about rights restoration. This isn't about disenfranchisement. But that argument is just misleading. The fact is that yes, this section of the code does have rights restoration provisions within it. Subsection C, that is the rights restoration procedure. But that's not the subsection we're here about. Subsection B, that is the permanent disenfranchisement piece. There are two things that can be true. This single statute contains both permanent disenfranchisement, which is what we're challenging, and rights restoration, which is not what we are challenging and is not at issue in this case. There is no question that under current law, as we sit here today, Ms. Moses cannot restore her right to vote using these procedures. If she filed a petition in court, that petition would be denied because she's permanently disenfranchised. She cannot go through the normal restoration process. That's what the statute says. And so defendants' arguments that were raised in briefing and I think have come up a little bit in court that, well, this is a restoration case and Ms. Moses should have gone through the process or filed a petition or she should have sued the Shelby County Election Commission. None of those arguments are on point because they're all focused on rights restoration, which is a different part of the statute. What we're focused on is subsection B. That is the permanent disenfranchisement section. And the way we know is that by looking at subsection C, which is the rights restoration provision, there are certain things that you could challenge there, and in fact have been subject to other lawsuits. A different plaintiff could challenge the restitution provision in C1 and say, well, that's a poll tax, or that's another unconstitutional obstacle to getting my rights back. But that's not what Ms. Moses has brought. That's not a claim in this case. Same thing with court costs and child support obligations and other provisions of the law that are obstacles to restoring your rights. You can imagine cases that are challenging those. And in fact, there was a federal court case in Nashville that challenged those. And in fact, the Sixth Circuit case, that Bredesen case that I think the court is aware of, that case was in fact challenging the rights restoration piece of this law and brought those kinds of challenges to restitution, and they were poll tax arguments. That's a different case. And so this idea that really this is a rights restoration case and we've gotten twisted around the axle and brought the wrong claims, that just really doesn't hold water. This lawsuit is just about subsection B, which is permanent disenfranchisement. And that leads to defendants' final main counterargument. If all of defendants' arguments, other arguments fail, defendants are falling back on the idea that Ms. Moses waived Article 1, Section 5 of the Constitution when she pled guilty in 2015. There's this waiver argument. Now, as we previously briefed, and it is as a matter of law, waiver is a defense that defendants have the burden on. And this is a defense that there is absolutely no competent proof in this case that's been offered at trial supporting a waiver defense. There's three principal reasons that a waiver defense simply doesn't work here. First, as we discussed earlier, pursuant to binding Supreme Court precedent in Gaskin, the Free and Equal Elections Clause is not a waivable personal right. And this is briefed as well. But Gaskin said, no, it's not a personal right. What Gaskin said was that it is a limitation on government power. It is a limitation on the power that was granted in 1834. And that in and of itself, that ruling, that interpretation, which is binding on this court, ends the discussion. It's not a right that can be waived at all. But even if the court believed that it was a waivable right somehow, that it wasn't a limitation on government power, other Supreme Court precedent from this state also puts an end to the argument.
I'm sorry, puts what?
Puts an end to that argument. So the case, the second case cited here, State versus Durso, and this has been in the briefing as well. This is another Tennessee Supreme Court case. And there, the court said that waiver of a constitutional provision is permissible only where it is both part of the rights guaranteed to an accused for his benefit in protection What that means is that it's a personal right to the defendant. It's not a limit on government power. So it has to be a personal right for his benefit and protection, and the waiver has to be done in accordance with safeguards provided by both the Constitution and implementing statutes or rules of criminal procedure. That case says you cannot have a waiver. Waiver is not possible unless it is both a personal right for a person's personal benefit and there is an established statutory or rules of criminal procedure framework that recognizes that right. And the reason is
Can you blow that up?
the state.
I can't see the site.
Oh, I can read it to you, Your Honor. It is State versus Durso, D-U-R-S-O, 645 Southwest 2nd, 753.
And what was the second part of that holding?
That it has to be both a personal right and that it has to be done in accordance, and I'm quoting, done in accordance with safeguards provided by both the Constitution and implementing statutes or rules of criminal procedure. The reason there is, under United States Supreme Court precedent, for a waiver to be knowing and intelligent and voluntary, it has to be laid out and explained. A person has to understand the rights that they are waiving. And the rules of criminal procedure, specifically Tennessee Rule of Criminal Procedure 11, lays out how that waiver is supposed to work. And the Supreme Court, Tennessee Supreme Court in Durso, recognized that in order to protect the constitutionally recognized rights of the accused, there needs to be a statutory or rules of criminal procedure framework in place to make sure that people are aware of those rights and they are knowingly, intelligently, and voluntarily waiving those rights. There is no such framework here. Article 1, Section 5, the right to not be disenfranchised unless you're convicted by a jury, that is nowhere in the statutes. It is nowhere in the rules of criminal procedure. There is no statutory framework allowing for such a waiver, partly because the state has never recognized it as a right in the first place. That's what this trial is about. It is a limitation on government power. And so even if the court believed that this was something Ms. Moses could waive, under Durso, the statutory framework is not there to allow such a waiver, and so that argument fails. And lastly, even if the court read past, believed that it wasn't a limitation on government power, contrary to what Gaskin says, or even if the court believed, well, we think we can read in a framework somewhere, contrary to what Durso said, the fact remains that there is absolutely no evidence brought forth during trial in any of the exhibits or any of the testimony demonstrating that Ms. Moses knowingly and voluntarily waived that right. She testified that she had no idea that she would be permanently disenfranchised by pleading guilty. She testified why she pled guilty instead, the pressure she was under. And the court can look. The transcript of her plea colloquy was admitted as an exhibit, and it is in evidence in this case. It was attached to the second amended complaint. There is no discussion in her plea colloquy of voting or suffrage or Article 1, Section 5 or disenfranchisement, permanent or otherwise. None of that during her plea transcript hearing, her plea paperwork, or the judgment form. So even if the court makes its way through these first two reasons why waiver is not a defense here, the fact remains that just on the facts of this case, Ms. Moses cannot possibly have waived this, even if a waiver were legally possible, which, again, it is not. So for those reasons, those are the main counterarguments defendants have raised. And I'll just note, overall, there's a commonality between these arguments, which is there's no evidence in support of them. The defendants had an opportunity to bring witnesses. They had 2 expert witnesses. They had an opportunity to ask whatever they wanted of Coordinator Goins, Ms. Henry Robertson, anybody else they wanted to bring. But there is really no evidence in support of any of these counterarguments. They are just procedural, legal counterarguments that the defendants hope will carry the day so that the court doesn't reach the merits of this case, because the merits are so clearly in favor of plaintiff. I'll conclude by saying this. Ms. Moses has been permanently disenfranchised for over a decade She was born in Sullivan County, Tennessee. She's been a prominent part of the Memphis community for many years. She has run for office. She's hoped to run for office again. She's been involved in a number of community initiatives. And she and tens of thousands of other Tennesseans like her have missed countless elections. They have missed countless opportunities to run for office and other ways to participate in our democracy. The state has shown no government interest supporting such a wide-ranging and discriminatory and arbitrary system, and one that directly violates the clear language of the Tennessee Constitution. It is time for permanent felony disenfranchisement to come to an end, and we respectfully ask the court to rule in favor of plaintiff on her claims. Thank you.
All right, thank you, Mr. Hoggenbeck.
Good afternoon, ladies and gentlemen. I'm Dawn Jordan here on behalf of Coordinator Goins. I don't have a fancy PowerPoint, but I do have, and I provided this to Mr. Hoppenreich already, copies of some statutes and other things that I'm going to talk about. And also used recycled folders. I hope you don't mind. And if anytime you can't hear me or don't understand me, please just ask me to talk up. I certainly can do that. But this has been an interesting case, and I thank all of you for your patience and indulgence with all of us in this. And I want to make sure that I incorporate all of the arguments that Mr. Halou made in the Rule 41 motion and all of the arguments that we have raised in the briefs and memoranda in support of motions to dismiss, our motion for summary judgment, and the briefs in opposition to plaintiffs' various motions. And as of now, as Mr. Haubenreich stated, the remaining claims are count 1, facial, free, and equal elections clause based on alleged elections manipulations by disallowing some felons to regain the right to vote. 2, count 6, an as-applied challenge based on the free elections clause, and particularly the jury trial issue. Counts 3 and 10, facial and as-applied equal protection based on alleged racial bias. Counts 5 and 7, facial and as-applied substantive due process.
I'm sorry, could you repeat the ones before 6, please?
Yes, there's a count 1, facial, free, and equal elections clause based on elections manipulated by disallowing some felons the right to vote.
Okay, and then it was count 6.
Yeah, count 6, an as-applied challenge based on the free elections clause, in particular the jury trial issue. And did I say that all, that cleared up? Okay, thank you. No, that's fine. First, as a subject matter jurisdiction, in City of Memphis versus Hargett, 414 Southwest 3rd, 88 at page 96.
Sorry, repeat that again?
Absolutely. 414 Southwest 3rd, 88 at page 96. The Tennessee Supreme Court found that to be justiciable, a case must be cognizable not only at the inception, but also throughout. A plaintiff loses standing if events occurring after the commencement of the action prevents the party from receiving meaningful relief, and that is what has happened here. Now, this panel held that Coordinator Goins would be kept in the case because, and I'm quoting here, plaintiff has provided evidence tending to show that Coordinator Goins could be directed to advise the local elections commission that she is eligible to have her voting rights reinstated. And this is the January 12, 2026 memorandum and order on the motions for summary judgment at pages 18 and 19. But plaintiff did not make that showing at trial. So let's break it down. Here, due to the 2025 law and another matter which I'll also discuss, plaintiff has not and cannot prove any potential redressability as to the one remaining defendant, Mr. Goins. Instead, the proof is, as of this time, Mr. Goins has a very limited role in reenfranchisement, and that role does not grant him any power to grant reenfranchisement. Now, you just heard Mr. Haubenreich in his closing statement And he focuses completely on what happened prior to the new statute in terms of the coordinator's involvement in reenfranchisement. The examples that it gave were in 2019 and 2024. The new law came into effect May 2, 2025. Now, that all might be relevant if this was a damages case, but it's not. All that Ms. Moses has requested is injunctive relief, prospective relief. And so we have to take a look at what is happening now. And plaintiff misunderstands the coordinator's role as it exists with the new statute. And the first two pieces of paper that I've given to you are from the old statute, 40-29-202 and 40-29-203. And these pertain to the certificate of restoration process. 40-29-202, which is the application for voter registration card, basically allows a felon who has completed his or her incarceration, including parole, probation, that kind of thing, to apply if they have paid all restitution, court costs, and they are current on all child support obligations. That's 40-29-202. 40-29-203 sets forth the Certificate of Voting Rights Restoration and the process for filling that out. A felon has to fill it out or have it filled out for him or her. And Part D of that statute, 40-29-203D, sets out the coordinator's responsibility as it existed at that time when Pamela Moses was denied. Says the administrator of elections shall send the certificate to the coordinator of elections, who shall verify that the certificate was issued in compliance with this section. In other words, that the certificate restoration was filled out correctly, that it was done properly. Okay? But those statutes were repealed in their entirety. They no longer exist. And as I said, that is what happened to plaintiff, but the new statute is drastically different. 40-29-103 is the new statute. It is entitled Petition for Restoration of Rights of Citizenship. And if you take a look at C1 of that statute, prior to the court acting on a petition filed pursuant to this part, the court clerk shall notify, and then go down to C1B, the coordinator of elections and the attorney general and reporter. The notice must be sent at least 30 days prior to any hearing on or disposition of the petition. The attorney general and reporter, as counsel for the state, may intervene either in person or in writing for the purpose of objecting to the petitioner's eligibility for restoration of citizenship rights. So the attorney general can intervene, but the coordinator cannot. Going on the next page, E1. The court shall order the restoration of the petitioner's full rights of citizenship and send a copy of the order to the state coordinator of elections if, upon the face of the petition, or after conducting a hearing, the court finds that the petitioner is eligible. And then Part G of this new statute sets forth the coordinator's authorities. Hold on. Okay. Part G of that statute sets forth the coordinator's responsibilities and authority as they exist as of today. A person whose right of suffrage has been restored by order of the court pursuant to this section shall submit a certified copy of the order to the administrator of elections of the county in which the person is eligible to vote. The administrator of elections shall verify with the coordinator of elections that the order was issued, and upon receiving the verification, shall issue the person a voter registration card entitling the person to vote. That's it. That's what he does. He verifies, yes, there was a court order issued. That's it. That's all he does.
Well, let me ask you a question. What would be the difference under the new statute with the coordinator having to verify that a court order had been issued versus the old statute where the coordinator would have to verify the person was eligible? Under the new statute, one would not be eligible unless the court found their eligibility, but the coordinator would still have the same function to verify that that person was eligible through the court order.
All the coordinator does is verify that a court order was issued.
Right.
He does not look, I'm sorry, I didn't mean to
I'm
interrupt you.
sorry,
Go-
they have to read the court order, all right, they have to read it, they have to analyze it, and they have to, and the coordinator has to make a finding or a determination that the order says eligible.
That's it, yes, that's all he has to do.
So what would be the difference, because you have a court order, so presumably you've gone through the court process, but under the old process, the coordinator still had certain things that he had to do to determine eligibility.
On the old, I'm sorry, and I didn't mean to interrupt you.
All I'm saying is
Yes.
that, is he still involved in the process? Because the order could say many different things. The order could be ambiguous, it could say eligible, it could say not eligible, it could say something in between. So
Right.
isn't the coordinator still analyzing that court order to determine eligibility? And then once he determines eligibility, that the court said she's eligible or he's eligible, then the coordinator would send it to the election commission in that county, would he not?
Okay. What the coordinator does in the new statute is he looks at the order, and if it says the citizenship rights are restored, the voting rights are restored, that's it. That's all he looks at. The previous statute, the certificate of restoration, is a very different process. The court was not involved in that process. There was a certificate that the felon filled out with assistance, or somebody else filled it out for him or her. The coordinator looked at that and made sure that all of the pieces fell in line. Were court costs paid? Was restitution paid? Was child support obligations current? He would make those determinations under the old statute. He does not do any of those things here. The court makes those determinations. The court issues the order. The coordinator just verifies, yes, this is the order. That's it. He does not look behind the order. He does not look to see, oh, but the court didn't address if there were court costs. The court didn't address whether there's restitution. The court did not address child support. The court did not address gun rights, whatever. If the court order says voting rights are restored, that's what he verifies.
What would be the difference in the 2019 letter that the 2024 letter that the coordinator sent that said, well, I've looked at this, I don't necessarily agree on eligibility, but this is what the order says, so register the voter, and if anything changes, then we'll purge.
Right.
So again, I mean, in that case, was there an order, if I remember correctly?
Yeah, at that time,
Yeah.
okay,
2024.
I apologize, Ernie. Yes, at that time, that was after the Falls versus Goins decision, where the Supreme Court put together a two-step process. There was a certificate of rights restoration, and then there had to be a court order as well. And at that time, the coordinator still was under obligation to make sure that the certificate of rights, the certificate of restoration was appropriate, and also would look at the order itself to see whether voting rights were restored. And whether also, and at that time, the law was that all citizenship rights had to be restored, including gun rights, in order for voting rights to be restored. That's not the case today. Today, a court can issue an order separate on the voting rights than any other right. So that's the difference. Does that make sense?
Yes.
Okay. Now, plaintiff also focused on 2-2-139B, which says that the county elections administrator must verify with the coordinator that a person is eligible to register under this section. But as I just discussed, the way the coordinator does that is contained in 40-29-103, and that is to say, yes, there's an order restoring this person's voting rights.
Sorry, could you repeat those two statutes as?
Yes.
Yes, okay.
I know.
2-2.
Yeah. 2-2-139, Part B. And the way that, again, the way that he verifies with the administrative elections is contained in 40-29-103G.
I'm sorry, repeat it again.
Yeah, I'm sorry, 40-29-103G. And plaintiff also focuses on, look, same statute, 2-2-139, Part C, which says the state election coordinator is empowered to formulate a uniform procedure for verifying the registration eligibility of any person convicted of an infamous crime. Again, three things I want to mention there is, one, the coordinator is not required to do that, but he does that anyway. Two, Mr. Goins, the coordinator, is not the one who applies the procedure to verify registration eligibility. That is the local official. And three, the procedure must be in compliance with all other laws. He cannot make an exception for anyone, so that does not assist the plaintiff. And finally, there was some discussion about some items from a 2014 affidavit from Mr. Goins that he is to prepare instructions for the conduct of registration, to advise election commissions, primary boards, and administrators of election as to the proper methods of performing their duties, and three, authoritatively interpret the election laws for all persons administering them and rules and regulations on effectuating the election laws. Now, as to all of these, Mr. Goins testified some of the local elections commissions, including Shelby County, have their own counsel, and they will often listen to those counsel if they don't agree with him. And Mr. Goins doesn't have any power to do anything about that. He certainly doesn't have any contempt power or anything like that. And while Mr. Goins comes up with processes, again, he is not the one who applies them. That's the local officials. And then to just break each one down, to review each one, instructions for the conduct of registration, again, as I noted, he does not have the authority to review individual registrations or make decisions on those. That is the court. He just looks at the court order, and if it says voting rights are restored, boom, that's it. That is for the local administrative elections and the election commission. Advise, again, the local administrators and commissions do not have to take his advice, and sometimes they do not, as he testified. Authoritatively interpret the election laws, again, some local elections council will not take that advice, but also the laws here do not give Mr. Goins the ability to be involved in any meaningful way with the reenfranchisement process. Again, all he does is verify an order has been entered. And as Mr. Goins testified, and he is exactly correct, the courts have the ultimate authority to interpret the law, not him. And what would the order compelling Mr. Goins say? You, Mr. Goins, have to direct the local administrator to allow this woman to vote? All that does is just give him authority pursuant to your order. It doesn't give him legal authority pursuant to any statutes. And he would have to do that, or he'd be found in contempt. And as I noted, under the current 40-29-103G, the only power he has to do is verify that a court order restoring voting rights has been issued, period. That is it. He does not independently determine whether a person is eligible. That is for the circuit court to do,
Okay.
and also the local elections official.
Let me ask
Yes.
you a very, very important question,
Yes.
because I'm thinking about the standing argument now.
Yes.
When this case was originally filed, I want to say it was in 19, yes. And Ms. Moses filed her petition for restoration in the circuit court.
Yes.
I was the judge. It was a petition.
Yes.
And when the original petition was filed, Ms. Moses was on probation. So the state took the position initially that she's still on probation, she's not completed her sentence, so she's not eligible for reinstatement. And then according to the pleadings, there was an amendment to the answer, and the issue with regard to the permanent disenfranchisement was raised.
Yep.
That was the first time that was raised. Ms. Moses, I believe, waited until she completed her probation flattened out her sentence and hired plaintiff's counsel. No, I believe that Ms. Moses initially filed her own petition challenging the constitutionality of that permanent disenfranchisement. Then she brought in counsel, and the Supreme Court appointed the panel because there was a constitutional issue regarding the validity of this statute. You with me so far?
Yes, ma'am.
Okay. So if I'm following your argument that the plaintiff the plaintiff lacks standing because Mr. Goins is not a proper party.
Correct.
So I want you to make sure we're on the same page. So if this lawsuit were dismissed, does that mean that Ms. Moses would then file her petition under the new statute with the circuit court, which would ideally come back to Division I, and that this judge solely would have the responsibility of looking at the statutes and determining whether Ms. Moses is eligible to vote? And if this court, under the new legislation, determined that Ms. Moses was eligible to vote based on the statute that she was permanently disenfranchised under, based on Article 1, Section 5, and any other analysis that the court did, and this court, not this panel, but this judge, under the new statute, ruled that Ms. Moses was eligible to vote and entered an order to that effect, that Mr. Goins, Commissioner Goins, would be then responsible to notify the Shelby County Election Commission
Yep.
that he would be responsible to either reinstate her right to vote or notify the Shelby County Election Commission that he now has a court order under this new statute, and that Ms. Moses would then be eligible to vote. Because that would be what you're arguing would essentially, if this case were dismissed and this constitutional question went away, and we're now saying that it's all by court order.
Yes.
No need for a panel, no lawsuit, just a simple petition under this new statute, and that trial court, whether it's Shelby County or some other court, would decide. But in Ms. Moses' case, because she is a resident of Shelby County and she's already petitioned this court, me, in 19, that ultimately it would be the trial court to decide, and whatever that decision was, Mr. Goins would be responsible to follow it.
A little bit nuanced, Your Honor.
Okay.
And that is, the order goes to the local administrative elections.
Okay.
The local administrative elections sends it to Mr. Goins just for verification.
Yes.
That's all he does.
Okay, so it goes to Linda Phillips.
Yes.
And Linda Phillips, although she has her own independent counsel, the statute says that Mr. Goins is also responsible for interpreting the law. So whether it's Ms. Phillips or Mr. Goins or a combination thereof, however that works,
Okay.
they would have to follow that court order because the court says she's eligible?
Mr. Goins doesn't have to follow that particular order because it's not directed to him. But if this panel were to issue, what I was saying is that if this panel issued an order directing Mr. Goins to tell the local elections official, let this woman register to vote, he would have to follow that order or he would be held in contempt.
Right, but.
And that doesn't really, I'm sorry, go ahead.
No, I didn't mean to cut you off, but my question is, if this panel were to agree with your standing argument
Yes.
that Mr. Goins is not the proper party to litigate these issues and to represent the state's interest in this case, then if this lawsuit were to go away, then would the effect of that be it comes back to the trial court through the new statute?
Yes.
Okay.
With the effect being that any trial court, circuit court, what does that say, circuit court?
It's circuit court, yes, Your Honor. Yes, Your Honor.
Any circuit court judge puts an order down that a person's rights have been restored, whether that order is in error or it's correct under the law. The statute now says all that happens is it's verified that an order was issued saying that, not look behind the decision,
Yes.
correct?
Yes, ma'am.
Is
Yes.
that where you were trying to go with that too?
Yes, yes.
Okay.
Okay. Yes. Okay. So, a little more on that. And further, the relief that plaintiff seeks in an order restoring her citizenship rights, sometimes I fall over myself, including her right to vote. The plaintiff has not presented proof that she is entitled to that relief regardless of whether she is banned from reenfranchisement pursuant to 40-29-102B. Because 40-29-102C requires that a convicted felon produce certain proof that she has paid all restitution and court costs and that she is current on any child support obligations. Plaintiff has not put on any proof at all to show that, as that she is otherwise eligible for restoration. There's no evidence of that one way or the other. So plaintiff has not shown an injury.
I'm sorry, could you repeat that?
Yeah, a plaintiff has not shown an injury here. She has not shown that she is eligible for restoration, regardless of whether she is permanently disenfranchised or not. She hasn't shown court costs, restitution, child support obligations, none of that.
Well, would that be necessary on the constitutional challenge? Once the panel decides the constitutional issue,
Yes.
if the statute were unconstitutional, then would it not go back to the trial court to determine the eligibility?
Yes.
You're not suggesting that we're responsible for determining eligibility here. Our limited purpose of this panel, pursuant to the Supreme Court order, was to determine the constitutionality of the statute, not to determine whether or not Ms. Moses is eligible.
What Mr. Hoppenreich just asked for as a relief is an order ordering Mr. Goins to direct the local elections official to let this woman register to vote. That is what he just asked
Okay,
for.
well, I'll
He
clarify
can't-
that when he does his
He cannot do that,
his
okay.
reclose.
Okay.
Okay, yes, ma'am.
But everything else said, yes, absolutely, Your Honor, yes. But this case is due to be dismissed for lack of subject matter jurisdiction. But plaintiff loses on the merits as well. As to the count one free and equal elections clause claim that the permanent ban on reenfranchisement somehow manipulates the composition of the electorate by disfranchising a large number of people. And this is a claim as pled by Ms. Moses, and I'm quoting, Tennessee's permanent disfranchisement statutes permanently deny thousands of Tennesseans their constitutional right to vote in violation of the free and equal clause. And that is in the second amended complaint, paragraph 90. But that makes no sense because the Tennessee Constitution, Article 4, Section 2, as we know, provides that the legislature may pass laws that exclude individuals from the right of suffrage if they are convicted of infamous crimes. And there's no provision that requires the legislature to enact laws that allow for reenfranchisement. So the legislature could permanently ban all infamous criminals. They could do that. So in effect, what the plaintiff is asking you to do, in effect, is to have this panel hold that Article 4, Section 2 is unconstitutional because of Article 1, Section 5. But this panel has already rejected such an argument in the July 19, 2023 order granting in part and denying in part defendant's motion to dismiss at pages 18 to 19.
I'm sorry, you said July 19.
2023.
Okay,
Yeah.
thank you.
And I'll be referring to that order quite a bit, so I may be say order granting
Okay.
motion to dismiss, but that's the one that I'm referring to, the July 19. And plus, there's no proof at all that the law in fact does this. True, there are people who can never be reenfranchised and can never vote. And true, there are many elections that are very close even by one vote. But so what? There's no proof as to how any of these people would have voted, who they would have voted for, or even if they would have voted. There was no analysis of what these felons would have done. There were no interviews or any attempt to define what they would have done. In other words, there's no proof at all that reenfranchisement would have made any difference. Dr. Baumgartner did talk about a number of elections, and I'll go through all those that he references in his report, but he did not testify that any of those elections could have or would have included anyone who can never regain the right to vote. And there's no evidence at all that there was any intent to manipulate the electorate, none at all. Now, as far as Mr. Goins testifying could have swayed an election, that's all we've got. Could have. That's not really proof. Could have. We don't know. That is speculation. And there's no proof which shows that any elections were swayed one way or the other. We don't have that on here. And if you look at tables 4, 5, 6, and 7, Dr. Baumgartner's report, that's Exhibit 34. Table 4 is on page 20 to 21 of the report, and it lays out the number of people who cannot regain the right to vote. That's Category 2 by year. The largest number is in 2024, 13,686. Now, if you turn to Table 5 on page 22, this table lays out various statewide elections from 1996 to 2018. The vote margins in all of them well exceed 13,686. Table 6, the U.S. House, which is on page 22 of the report, Dr. Baumgartner lists U.S. House election winners gaining less than 53% of the vote. I would note that he includes elections from 1982, 1978, and 1984, all of which were prior to the very first permanent disenfranchisement statute in 1986, so there could not have been any manipulations there. I would also point out that there is no proof as to whether anyone who cannot regain the right to vote actually lives in any of these districts, or if so, how many. But also, let's take a look at the individual ones. In 1992, the first one he lists, the vote margin was 2,930. In 1992, there were 1,191 statewide who could not regain the right to vote. 1982, there was no statute. 1994, the vote margin was 2,174. In 1994, there were 1,555 statewide felons who could not regain the right to vote.
Was that 100?
1,555, which is, of course, less than 2,174.
Okay.
1978, no statute. 2002, the margin was 10,309. In 2002, there were 4,478 statewide felons who could not regain the right to vote. In 1994, again, the margin was 10,744. But in 1994, again, there were 1,555 statewide who could not regain the right to vote. And the last one, in 1984, there was no statute.
All right, okay. You said Table 6?
Yes, ma'am.
Do you know what
Yes.
page that would be on?
Yeah, it is on page
Oh, 22.
22.
All right, thank you.
Yeah, all of this is pages 20 to, I think the last page is 23, which is Table 7.
Okay, thank you.
And Table 7, which is page 23, granted, at first the issue looks to be a bit closer, but again, Dr. Baumgartner did not provide any information as to how many infamous felons live in any of those districts, not to mention any information on how many infamous felons who could not regain the right to vote lived in any of those districts. So that table is completely meaningless, as are all the other tables. So count 1, the manipulation of the right to vote is due to be denied. As to the equal protection claims, here Mr. Halbenreich really did not address this, but I will. The first issue is what type of scrutiny applies. Is it strict scrutiny, heightened scrutiny, or rational basis? And for strict scrutiny to apply, there must be a suspect class or fundamental right at issue. For heightened scrutiny, there must be a state-sponsored gender discrimination. Obviously, that doesn't come into play here. And rational basis applies to all of the others. And that's Hughes versus Tennessee Board of Probation and Parole, 514 Southwest 3rd, 707 at page 715. Strict scrutiny does not apply. First, as to whether there's a fundamental right at issue, there is not. The Tennessee Supreme Court has held that a state may constitutionally disfranchise convicted felons and that convicted felons do not have a fundamental right to vote. That's Falls versus Goins, 673 Southwest 3rd, 173 at page 182. Now, plaintiff attempts to argue that 40-29-102B
40-29-103B?
102B, I
Okay.
think, yes.
Okay.
It's the statute that applies to deprive plaintiff of a right to vote. That's wrong. It is 40-20-112 that deprives all felons of the right to vote regardless of the felony.
I'm sorry, could you repeat that? My brain is, I hear you, but my brain is having a hard time catching up with my handwriting, so.
I'm going too
Okay,
fast,
that's
I'm
okay.
sorry,
You
yes.
said 40?
I need to be more entertaining like Mr. Hobbenreich.
No, it's okay.
I need,
late in the day.
okay, I'm sorry, I'll okay.
Okay.
Anyway, so plaintiff attempts to argue that 40-29-102B is the statute that applies to deprive plaintiff of her right to vote. That is not correct. Okay. It is 40-20-112 that deprives all felons of the right to vote regardless of the felony. And that applies at the outset to disfranchised felons. At the time of her conviction in government, she lost her right to vote pursuant to constitutional provisions and 40-20-112. Okay, so let's think about it for a minute. Pretend that 40-20-112 does not exist. Okay, doesn't exist. And so we have 40-29-102, and it's in your packet as well, just sitting on its own. The sentence in 40-29-102 says the following: the following persons shall never be eligible to have the right of suffrage restored and vote in the state. Okay, it says restored. How did they lose the right to begin with? They don't lose the right here. They lost it somewhere else. And this statute says they cannot restore it. So that's why 40-20-112 applies and not this statute. Because if you didn't have 40-20-112, this statute does not disfranchise anybody. So plaintiff does not have a fundamental right to vote. All felons lose the right to vote. And as I pointed out, the legislature does not have to give that ability to anyone. The legislature has made the policy choice to allow some felons to seek reenfranchisement, but not to others. There's no fundamental right to seek reenfranchisement. Next, is there a suspect class? No. In order to prevail on a suspect class claim, plaintiff must prove not just disparate impact, but also that there was improper intent of the legislature and legislators at issue. Proof including statistics showing disparate impact are not sufficient. And that is McClay versus Airport Management Services, 596 Southwest 3rd, 686, and Worrell versus Obion County, 694 Southwest 3rd, 158 at page 169. And here there's no evidence of racial motivations for the statutes that affected Ms. Moses, no evidence at all. And Dr. Holloway, and I will say this, I have a lot of admiration and respect for Dr. Holloway. She knows her stuff, that's for sure. It's just that her stuff is not relevant to this case. She was their primary expert for this part. Dr. Holloway made it very clear that she did not analyze anything, particularly legislative intent, after the 1950s. And a lot occurred after that she did not analyze. She did not analyze any statutes that say certain felons cannot obtain reenfranchisement, which is the only issue in this case. She makes no distinction between those felons who can seek reenfranchisement and those who cannot. She did not reach any analysis as to the different methods of seeking reenfranchisement. She just lumps everybody together. And this panel has made it very clear, and plaintiff has made it very clear, that this case is only about the fact that certain felons cannot ever seek reenfranchisement. Dr. Holloway did not speak to that, not in terms of intent, statistics, nothing. She did not analyze the intent behind any statutes which do allow reenfranchisement, other than to say that there are statutes that allow for reenfranchisement in certain circumstances. That's not helpful. She did not analyze the intent or motivation behind any legislators or legislators after the 1950s. She did not read the legislative history, the floor debates for the 1986, 2006, or 2025 legislation. Again, nothing after the 1950s. So any idea that racial motivations were occurring at the time of these relevant statutes in 1986, 2006, and 2025 is rank speculation on her part, on anybody's part. Dr. Holloway is simply speculating about the intent of the 1986, 2006, and 2025 legislatures, and that is not sufficient for an expert opinion. In Daniel versus CSX, 955, Southwest 2nd, 257 at page 265, the court must assure itself that the opinions are not based on an expert speculation. The Tennessee Supreme Court in Kilpatrick versus Bryant, 868 Southwest 2nd, 594 at page 602, held that expert proof based on things like might have, may have, or could have happened are not sufficient because it is too speculative. And that goes back to Mr. Goins' testimony about could have. That is speculative. And past discrimination is not imputed to current legislatures and current legislators. The United States Supreme Court in Abbott versus Perez, 585 U.S. 579 at page 603, held, quote, past discrimination cannot, in the manner of original sin, condemn governmental action that is not unlawful, and the Tennessee Supreme Court has held many times that these laws are, in fact, lawful. In State versus Evans, the Tennessee Supreme Court held that in order to establish that the discriminatory application of the death penalty violates the Equal Protection Clause, a defendant must show that the legislature enacting the statute or the jury sentencing the defendant acted with a discriminatory intent. And I'm quoting from that. And it's State versus Evans, 838 Southwest 2nd, 185.
I'm sorry.
Yeah.
838 Southwest 2nd.
185.
All right, thank you.
Yes. And this language specifically represents the legislature enacting the statute, of course. And as this panel noted, quote, historical discrimination is not evidence of current discrimination, and that's in the July 19, 2023 order granting in part and denying in part defendant's motion to dismiss at page 24. So plaintiff has not shown any discriminatory intent for anyone after the 1950s. The defendant, on the other hand, has provided proof to show that the 2006 law that affected Ms. Moses was not racially motivated. Most of the black legislators at that time were in favor of the 2006 law that affected Ms. Moses. Dr. Beto testified to that. In addition, the legislative history, the floor debates, and other public record is devoid of any racially discriminatory discussion. So plaintiff cannot win on the intent angle, so she attempts to show disparate impact. But as I said before, plaintiff must prove that there was improper intent of the legislature at issue. Proof, including statistics showing disparate impact, are not sufficient. And again, that's McClay versus Airport Management Services and Worrell versus O'Brien County. And if you need those case sites again, I can get them. The only possible exception is statistics that are so drastically stark that there is no other reasonable explanation for the law. And that is in State versus Banks, 271, Southwest 3rd, 90, at page 156. So I don't want you to have to go through 66 pages to find that.
Can you say
It's
that again?
I'm just making a little joke, sorry. Trying to liven it up a little
You
bit.
said 271 Southwest 3rd.
90 at page 156.
Thank you.
You're welcome. Plaintiff did not meet this burden. Plaintiff failed to show that the statistics are so stark that there is no other reasonable explanation. Plaintiff's statistics expert, Dr. Baumgartner, admitted that disenfranchisement affects white Tennesseans more than black Tennesseans. If you look at Trial Exhibit 36, Whites represent 61% of the convicted felons, and blacks represent 36%. A law that disfranchises thousands more white felons cannot possibly show a stark pattern of discrimination against black felons that is unexplainable on grounds other than race. Plus, the challenged reenfranchisement statute is easily explainable on grounds that this panel has already agreed with. I'm quoting here, "The General Assembly could rationally conclude that permanent disenfranchisement is appropriate for certain offenses against administration of government, like the one Ms. Moses was convicted of, as necessary to protect the integrity of Tennessee's elections. The General Assembly could also rationally conclude that persons convicted of certain offenses are unfit to take part in electing the legislators who make the laws, the executives who enforce them, the prosecutors who must try them for further violations, or the judges who are to consider their cases." And that is on the July 19, 2023 order on motion to dismiss at page 22. And here, as we know, plaintiff was convicted of tampering with or fabricating evidence. What she had done was fabricate a judicial complaint formed to the Board of Judicial Conduct against a general sessions judge who had held her in contempt. Sorry. And that, again, is in the July 19, 2023 order granting in part and denying in part defendant's motion to dismiss at page 2. Also, you can find it in State v. Moses, 2016, Westlaw 4706707, and of course the plea colloquy, which is evidence in this case, and is attached to the Second Amendment complaint. The legislature can properly decide that a person who fabricates or tampers with evidence should not be allowed to vote for judges or other elected officials. And in similar cases, courts have found that the proof of disparate impact was not sufficient. In Community Success Initiative versus Moore, 886 Southeast 2nd 16, the North Carolina Supreme Court found that evidence that blacks were disfranchised at a rate of 2.76 times that of white people was not sufficient. And this is similar to the rate that Dr. Baumgartner testified to in this case.
What case was that?
Yes, Community Success Initiative versus Moore, 886 Southeast 2nd 16.
Okay, wait a minute, let me write that down.
Yes, ma'am.
You said 888,
886
886,
Southeast 2nd
Southeast 2nd, okay,
16.
16, all right.
Community Success Initiative. Okay, and in fact, Dr. Baumgartner was the expert in that case as well.
And what year was that case?
2023.
Okay, thank you.
In U.S. v. Clary, 34 F. 3rd 709, the Eighth Circuit found that even though 98% of those convicted were black, that was not sufficient because there were rational motives behind the law. That is, 98 out of 100 people who were convicted were black. 98%. We don't have nearly that percentage here. And that was still not sufficient because there was an explanation for the law other than racial bias. And here, as this panel has already found, there are rational bases for the law.
What law was that where 98 of 100 people were black?
It had something to do with drug convictions for, I think, cocaine. It's crack cocaine. Crack cocaine, yes. That's what it is, okay.
And was that the case that you cited from 2023?
That one, I don't have the year for that, but it
Okay.
was 34 F. 3rd, so it's fairly recent.
All right, could you please give us that site too? 34?
Yeah, 34 F. 3rd 709.
709. 34 F. 3rd 709.
Yes, that's right, yes. And here, as this panel has already found, there are rational basis for the law. And bear in mind that the 1834 Constitution was the first time the Tennessee Constitution said only free white men can vote, or freed white men can vote. And it was also the first time there was a provision for felon disenfranchisement. And plaintiff proved that the first disenfranchisement laws were in 1858, obviously after the 1834 Constitution and prior to the 1870 Constitution. And Dr. Holloway admitted that at that time, 1858, black people could not vote, so they would not have been barred by the disfranchisement provision, because they couldn't be. They couldn't vote. The only people affected were white people. That's obviously not racially motivated. So strict scrutiny does not apply. It is rational basis. And as I already stated, this panel has already found rational bases for the law. And under this statute, if some reasonable basis can be found for the classification, or if any state of facts may reasonably be conceived to justify it, the classification will be upheld. That's Tennessee Small School Systems versus McWhorter, A51 Southwest 2nd at page 153. This standard is met if any reasonably conceivable state of facts could provide a rational basis for the provision. That's Fisher versus Hargett, 604 Southwest 3rd, 381 at page 399. And put another way, a statute does not violate constitutional rights so long as some plausible reason exists for the law, any plausible reason, even one that did not inspire the enacting legislature. That is Tawari versus Friedlander, 26 F. 4th, 355 at page 361. And that cites a number of United States Supreme Court cases. And under Tennessee law, governmental entities do not have to produce evidence of a government interest when defending legislation under rational basis review. Tennessee courts explicitly hold that specific evidence is not necessary to show the relationship between the statute and its purpose under the rational basis test. That's Riggs versus Burson, 941 Southwest 2nd, 44. And in City of Memphis versus Hargett, 414 Southwest 2nd, 88 at page 103, the Tennessee Supreme Court held that the intent of the state in preserving election integrity is a compelling state interest. At page 104, the court addressed the plaintiff's argument in that case that the state had presented no proof that voter fraud exists or had ever existed. The court rejected that argument. The court stated, a number of courts, including the U.S. Supreme Court, have rejected the notion that a state must present evidence that it has been afflicted with voter fraud in order to enact laws pursuant to its authority to protect the integrity of the elections process. And I'm quoting from that. So the equal protection claims fail because there are rational bases for the law. The substantive due process claims also fail. A person only gets due process for rights that they have. A felon has no right to vote by operation 40-20-112. And I point out in the due process counts, plaintiff lumps substantive due process and procedural due process altogether. And all that plaintiff says in those counts is that, quote, by failing to give plaintiff notice that she would be permanently disfranchised by pleading guilty to tampering with evidence, plaintiff's rights under the due process guarantee of the Tennessee Constitution, both substantively and procedurally, were violated. And that's paragraph 119 and 130 of the Second Amendment complaint. Nothing more. And this panel has already found that there is no procedural due process violation because she had a considerable amount of process with her guilty plea and the appeals that happened after that. She tried to withdraw the plea, that kind of thing. But in addition to that, until this lawsuit, years after she exhausted all of her appeals, she tried to withdraw her plea. That was not allowed. Plaintiff never complained about or appealed the fact that she was not able to be reenfranchised. She had plenty of opportunity, so she cannot complain about that process. In addition, all citizens are presumed to know the law, so she had notice in that regard as well. But even if she had made more of an actual substantive due process claim, that claim fails. To maintain her substantive due process claim, plaintiff must show that a fundamental right exists or that the statute at issue is conscience shocking. That's Worrell versus O'Brien County School District, 694 Southwest 3rd at pages 166 to 167.
I'm sorry, repeat that again, counsel, please.
Yeah, 694 Southwest 3rd at pages 166 to 167. And that was just last year, I think, or 2024.
What were those page numbers, please?
166 to 167.
Thank you.
And here again, like I said, there's no fundamental right issue. Rational basis applies, and there are rational bases for the law. So the only issue is whether the law shocks the conscience. It does not. The analysis that I discussed already should cover that, but to be thorough, let's talk a little bit more about that. The Tennessee Supreme Court has held very recently that usually the shocks the conscience standard applies to executive action, not legislative action. And that is, again, in Worrell versus Obion County School District, 694 Southwest 3rd at page 167. And of course, only the most egregious official conduct will violate that standard. The example that's frequently given is pumping somebody's stomach to get evidence. Now, obviously, that's not what happened here. For the legislature to pass a statute that precludes somebody found guilty of felony evidence tampering or fabrication, which she did here, fabricate, does not shock the conscience. And plaintiff has put on no proof at all to show that it does somehow shock the conscience. And consider this, none of the constitutions have required a reenfranchisement scheme, but they do allow for the legislature to take that right away. The federal Constitution allows it. The due process claims thus fail to shock the conscience standard. And there's a facial and as-applied challenge, and I want to drill down on that a little bit more too. As to the facial challenge, generally where the challenged provision is subject to rational basis justification, it does not meet the extraordinary shock the conscience standard threshold across all applications. That's Parks Properties versus Maury County, 70 Southwest 3rd, 735 at page 744. Fisher versus Hargett, 604 Southwest 3rd, 381 at pages 396 and 98. And again, this court has already found that the statute has rational bases, the protection of Tennessee's elections from criminals that committed offenses against administration of government, and a conclusion that those convictions render a person unfit to take part in elections for legislators, executives, prosecutors, and judges. Now, Mr. Halbenreich brought up that there are certain laws that there are certain crimes that do not fall into this category, but laws such as the one that Ms. Moses violated, evidence tampering, fabrication, is directly against government processes, and therefore it's proper for the legislature to decide that those rights should be removed permanently. And the legislature has decided that as a policy of the state, and the legislature is the branch of government that decides policy. And what the plaintiff is asking you to do is substitute your judgment for that of the legislature. The two rationales for the law that this panel has found, along with the fact that no pathway to reenfranchisement is required, dooms the facial challenge. And then quickly, as to the as-applied due process challenge, basically, Ms. Moses' due process claim is a repackaging of her discrimination claim. Therefore, the analysis is under the equal protection claim, and that applies, which I've already stated fails for a number of reasons. And now then finally, as to the alleged requirement that there be a conviction by a jury trial, essentially what plaintiff wants you to find is that a conviction by a jury of an infamous crime is an unwaivable prerequisite to disenfranchisement. This conflicts with the history and Tennessee Supreme Court precedent. And there are two constitutional amendments at issue. Mr. Halbenreich put it up on the board, and I have given you those on one piece of paper, so they're both on there at once. Old school, sorry about that. Article 1, Section 5, and Article 4, Section 2. And plaintiff misapprehends the two constitutional amendments and how they act together. And this court is charged with the responsibility to make sure that both provisions are given full effect. In its order on the motion to dismiss, this panel held that, and I'm quoting, "The Constitution of Tennessee is the product of the sovereign will of Tennessee citizens, and the courts must construe each provision in a way that gives the fullest possible effect to the intent of the Tennesseans who adopted it." The State of Bell versus Shelby County Healthcare Corporation, 318 Southwest 3rd, 823 at page 835. Thus, one provision of the Tennessee Constitution cannot be used to impair or destroy another provision. And all of that I just quoted is on page 18 of the order on the motion to dismiss, the July 19, 2023 order. And I'll point out that at the 1870 Constitutional Convention, there was some attempt to remove the legislature's ability to make laws impairing the right to vote. And that is on page 54 of the Journal of the Proceedings of the Delegates, and I think that's Exhibit 70, which Mr. Halbenreich has here. And in fact, Dr. Holloway testified that at the time that she wrote her first report, she thought that actually Article 4, Section 2 had actually been removed from the 1870 Constitution. but obviously we know it was not. Article 4, Section 2, as we can see, allows the General Assembly to enact laws excluding from the right of suffrage persons who may be convicted of infamous crimes, and there's no requirement that there be a conviction by a jury in that provision. In Article 1, Section 5, elections shall be free and equal, and the right of suffrage, as hereinafter declared, shall never be denied to any person entitled thereto, except upon conviction by a jury of some infamous crime previously ascertained and declared by law, and judgment thereon by a court of competent jurisdiction. And plaintiff only focuses on one phrase, conviction by a jury of some infamous crime, but that's not the only phrase in that provision. There's a qualifier, an important one, that the right of suffrage shall never be denied to any person entitled thereto. And plaintiff overlooks the differences in the language of the provisions and overlooks that important qualifier that the person seeking such enfranchisement must be entitled to it, and that dooms her case. For starters, plaintiff does not challenge, I'm sorry.
Yeah, this is the first time I've heard this argument, so you're focusing on entitled thereto?
Yes,
What do you believe that, what do you contend that that means?
that they are entitled to to the right of suffrage.
Well-
It says, it shall not be denied to any person entitled thereto,
But what does the next part of that
except
section-
upon conviction of, yes,
Right.
I'm getting to that. That's a great question, and I'll be explaining it, I think.
Okay,
But if not, I'll be happy to
okay,
take further, to try to clarify it if I can.
okay.
Okay. For starters, plaintiff does not challenge the statute that caused her to lose the right to vote in the first place, 40-20-112. She does not challenge her disfranchisement. All she challenges are the statutes that bar her reenfranchisement so that she cannot restore her right to vote. And as such, plaintiff is not entitled to the right to the franchise because she has lost the right to vote by operation of that statute. So Article 1, Section 5 does not apply here at all.
Well, see, that's where I'm kind of confused because it seems like one side is characterizing it as a reinstatement of rights, whereas the other side is characterizing it as a permanent disenfranchisement. And the statute that Ms. Moses was disenfranchised under, it has 2 sections. So I think Section C speaks to the reinstatement, Section B speaks to the permanent disenfranchisement. So is this a case about reinstatement, or is this a case, because remember, this panel was impaneled for one reason,
Right.
to deal with the constitutionality of the permanent disenfranchisement statute.
Correct.
We were not impaneled to deal with the constitutionality of the restoration statute or to determine whether or not Ms. Moses was entitled to vote. We have one limited question.
Right.
And that because this is a panel that was appointed to deal with that question, whether or not, and I'll tell you the specific statute. And I know you know what it is, but I want to make sure that
I might not. I don't know all the answers, that's for sure.
Okay. Is it 40-29-204?
That statute has been repealed.
Okay, so,
That statute became 40-29-102.
That's correct.
Okay,
Is that, okay,
that's what you were looking for.
okay, 40,
29102.
102, Section B.
And I apologize, I confused you because I had the original statutes up there just to show the difference between then and now.
Okay.
Okay, so yes, so it's now 40-29-102. And Part B,
So I was a little bit confused when you were explaining the Article 1, Section 5, and you
Yes.
were analyzing that provision
yes.
in terms of how it applies in this case. So could you cover that again for me, please?
Yes, yes.
Okay. Why you believe that it doesn't apply, that
Yes.
that Ms. Moses was already disenfranchised? I was having a little bit of difficulty understanding that.
And before I do that, can I back up? There was
Yes.
you asked about a certain case site, U.S. versus Clary, 34 F. 3rd 709. That's 8th Circuit, 1994.
Okay.
Okay, all right. Now, in terms of 40-29-102B and the whole disfranchisement, reenfranchisement, that kind of thing. Ms. Moses lost her right to vote by operation of 40-20-112. The issue is whether she can gain reenfranchisement, and we know she cannot. But if you take a look at 40-29-102, which is the statute at issue now, the other one has been repealed. The sentence on B reads, "The following persons shall never be eligible to have the right of suffrage restored and vote in the state." Restored, which means they've lost the right to vote by some other mechanism, and that mechanism is 40-20-112. The issue is whether she can seek reenfranchisement, and she cannot by operation of 40-29-102. Does that clarify things?
In other words, 40-12-112 is entitled Felony Convictions, semicolon, Voting Rights, semicolon, Testimony. And it says, upon conviction for any felony, it shall be the judgment of the court that the defendant be infamous and be immediately disqualified from exercising the right of suffrage. Then it goes on to say they can still testify in court, okay?
Right.
So that's the statute that declares all felons lose. That's the disenfranchisement statute.
Yes.
And then when we turn to 40-29-102, which used to be those other numbers,
Yes.
it's entitled Restoration of Citizenship Rights,
Yes.
right? I mean, the titles tell us one is convictions and one is restorations,
Yes.
right?
Yes. Yes.
And then that's when it goes down to say there are certain people who are never eligible to be restored. It contemplates they've already been convicted of something.
They've been convicted and they've lost the right to vote, and the issue is
Just-
whether they can be
I want to make sure I'm
restored.
tracking your argument.
Yes.
Okay.
You said it better than I did, so thank you. Appreciate
I'm
that.
just trying to clarify.
No, well, no. Please clarify away. I need that. Okay. But plaintiff did not challenge the statute that caused her to lose the right in the first place, so she does not challenge her disfranchisement. All she challenges are the statutes that bar her reenfranchisement, and as such, she is not entitled to the franchise. So Article 1, Section 5 does not apply here at all. She lost it. She's not entitled to be to the franchise and can never be. Whether there was a jury trial or not is irrelevant. And as a further point, look at the word denied in Article 1, Section 5, and I put some dictionary provisions for you in there. They're hard to read. Sorry about that. It was an exercise. The book is bigger than this table. The word denied during that time frame meant to refuse to grant or to withhold. That's in Article 1, Section 5. They use the word deny. The word excluded is used in Article 4, Section 2. And in the 1800s, that word meant to thrust out or shut out. However, when she was convicted of tampering with and fabricating evidence by operation of the Constitution and state law, she was then excluded or thrust out of the franchise, in her case, permanently thrust out. She could never seek reenfranchisement. She was already thrust out. And that's where the important qualifier in Article 1, Section 5 comes into play. At this point, she's not entitled to the right of suffrage, so the jury trial issue is moot. And this reading comports with the history of both amendments in the Tennessee Supreme Court precedent, including the Gaskin versus Collins case that Mr. Hobenreich talked about. At the time of the 1870 Constitutional Convention, as Mr. Hobenreich explained, it was generally agreed that the requirements of loyalty oaths before one could be enfranchised was loathsome, and the delegates wanted to come up with a solution. People who had not been convicted of any crime were being denied the right to vote, the right of suffrage. The government was denying, i.e. refusing to grant or withholding the right unless they signed a loyalty oath. They were otherwise entitled to it except for the loyalty oath. What had happened was there was a retroactive disfranchisement of those people, and they were being denied the right to vote. That's what had happened. The convention delegates wanted to prevent any further similar retroactive deprivations and required that the crime be identified before there is a conviction and a finding of infamy. And the Tennessee Supreme Court in Gaskin versus Collins, and I want to point out a couple of things about this case. This case did not deal with the issue that we are talking about here today, whether conviction by jury trial is required before disfranchisement can occur. This case was about whether it was a law that was passed after this person was convicted of a crime, and yes, in the court in Gaskin versus Collins held that no, you can't retroactively pass a law to disfranchise somebody. That's essentially an ex post facto law. It's what the court held. And it does not involve waiver of the jury trial, it doesn't talk anything about the issue that we're here about today. And in particular, I would like to direct your attention to, on page 867, and if you go on the Westlaw site, there's a 2 in bold in parentheses there. And this whole paragraph is very telling about what the court was considering at that time. We do not agree, however, with appellant's position that these provisions only require that the legislature acts in order that a person be disenfranchised. This interpretation ignores the ordinary meaning of the words previously ascertained and declared by law, read within the context of the provision. When construing a constitutional provision, we must give to its terms their ordinary and inherent meaning, and then there's a cite. The phrase previously ascertained and declared by law modifies the words infamous crimes. It qualifies the words infamous crimes in the sense that it places a time limitation on when an act shall be declared infamous. In other words, when a law can declare an act infamous, that is before conviction of the crime by a jury. So what the court was faced with in that case was there was a law that was passed before somebody was actually found guilty of a crime. And that was wrong, obviously, for a number of reasons.
Ms. Jordan?
Yes,
If
yes.
I may. So if we were to take the position that the wrong statute has been challenged,
Yes.
that the disenfranchisement statute is 40-20-112, that says upon conviction for any felony, all this argument about the Tennessee Constitution language about conviction by jury comes into play under that statute, not the restoration statute, right?
Yes.
There's nothing in 40-29-102 that discusses the method of conviction. It just says some people are eligible to be restored now and some people aren't, right?
Correct, yes.
So
Yes.
so hypothetically, if this panel were to find that the wrong statute's been challenged, we don't even have to reach the issue about conviction by jury language.
Correct. That's my point.
Okay.
Yes, right, yes, okay. And then, one final note on the issue. Dr. Holloway stated there's a long tradition of juries as being essential to democracy. Agree, no doubt about that. But however, there's also a long tradition of freedom as being essential to democracy. And part of that freedom is the ability to waive certain rights when such waiver benefits us. They are rights that are accorded to us We can waive them if we so choose. To somehow say that we cannot waive that right when it benefits us is absurd. Ms. Moses can and did waive her right to a jury trial. She did so because, as she testified, she wanted to go home. And she got to go home. But she also, you okay? Do you need, okay, that's good. Do you need more water? Okay. I'm being nice to him. I don't know why. Okay, anyway, she was allowed to plead guilty to lesser offenses, to have some of those offenses removed, and thereby significantly reduce the sentence she might otherwise have received. And she got to go home. Ms. Moses received her benefits, and as part of that plea, that benefit, she accepted the collateral consequences of such a plea. And I want to point out, you all know this, that Ms. Moses did file a petition to withdraw her plea and argued many points on that, including that she pled in part because she was concerned about her mother and her son, but she never, in that petition for withdrawal or anywhere else until now, she said nothing about losing the right to vote. The Court of Appeals affirmed the Circuit Court's denial of the withdrawal, finding that, and quote, there was absolutely no indication at the plea submission hearing that Moses was coerced into entering her plea, that she was entering her plea through fear or fraud, or that her plea was involuntary. That is in State v. Moses, 2016, Westlaw 470-6707 at page 12. And that case has a lengthy discussion of what happened at the plea colloquy and then the evidentiary hearing on her request to withdraw her plea. And plus, Ms. Moses in particular has had experience in disenfranchisement in which she, in writing, indicated that she knew she was giving up the right to vote. And as we said in our trial brief, plaintiff cannot transform a waivable procedural protection into an unwaivable shield against the collateral consequences of accepting a plea, including the right to vote. This case is due to be dismissed. Thank you. Unless you have any other questions. Okay, thank you.
Okay, Mr. Harborick, we close.
Thank you, Your Honor. You would just allow us one moment, Your Honor, to get
Okay.
the screen back up.
Which classic movie is that, Mr. Harbin?
This is actually my rebuttal. Just kidding.
You've gone retro, black and white.
Thank you, Your Honor.
Okay.
I'm going to try to cover these topics as best I can without jumping around too much. I want to start with the idea towards the end of defense counsel's presentation about the two constitutional provisions. The idea that Article 1, Section 5 only comes into play if there's sort of a right to vote already, but that argument would swallow the entire idea of Article 1, Section 5. If you think about 1870, what was going on, and Dr. Holloway's testimony covered this, there were people who had already been disenfranchised by operation of law.
Only white people.
Correct,
Only white people could
Confederates.
vote, right?
Correct, yes, Confederates. So there was a class of people, Confederates, former Confederates, who had been disenfranchised by operation of law. If you take defense's arguments at face value, they would have been properly, quote unquote, excluded, and therefore Article 1, Section 5 wouldn't affect them. It's the same logic. That argument swallows the entire point of Article 1, Section 5. The point of that was to say, listen, you can't just disenfranchise people as a matter of law without having them being convicted by a jury, without having had an offense that was previously ascertained, and without having a judgment upon that conviction by a court of competent jurisdiction. The idea that you can just disenfranchise as a general matter, anybody and everybody, and then they would have no remedy under Article 1, Section 5, the Gaskin case held the exact opposite of that. The people in the Gaskin case who were challenging the statute that disenfranchised them, according to defense's argument, they wouldn't have any standing. Article 1, Section 5 wouldn't apply to them because they were already disenfranchised as a matter of law. But that's not right. That's not what the Tennessee Supreme Court held. The Tennessee Supreme Court held that no, yes, those people were disenfranchised by operation of law. There was a statute on the books, just like there's a statute on the books here. But the Tennessee Supreme Court said, no, Article 1, Section 5 mandates that before those people could be disenfranchised, there had to be a previous ascertainment. You couldn't retroactively do it. So that argument that the defense counsel made that somehow Article 1, Section 5 doesn't apply here, could never apply here, is just flat wrong. Otherwise, the Gaskin case would be wrong and could not have been decided that way. It is very clear that if a person has been disenfranchised, the other provisions of the Tennessee Constitution still apply. Equal protection still applies. It's not that you lose your right to challenge disenfranchisement or permanent disenfranchisement, which is what we're challenging. You don't lose the right to challenge that under other parts of the Constitution just because there's a law in the books that says you lost your right to vote. These are fundamental constitutional challenges to that disenfranchisement system, permanent disenfranchisement system here. So the idea that Article 1, Section 5 doesn't come into play or offers no relief here is absolutely foreclosed by the Gaskin case. It was the exact same situation, and in fact, the historical evidence is the same. Now, I want to get back to this idea about we've challenged the wrong statute, because I understand Judge Cook has articulated that argument well. But that argument is also wrong for a couple of reasons. I covered in my first closing that, again, we're not challenging, as this court has held that we cannot, general felony disenfranchisement. We are challenging permanent felony disenfranchisement. The permanency, that is in 4029-102. That's the only place that is. And it operates in tandem and at the same time as 112. 112 applies across the board, but the permanency, that's the case, that's what we are challenging. That's in 102, and that's why we had to challenge 102. It has the rights restoration language in there, but it also says the person shall never be able to vote. It says you'll never be eligible to restore your right to vote, but it also says you'll never be able to vote. That is just permanent disenfranchisement by any other name. You can try to mask what it is, and defense counsel is doing it, making their argument, this is really about rights restoration, but that is the only statute that permanently disenfranchises. The other reason that we challenge that statute, and that statute in particular, is because that is the statute that Coordinator Goins relied upon when he told the Shelby County Election Commission, Ms. Moses cannot register to vote, and she cannot vote. And that is what's up on the screen right here. This is the email that I showed you earlier during my closing. It's Trial Exhibit 64.
Can you blow that up for us, please?
I can, yes.
A little bit more. Okay. All right.
That was a big
Okay.
thing to get it still fit on the screen.
Okay.
So this is the email conveying the letter from Coordinator Goins. It says, attached, please find a denial letter. And we heard defense counsel talk about, well, this isn't really a denial. It's the defendants who are calling this a denial. These are their words. Find a denial letter for Pamela Jeline Moses. The reason for denial is that she is permanently ineligible to vote due to her conviction, and they cite the statute that we challenged. Defendants, this is their words, this is their exhibit, this is their citation. Frankly, and we can brief this in post-trial briefing, we think defendants are actually stopped from arguing that we've challenged the wrong statute. They identified this statute in their letter, and this is the injury. This is when Ms. Moses was denied the ability to register and to vote. And that is why we've challenged that statute, and it is the right statute. That is the permanency statute. Trying to draw this fine line between initial disenfranchisement and permanent disenfranchisement, that's a false dichotomy. They work together, and they work at the same time. At the moment Ms. Moses or anybody else pleads guilty, they are both disenfranchised, and if they qualify for one of those offenses, they are permanently disenfranchised. At that moment, it happens automatically and immediately. And that is the function of
But
102.
they would never be disenfranchised if they hadn't committed any felony, a felony.
That's correct, but it's not the commission of the felony that creates the permanent disenfranchisement.
Certain
It's 102 that creates the permanent
Certain
disenfranchisement.
felonies are permanently.
Correct, that's correct.
But the starting premise is you have to have been convicted of a felony, and all felons are disenfranchised.
That's correct,
Okay.
but it's the permanency that we're challenging. And that's why 112 is not the right challenge here, is because the court has held that this is a case about permanent disenfranchisement. And I want to draw the court's attention to the order. One moment. This is the order from September 16th, 2025, on plaintiff's motion to amend. This is where the discussion about the jury conviction claim and what was going to be allowed as amendments. And this court has already held that the permanent disenfranchisement statutes, that's 102, deprive Tennesseans of their rights under the jury conviction requirement of Article 1, Section 5 of the Tennessee Constitution. It is the court's view that this argument was fairly implied by plaintiff's claims as pleaded in the Second Amendment complaint. This court has already recognized, back in September, that we pled an Article 1, Section 5 jury conviction claim under these permanent disenfranchisement statutes. And that is why we have gone forward with this claim, and that's why this claim is in the case, and that's why we're at trial prosecuting this claim. Article 1, Section 5 does apply. It has to apply. And we have challenged the correct statute not only because by the operation of its text, but also because that is the statute that was identified by defendants.
So let me make sure I understand. So if say you're convicted of theft over $1,000, which is a felony, and you've not been convicted by a jury, one would presumably have standing to challenge that conviction, which we said we were not going to allow, but at a different day, a different case.
That's a different case, Your Honor,
A different
yes.
case for a different day, but it would still be brought under Article 1, Section 5.
Correct, Your
Because it's
Honor.
just a disenfranchisement. That's not what.
Not a
was-
permanent disenfranchisement.
Right.
Correct.
But the only statute that triggers the permanent disenfranchisement is 4029.
102B. That's correct, Your Honor.
So you're arguing that that also can be challenged under Article 1, Section 5.
Correct, Your Honor, and that's what the court held. I mean, that's what this order says.
Right, because Ms. Moses did not become permanently disenfranchised until they passed the statute in 2006,
Correct, Your Honor.
which was later amended in May of 2025.
Correct. As to her, the statute was amended, it was just moved over. It's the same list of crimes.
Right.
It was just moved to a different section.
Right. But that was in May of 2025 while this case was still pending.
Correct, Your Honor.
So my question for you is, if the statute was modified while this case was pending, how does that affect this case? What effect, if any, does it have on this case? Because under the old statute, which I pulled up, notwithstanding this part, the following persons shall never be eligible to register and vote in this state. And then it goes on to list those crimes, and that's it.
Correct.
That's it. That's all it says. And it was the Acts of 2006, Chapter 860, Section 1. And, well, it looks like it may have been amended. Then it says 2011, Chapter 184, Sections 1 and 2. But that was the total statute. So it was later amended while this case was pending in May of 2025. And it goes into this whole scheme of, or procedure for restoring one's rights. So what effect, should we be looking at the amended statute? Well, put it this way. Should we be looking at the statute that was in place when this lawsuit was filed? Or should we be looking at 40-20-102 and apply it retroactively to Ms. Moses?
We are happy to include this in our post-trial briefing. I believe the answer is for declaratory judgments, you look at the current statute as a technical matter. But the reality is that the substance isn't any different. It really doesn't matter. So you can look at the old 204, or you can look at the new 102.
Well, it's easier to argue restoration under the new statute than it is to argue it under the old statute.
That's right, Your Honor, but only because of the location of the permanent disenfranchisement. It's now been nested in with the restoration, but that doesn't mean it's about restoration. It is still the.
That. I'm just saying it's easier to argue that it's about restoration now because it's couched within that whole statute.
Agreed.
Whereas before, it just spoke to permanent disenfranchisement.
That's right, Your Honor. I think that's why defendants are making that argument, because now it lives nested within this rights restoration section, but that doesn't mean it's about rights restoration. It is substantively the same. So it doesn't matter as a matter of law which version you look at. But I do want to touch on this rights restoration question, because there was a long discussion with counsel about that. I want to make clear what the procedure here is. Now, Judge Corbin Johnson, you were asking what would happen if Ms. Moses filed a petition under the new statute to restore her rights, and it came in front of Your Honor or another circuit court judge. The problem with that hypothetical is that it doesn't work. There is a statute that I wrote down somewhere, 2018-101. That is the three-judge panel statute. That statute says that if you raise any constitutional claims, you have to have a three-judge panel. So the idea that Ms. Moses could come, file a petition, raise this Article 1, Section 5 claim, and then just have a judge rule on it, and then take that ruling to the coordinator and get her rights restored, that's not how it would work.
But I didn't envision it like that. I envision it, someone who's been disenfranchised permanently files a petition, and the court looks at it and says, oh, you pled guilty. Looks at the law and says, well, Ms. Moses doesn't raise it, or the person who's seeking the rights doesn't raise it. But the court looks at the law and says, oh, you were never convicted by a jury. So therefore.
Your Honor, the problem with that hypothetical is that the Attorney General's office gets notice of all those petitions and has a right to intervene. even if it wasn't raised in the complaint, since it raises a constitutional claim, I feel very confident the Attorney General's office would assert this statute and say this has to be governed by a 3-judge panel, which is what happened in this case. This started out as a restoration petition.
Only because Ms. Moses raised the constitutional question. If the Attorney General raised the issue and said she's just permanently disenfranchised, that's that on that.
Agreed.
Ms. Moses raised that issue.
But again,
But I understand what you're saying.
I think
I do.
the problem is that alternate future where Ms. Moses files a rights restoration petition, first of all, she can't. That would not go anywhere because under current law, she's permanently disenfranchised. She's not eligible. She's not eligible for any of that process. The only challenge that she has is these constitutional challenges. And so that whole hypothetical about going through a different process and Coordinator Goins isn't involved anymore, this really gets to the standing challenge because the defense's argument is the whole process has changed. Prior to 2025, Coordinator Goins, his office was the one that was making the call and they were doing the research. And now that's different. It's the circuit court. But the problem with that argument is that that is not the process we're talking about. This is a constitutional declaratory judgment action challenging the heart of the statutes themselves as constitutional, not the process, not arguing that she's entitled to restoration following either the old process or the new process. Back in 2019, she did submit a certificate of rights restoration. She did file a petition. She did both. And then it turned out she was permanently disenfranchised. She can't go through that process. This constitutional challenge is all that there is. And under the constitutional challenge, Coordinator Goins is undoubtedly the correct defendant because eligibility decisions about people who are convicted of felonies have to go through him. They have to go through him. And we know that because he testified to it. You'll give me just one moment to pull this back up. So this testimony, Your Honor, this is from trial day 2. This is Defendant Goins. And he is talking about current practice. Ms. Jordan was talking about in her closing that we were talking about historical things from before 2025. We talked about what happened in 2024. I would submit that's still very relevant because it shows the path of what would happen here. We're talking about 2019. This testimony is about what happens today, after the law has been passed, and what happens when a person like Ms. Moses, who's been convicted of a felony, tries to register to vote. The law, 22139, that I showed and Ms. Jordan talked about, that is the current law. Anytime a person who's been convicted of a felony like Ms. Moses tries to register to vote, it has to go through the coordinator. And that is what he testified. I asked him, as far as being convicted of a felony and being able to register, notwithstanding that conviction, this is the authorization to register that person. And he says, yes, it verifies the right has been restored. That's what we verified. That's what Ms. Jordan talked about. And then I asked, understood, but they can't register that person until they send it up to you. And you all respond to them and give them the green light, correct? And he said, I would agree with that. It has to go through Coordinator Goins. If for whatever reason we were in a different world and it was the Shelby County Election Commission or whoever the administrator is, they would say the same thing. We have to go to Coordinator Goins because it's a person who has a felony conviction. That goes through them and they tell us what to do. And that's what Mr. Goins said. They can't do anything until I give them the green light. That is why he is the proper defendant here. This is not some situation where Ms. Moses is going through the petition and filling out a core and going through that whole process. That's not this case, as much as the defendants want it to be. And I said in the beginning, about halfway through my closing, defendants' arguments are not really on the merits of this case. There's semantic arguments. Well, exclude doesn't really mean deny, and Article 1, Section 5 doesn't apply because it can't challenge the earlier provision. These are all procedural, semantic, grammatical arguments, because the fact of the matter is the plain language in Article 1, Section 5 says you cannot be disenfranchised or permanently disenfranchised, in this case, absent conviction by a jury, and there's no dispute that she was not convicted by a jury. So we are asking for a narrow ruling here. It's about permanent disenfranchisement, not general disenfranchisement. That's why 112 is not the right statute. That's why 102 is the right statute. And we believe that the current state of the law, again, I want to call your attention to 22139. That is the current law that says it has to go through Coordinator Goins. That statute, by the way, was amended in 2025. The legislature looked at it, and the provisions that say before a person is registered, it has to go to the coordinator, they left those provisions untouched. Those were not amended. The legislature could have changed it and could have cut Coordinator Goins out of the process entirely. They chose not to. He makes the ultimate call. He gives the green light. So any question that we challenge the wrong statute or have the wrong defendant, those are ultimately just sideshows to what is truly the case, which is the language of the Tennessee Constitution is clear, the statistics and the history are clear, and we think it is clear what the court should rule in this case is that permanent disenfranchisement without conviction by a jury violates the Tennessee Constitution, as well as rulings in our favor on our other claims.
All right, thank
Thank
you.
you.
I do have one question for Ms. Jordan. Hopefully it'll be a short one. Ms. Jordan, could you address, please, I forgot to ask you, and I apologize for that. Could you address the plaintiff's argument that Article 1, Section 5 is a restriction on the state's power as opposed to a waivable interest or right that the plaintiff would have? That distinction?
Yeah, and that one, that came from Gaskin versus Collins? Is that that's where their argument came from? But-
I'm not sure, but that was, yes.
Yes. And as I pointed out, that's not what Gaskin versus Collins held. And I read the part of the case. Let me pull it up again. I've gotten all my stuff in disarray. It'll take me a moment. The court in Gaskin versus Collins was faced with a situation where the defendant was found guilty, or was disenfranchised by operation of a statute that was passed after he was tried. I think it was. Let me see. Okay. Okay, this is what it was. Okay. He was convicted in November 11, 1971 of the felony of manufacturing marijuana. And at that time, it was not an infamous crime. In 1975, he completed his term of incarceration and returned to society. On May 18, 1981, 2 bills became law which had the effect of expanding the definition of infamous crimes to include all felonies and disenfranchising all felons regardless of when they were convicted. And then as a result, he was found to be infamous, and it was held that he could not vote because of the law that happened in 1981 or 1981 that was passed even after he had served all of his crime. He tried to apply to vote, and the court said, nope, sorry, this particular law disfranchises you because you were convicted of that felony. So it's a retroactive disenfranchisement. And that's why the court was talking about in that one paragraph that I read to you about this is what they were faced with, and what they said was the phrase previously ascertained and declared by law modifies the words infamous crimes. It qualifies the words infamous crimes in the sense that it places a time limitation on when an act shall be declared infamous, that is, before conviction of the crime. And it says by a jury, but before the conviction of crime. And two things I would point out here. Going back again to the 1870 Constitution Convention and the loyalty oaths, the people who were denied the right of suffrage had not committed any crime. They were all they were. They was part of the Confederacy. This just seems to happen to. That's okay. So there was no process at all for those people. They were denied the right without any crime being committed at all. And the constitutional delegates just wanted to come up with a solution to prevent the retroactive disenfranchisement. And that's what Gaskin versus Collins was about, was a
Okay.
retroactive disenfranchisement.
Mr. Harbenbrink, was that the case you cited for that proposition?
Yes, Your Honor. There's no question that that case was on that section of Article 1, Section 5,
Right.
about previously ascertained. The reason we're talking about the case is because the way the Tennessee Supreme Court reconciled the 1834 provision and the 1870 provision. The Tennessee Supreme Court said 1870 is a limitation on 1834. So 1834 gives the general power to disenfranchise. 1870 limits that power. The words modify and qualify say, yes, the state can still disenfranchise, but subject to these limits. It was looking at one of them, we're looking at one of the other ones.
Okay. All right, any other questions, judges? No? Okay. All right, well, I believe that concludes, sir?
Just have a procedural question for when
Okay.
Your Honor is ready. So under Rule 52.1, given that this is a non-jury case, I believe the court is obligated to produce findings of fact and conclusions of law. I think our experience has been generally that the parties submit proposed findings of fact and conclusions of law after we receive the transcripts and everybody has all the exhibits. I
Well,
think
let us confer.
Okay.
Sometimes we accept those, sometimes we do our own, so let us confer and determine what we think might be appropriate.
Okay. I think, I don't want to speak for Mr. Hellu or any of the team, I think we would very much like the opportunity to submit proposed. I think the only other flag I wanted to note was I think there's still some outstanding motions. So a couple of, maybe one or two pretrial motions and then the motions to strike that both parties filed. So I think probably those would need to be resolved before we could submit any of our
Okay, well, let's just talk about what's outstanding so that we're all on the same page. So from the plaintiff's perspective, what does the plaintiff contend is still outstanding under advisement?
So there is our motion to strike, the testimony of Beth Henry Robertson about government interest. There is defendant's motion to strike, I think is it all of Dr. Baumgartner's testimony? All of Dr. Baumgartner's testimony. There is a pretrial motion that plaintiffs filed with respect to, oh, help me out here. Not Beto, we have an agreement on that one. That's right. There was a pretrial motion similar to our motion to strike, asking the court to preclude defendants from offering any proof of government interest. Oh, and then there was another pretrial motion, might be moot at this point, I guess not, that we had filed about preventing the defendants from using privilege as both a sword and a shield with respect to evidence of discrimination. And then I think defendants had a motion regarding Dr. Holloway's testimony and Dr. Birch's testimony. Oh, one motion covering both Dr. Birch and Dr. Holloway. That was a pretrial motion as well.
Okay. And those were motions to exclude? Dr. Holloway, and who was the other person? Dr. Birch, okay.
And then you have your motion for directed verdict. I'm sorry, involuntary dismissal,
Yeah, Rule 41 motion, that's right.
4102.
Summary
And then you
judgment motions,
Then you
were-
renewed it at the close of proof, okay?
summary judgment motions were ruled on,
We
correct?
have, I think the panel partially ruled, partially didn't, so it's, we have defendants had an initial motion for summary judgment filed on June 27th. Ms. Moses had a motion for summary judgment also filed on June 27th. And then there were December 12th motions for summary judgment by both parties that were granted in part, denied in part. And so they're actually withheld ruling in part, granted.
That's right.
And so there's withheld rulings in the December motion for judgment.
Okay,
And I think the court did dispose, no, the court didn't dispose of defendant's motion to dismiss on standing. It overlapped with the summary judgment standing arguments, but it was a separate motion. And we only say all this because I just haven't felt the court smack me for having a lot of motions.
Yeah.
So,
well, yes.
I think Judge Clement even said a one-line denial would have been enough. So we're just trying to.
Right. So the December 12th motion, did that include the motion to dismiss, or was that a separate motion?
No, the December 12th motion was focused on the Article 1, Section 5 claim that came in after the motion to amend.
Okay,
I think we both filed dispositive motions on it. And if I'm being quite honest, Your Honor, I think our initial June summary judgment motion addressed it to some extent.
Yeah.
The court just allowed us to rebrief.
okay.
in my-
All right, wonderful. Well, what I'm going to ask is that you all confer and send us a letter or an email, just agreeing on what's under advisement, so that we can make sure that we dispose of everything.
Absolutely,
Okay.
Your Honor. Happy to do it.
Okay.
Last bit of business is, this is Exhibit
71?
70.
70,
70.
yes. Okay, so I have the exhibits here. And, sir, you have the originals? You have the originals marked? Okay, can you put those in order for me? They should start with number 70.
So this should be 70.
Yes. We can, yes. Absolutely. Okay,
We were trying to work together. We did-
okay,
It just occurred to me that you might sit my designations.
okay. All right, so here are the exhibits. Who's going to keep those? There should be 70. Were there any exhibits that needed to be marked late? No?
I think that was
I don't
it.
know the 400 pages.
No. Okay, so let me just make sure we have
Is that the 400 pages that we started the morning with?
70, 71.
I do not want the 400
2.
pages to take home with me. I have a full set of everything else.
The plaintiff is happy to take custody of the exhibits if
All right,
that's helpful.
so I'm tendering 76 exhibits to Mr. Wilson, Mr. Helo. Do you have any opposition to plaintiff's counsel holding those exhibits? No? Okay.
Thank you, Your Honor.
Okay, all right.
I'll make
so
Mr. Peterson fly home with
Let's put it on the
them.
record.
Like somebody gets to take them through the airports. Lucky you.
Okay. Well, we can have Mr. Wilson's office hold them if it's more convenient.
I think we're happy to take them.
Okay.
They have the box, Your Honor.
Okay. And they have more lawyers too, so, okay. All right, well, we want to just close out by saying that it's been a very interesting trial. We think the lawyers have done an outstanding job representing your clients. It's been very interesting, and of course, there are some difficult issues that we will resolve, but I hope that you all go home tonight and pat yourselves on the back, because, you know, it's been a long case, and you've both done an excellent job, both sides. So we're looking forward to deliberating and reviewing the case, and we will let you know if we need findings of facts and conclusions of law, okay? All right, very good. So if there's not anything else, we are going to adjourn for the evening. We hope everyone gets home safely, and if there's anything that we need, if anything that you lawyers think of, just email Ms. Kelly, and we will take it up, okay? I want to thank Jordan. Jordan is our fellow, so Jordan's done an outstanding job helping us get to this point. So I know that you all appreciate all the hard work that he's done. And we have our camera team in the back. They've been, yes,
Are y'all gonna break down tonight or in the morning? In the morning?
in the morning?
I
Okay,
guess they gonna call me in the morning?
okay.
Yeah.
Well, we've had a lot of support with this case. Ms. Kelly, she's been on it for over a year, and she's just done an extraordinary job getting this courtroom ready and making sure that all the logistics are in place. So thank you, Ms. Kelly. And then Officer Leak, very seasoned. He's helped us move through this trial. I remember we had one sheriff, and you guys may remember, but someone handed him an exhibit, and he was getting ready to head out the door with it. Do y'all remember that?